Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican boys, verbal flooding.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for Trump's sake.
Welcome to the Court of Public Opinion. I am the Recovery Addict. Good morning to you. Happy Tuesday to you. It is a Tuesday all day today. Can you believe yesterday was Monday? It seems like we've been here longer this week. I don't know. Maybe that's just me. How's everybody doing this morning? Good morning. Welcome. Good to have you here. Especially a big warm welcome to Fran Fitzgerald, who was first in chat. Fran, congratulations. Your promptness and punctuality has earned you the punishment of internet ownership. Everything IP related worldwide is your responsibility throughout the remainder of the day here today. And what a day it is. We are on tap to get closing arguments in the Tracey Grist Trial. Yes, both the state and the defense have rested. We are ready for closings. It should start fairly soon this morning. Maybe some instruction first for the jury. But it's going to be great. So we'll be here for that. And other stuff. We might get into some documents. Read some documents from the Maya trial. Yes, the Maya trial. It's back and it's spicy and it's as interesting as ever. I saw last night there was very appropriate filing yesterday for 420. I think that was related to the Afro Man trial, where I think the state's appealing or something. What a day to choose that. I'm sure he's going to have a song about that. All right, good morning. Can't believe what we watched yesterday. It was nuts. Wait till we see the closings. I want to see how defense wraps this all up and puts a bow on it and explains his behavior. But let's see. What's that? Why is the garbage truck coming on a Tuesday? Our day is on a Wednesday. That's not cool. That's not cool, garbage truck. Skip us because you're a day early. All right, today has been a great day. Hope yours is going as well. You're a little farther ahead of us than the rest of us. So, Sarah, is it Bethage? Gifts a sunshine. She gave us sunshine this morning. Sarah, thank you very much. I appreciate that. I think it's a super sticker. Thank you very much. I appreciate that. Good morning.
Hello.
Good morning. Let's see. We have a couple things. I think we have birthdays this morning. Once we have birthdays, there it is right there. There's our birthday sound. I was delayed, but I found it. Greeners, thank you for your help here. Greeners, good to have you back. And one more time, Greeners comes in with more birthdays. Let's see. Poor Tammy has to make her own pancakes, but they're yummy. Oh, yes. She is making her own pancakes today. We'll sing about that. All right, let's sing to the birthday people, and then we can get this morning started. We're still waiting for a live feed from court. Not here yet, so we'll just get this underway, and any minute now, that'll come in. So wherever you are, if you're able, and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Sing happy birthday to these wonderful people. Thank you, Regina Adams, for the birthday party whistle horn things like this. Happy birthday to you. Happy birthday to you. Happy birthday, dear Georgina, Laura, Little Wild Bit, Ross, Sarah Kay, and Tammy Dunlap. Happy birthday to you. I slowed down too much. Georgina, Laura, Little Wild Bit, Ross, Sarah Kay, and Tammy Dunlap, happy birthday. There are many wonderful days, but today is your special day. And I realize there are a million places you could be at, a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you and make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, who was making birthday pancakes, Andy's Grill, Bob Evans, and Cracker Barrel. I missed one. Begin by helping yourself to pancakes at Denny's, IHOP, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, Cracker Barrel. There's something else in there. There's something else. But Tammy Dunlap's is the only place you need to go. It's her birthday. She's making pancakes. It's in Germany. I probably should have said that first. Germany is probably more of the factor about where you're going to get your pancakes. But Tammy makes the best pancakes for sure. Whew. Sitting down till the room stops spinning. Where does Tammy get her birthday waffles from? She makes her own. They're good. Colleen, Itchy Wither, Horse Rescue. French toast, as always, available for you. And you can watch the horses. Waffle House. Waffle House might be in there. Did I miss that one? Waffle House and sushi. Those two don't go together. Kittybug, thanks for the sparkles. Happy birthday to all. Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, Cracker Barrel. That's it. I think we got them all, Greeners. Thank you very much for the confirmation there. All right. Kittybug sends a floating heart as well for all the birthday people. Laughing Disco Ball. Laughing Disco Ball. I don't even know how to... There it is. Thank you. Thank you very much, Anna's YouTube account for the Laughing Disco Ball. Also, a big thank you to Susan CR. Gifted 5 memberships this morning. You guys are amazing. Absolutely amazing. As we wait for court to start, Shelley Small says, is there a time limit on the closing arguments? Not that we know of, but a lot of the decisions like this have been made in chambers, and the judge just doesn't bother telling us. Not a fan of the judge for this reason. I think we should probably be let in on the secret, but so far, unless he tells us again this morning or explains it to court, we'll just go with the fact that we don't know. Thank you all for the gifting the jewels. That is awesome. I appreciate YouTube making that available, and appreciate you making use of it here. Many places you could do that. Thank you. I missed the drums. I was dancing so hard. P. Lola's mom sent a sundae. Thank you very much. That one looks delicious. Heart-flavored. No, not heart-flavored. That would be disgusting. Heart-shaped ice cream. It's probably better than heart-flavored any day. But yum. Like me a fresh heart ice cream. All right. Not a fan of this judge. Tammy Dunlap, happy birthday. Says, come on down. Still don't know how I can give gift jewels. It's down on the bottom. It's where the rest of the gifting options are, but it's sort of rolling out slowly to people. Not everyone has the capability yet. So, Heather from Texas, thank you for the super sticker with the sunshine. Mine tastes like spleen. That's funny. Full of iron. Heart tastes like chicken. Oh yeah. Did they do closings yet? No, they did not tow. And I can just say tow. I can't say your full name. But let's see, I caught myself there. But we expect them today. That's all we expect today. Both sides have rested. So we have jury instructions and closings and jury deliberation. And then, from there, who knows what happens. Verdict watch. Sandra gives us a 6-7. Oops, I just broke everything. Yeah, let's fix that. For some reason, I can't just change it back. This is Aaron PK's chat overlay. I didn't know that. Hang on. I have to completely close out chat and reopen it to make this work. Pretty sure this is an add-on, like a Chrome add-on that I use. Kim R. gifted the sunshine as well. There it is. Show it. It has to happen. Any guesses how long the jury will deliberate? Probably. Can I be right this time and say not too long? Can I please just be right instead of having like another 9-hour deliberation? It's only been a 6-day case, right? How long do you think jury deliberations will take today? I'm going to say 3 hours. 3 hours. Highlighted chat to visibility has been toggled. Thank you. Flipping a switch. I'm never right with the deliberation. I'm always wrong. Always wrong. We've got this new word that everyone is using. They're all liars. Who do you trust? That's part of the problem. Do you trust the liars or the liars on one side or the liar on the other? And it's a bit of a question. I did tell you I was going to do a little show and tell today, and I forgot. So let me hurry and do that really quickly. Package did arrive today with Apple AirTags. That's what these are, Apple AirTags. These are like actual size, I think. These are very useful for tracking equipment like ours. If I say ours, they have the special tag I have to tear off, which doesn't want to come off. Okay. It's open. There we go. AirTags. Okay. Open it. It's quite an experience opening these up, but turn on Bluetooth, then pull tab. There's a little tab. Hold near device and follow screen instructions. So I have 4 AirTags. They look like these. It's just a little tiny, like a button, a white button, plastic on one side and a little metal on the other. There is a tab in here that's keeping the battery contact from touching, so it's not turned on yet. And it's they taste like lithium. Yes, don't put them in your mouth. They're not designed to be eaten. As a matter of fact, that can probably cause major health concerns if you do. But these are going in all of our equipment cases because they're worth a small fortune, and so we want to be able to find them in case somebody borrows them without our permission. So there'll be hidden transmitters in there. Let's see. I think Bluetooth's on, right? Bluetooth is on. We'll turn on the first one. You have to sort of unwrap it. And now it makes this made a little sound. AirTag Connect. We're going to call this one custom name. This one's our audio box. Select an emoji. To be a speaker. Oh, let's do mics. Here we go. AirTag is linked. It's intended to solely track items that belong to you. Using AirTag to track people without their consent is a crime and may constitute a crime in many regions around the world. AirTag is designed to be detected by victims and enable law enforcement to request identifying information about the owner. Okay, so we're done. One down. Oh, it's beeped. I have precision finding. So there's an arrow on my phone that will point me right to it. I can ping it from my Apple Watch, and I can share my AirTag with other people so they can find it as well. So one down, 3 more to go. I think I'll give one to my son. He loses his wallet almost every day. All right, now we're just waiting for court to come live. We are about 15 minutes from when the jury's supposed to be here, so any second now we'll get a live stream. Will they beep on an airplane if I'm also on the same plane? As long as I am near them, they won't beep by themselves. But if I leave them alone by themselves, they will beep to alert people to the fact that there is, in fact, an AirTag. There we go. We're bringing a feed in. We got it. It's in. Thank you once again to Law and Crime, the pool feed operator for this case. Diane had it figured out on day 2. She did. And by day 2, it wasn't day 2 of trial, day 2 after the murder. Thought about getting that for my luggage. They're great. There are a million different ways you can hold them as well, like little cases. I showed you mine, right? The one I'm using is a little, here's the AirTag, and this goes inside. So just pop it open. Top screws off. AirTag drops in. And the top screws back on. And just like that, it's waterproof and everything. What time are we starting? We're starting officially with the jury in about 12 minutes, possibly sooner. We're hearing sound. Might just be a sound check. Can I boost my audio some? Test 1 2. Test 1 2. How much would you like it boosted? I can boost my audio a lot. What's the general feeling? Guilty or not guilty? We ran a poll yesterday. I think we were in the 82% guilty on this one. 18% not guilty. So this one's going to go in the audio box. We're ready. I already have AirTags for my e-bike, which I don't want anyone to borrow without my permission. My Live View, which I send around to the country sometimes. And let's see. Send you a link in chat for your son's wallet tracking. Looks pretty cool. And it's cheaper than an Apple AirTag. It's pretty nice. I'll send it to him. Thank you. Katie Bug, thanks for the super chat. Appreciate it. Greeners is tracking little Ari wallet. That's what I heard. Do you think that lady yesterday was what sunk her? Barbara, you talking about the defendant getting up and testifying? I don't think it was very good for her. Didn't go well. Better put one on Mrs. Ari's good mixing bowl next Halloween. That's a great idea. Put some in the candy bowl. Can we get the wallet tracking link? Do you want the link that? Let me give you the one that Greeners sent me. Hang on, just 1 second. I'll get you an affiliate link for it. Thanks, Greeners. There's a link. Give me a second. There we go. In chat, it's the affiliate link for the wallet tracker. I think they're about $17
Remember
each.
in the beginning when we started 110 years ago?
Usually we get some jury instructions before closing arguments. Let's see. Did y'all see Kathy, Gossip Premier Innuendo? She said that one of the sisters was in the chats yesterday. Yes, in Take It to Trial or something's channel. If I remember, that's it. Kathy was saying that that Tara Lynn popped in chat and was saying some things about Mom and how she didn't tell the truth or something. Saw that on Kathy's video this morning. Which, if we had a sound effect for Kathy, it would be say more. Say more. That's her sound effect.
If you could just use your words.
There are other trackers that work with Android if you want. Did get some shout outs from Kathy. Thank you. And if you come over from Kathy's channel, we appreciate it. Thanks for the follow and the subscribe. Kathy has some great words she uses. All right. We got some 12 pack of batteries, so this is basically 4 years supply battery pack for these. I'll probably never remember where they are.
I saw a chicken fight.
When I saw Judge Middleton's new courtroom, I thought I was inside some sort of psychedelic yurt. What a background! What a layout! That's a trippy place. I'm not sure if he likes it. I didn't get to hear if he liked it or not. I'm sure GRI would send you the clip. I could steal one from her. I think she wouldn't mind. Kathy, if you're watching, love your videos. Says little Miss Princess Me. Kathleen, hear from Kathy. Thank you. Appreciate it. Does it give a warning when it has a low battery? Yes, it does. Has Diane been able to stay in the courtroom? I don't think she wanted to, but I think she was released, so she would be able to if she chose to. I think if we did a sound effect, Kathy said you're scared to accept her invite. If we did a sound effect, it would be Kathy just saying "say more." It wouldn't be like anything more than that. So, can we give Kathy a command, please? She's how I found you guys. Let me see if I can find a good version that I like of her saying "say more." Kelly Jordan, no buffering on my end. I'm pushing 7 megabits per second. Looking good. Cache is clear. Oh, town bicycle. Oh no, that has other connotations. As you said that, you buffered. Tell me everything. No, we don't know about the time limit. We don't know. We'll have to wait for the judge to tell us, and he hasn't been very good at giving us all the scoop on the download of what they decide in chambers. So we might just have to time them or see if they start a timer when they start talking. So, all right. Boom, boom, boom. They're useful for tracking trucks of unsuspecting husbands coming to pick up their wives from another state, or so has been explained to us. They do work for that, although it may be a crime. Please consult your local lawyer before endeavoring to do that. Kathy is Gossip, Rumor, and Innuendo here on YouTube, a fellow content creator who does an early morning video updating us on the world of true crime in a hilarious way. Just noticed I'm missing one of my feeds. Hang on. When I turn the volume up, you get to hear my fan. I'll turn that one down a little bit. Leave the other one up. That should work. All right. Hubby is building my chicken coop today. Regina, that's awesome. Congratulations. Chickens sound really cool, in theory. I've never, well, as a child we owned a bunch of them, but on my own as an adult, since I got married, no. I need an AirTag on my whole life. I lose everything all the time. Maybe, Legally Blonde, maybe the AirTag should just be something you carry with you, so you know where you are, and then you can you can find everything else. Selena K, still in Hawaii, rubbing in and saying, going surfing again this morning, then on to the airport. Selena, we're jealous. See, your profile picture has you out on a board in the ocean. Yes, we have not had that come in this trial, Tara Allen. That Rachel testified that Tracey's business, let's say massage therapy business, collected premiums, allegedly, for additional services, which could account for why, you know, you can afford Disneyland for 18 people and everything else. I guess they say it's the happiest place on earth, so it seems fitting. But yeah. All right. Let's see. Broken Bakers, thanks for the raid. Welcome. Kitten, that's what the insinuation was. Still waiting for court to start. We had a late start yesterday, and we knew that the lawyers were going to be coming in a little bit early this morning to discuss some issues with the judge. And Baker told us to behave. Thank you. I appreciate that. We all appreciate that here. We're a little bit of a tamer environment, but you're all welcome. Thank you. Big shout out to Broken Baker. As a massage therapist, that makes my blood boil. That's why we have to be so careful when vetting our clients. Jody, you guys heard my experience with massage therapy most recently here the last month or so. That was interesting. I just didn't know what was expected. How do you find Kathy? You search gossip, rumor, innuendo on YouTube, and you'll see a thumbnail that says gossip, rumor, innuendo on it, and you just click on that. All right. How do I find Kevin's trial? Bird Girl, Kevin's trial is on the YouTubes. I believe both Law and Crime and Court TV have the full rendition of that trial, and it has some spicy bits in it, especially if you get into the victim impact sentencing, victim impact statements during sentencing. We'll see what happens there as well. There's a link. Thank you very much, Red Pen, for the link to Kathy's channel. GRI referred me. Thank you very much. That's suspicious. Welcome. Yes, now they're one and the same. At the time, they were different. They're now under one ownership. It is all Law and Crime. Court TV has sort of been enveloped into the fold. And although they still run both channels. What's Kevin's last name? Ellis. Ellis. Kevin Ellis. All right. We are now a minute late for court, which means that the lawyers are probably still trying to sort things out. This could be something as tame as jury instructions, fighting over the wording for what the judge is going to tell the jury about the rules and how they need to deliberate. Or it could be something a little spicier. But without the judge telling us once they come out, we may never know. Innuendo is such a good word. It is. It has like half vowels. It's pretty nice. And 3 N's. How many other words do you know that have 3 N's other than like banana? B-A-N-A-N. No, that's just one. That's just 2. I'm sorry. connotation, says Greeners. Also a good word, though. Innuendo sounds just like it means to. Red, you get a timeout. All right. That's funny. Thank you for the laughing disco, Linda. Appreciate that. You guys are very generous. So, do the jury know that Kevin and Kate are in jail? Yes. I believe they heard specifically that Kevin was incarcerated, was convicted. I think defense told them that Kevin was incarcerated and convicted for the murder, for the shooting. They know that Kate is in jail. She's been in jail clothes, testifying in court. So they know both. Non-negotiable. That's the word you want to use in all your Facebook Marketplace ads. Non-negotiable. And boy, do I have stories about that. We're trying to sell the car we bought when we moved to North Carolina 7 years ago. And as you can imagine, it was well used when we bought it, and it's even more well used now. And it has more features than it ever had, like special noises it makes after you start and drive for a little while. Features about windows that stay down even when you want them up, and all those new features that happen with cars over time. And we listed it for like much cheaper than the average listing for the vehicle that year. Those miles were. No duct tape. No. It's not that bad. And immediately people are like, "I'll give you less for it." It's like, or you could give us what we asked for it because it's a stinking good deal. And we know it's a stinking good deal because we had like 70 people reach out immediately as soon as we listed it, saying, "Hey, can I come test drive it? Can I try it?" And then people that test drive it, they're like, "Oh man, I only brought this much. I didn't bring it." Well, you knew what the price was. Enjoy your 2-hour drive back to wherever you came from. So we're doing the non-negotiable or best offer.
Remember in the beginning when we started 110 years ago?
Innocence is good. Lots of 3-letter N-words. 3 N-letter words. Is that... Man, I have to be careful how I say this because I might get in trouble. But beginning is another one. So those 3 N's. Greeners, that's what we were not getting into. Are you going to follow the Asheville case for Henderson, North Carolina? I was looking at that. That's a fascinating case. It's 6 hours away from me. And it's probably in one of the most expensive areas in the state to stay, as far as it's right over where the hurricane hit and the floods. A beautiful area. We have rented an Airbnb there around Christmas time, and we've stayed over there a little bit. We enjoyed it. It was wonderful. Don't know. I don't know if we're going to get out there to follow the case or not. There is some local interest, so if there's another Pool media outlet that wants to handle it, I would probably stick with them. But it's my backyard. I'm in Asheville. It's a beautiful area. It's actually in Henderson, so it's just like south. I think it's a little southeast of Asheville. Henderson County. Enunciation. Good words. Wasn't even trying for 3 N's, says Debbie. It happened on accident. Kathy, welcome. Did you miss anything? Nothing in court. We're waiting for their first appearances to show up this morning. And we think they're in chambers. Judge's chambers has been hopping in this trial. Unfortunately, the secrets, what happens in judge's chambers stays in judge's chambers. We haven't heard jack squat after they come out. So must be good, whatever it is. Yes, we talked about you, Kathy, as well. It was all good. Is Tracey in jail? She is in custody, I believe. You need to listen to Prejudice by Tim Minchin. It's the ultimate play on words song ever. I do like a good play on words. Oh, I've got a gig this Saturday. I almost forgot. Projector screen, wireless mics. I think they have everything else. All right. Once again, this court has been quite prompt with two major exceptions, and this is one of them. So, Kathy, we were talking about making a sound effect in your honor, so that that when people type an exclamation point in one of the commands we have on the channel, it would play a sound effect. And I was thinking that it would be you saying "say more," because I love it when you say that, and the look on your face is funny.
Remember in the beginning when we started 110 years ago?
So it would play like that. That was the 110 command, which was triggered by Wizard of Ezi. I'm not sure if you would object to say more, if you would like a different version. I'll accept input, but remember, I have total veto power on this, as long as you give your go-ahead. We might do that. It has to be sort of, it has to be in line with our channel. So it can't be rude to somebody. But
you are banished from the state of Georgia.
Yeah. We'll see. Let me know what you think, Kathy. Got a shout out from Josh the other day. That's awesome. It's awesome. Josh is wonderful. Love his crew. He got a shout out from the Tyler Richens. Sorry, not Tyler Richens. Tyler Robinson. There we go. I'm mixing the two cases that she was the defense attorney on. Tyler Robinson case. I'm probably not in a good way, but Tyler Reed Richens. There it is. You want girl? That's a good one. Say more is great. I want a sound effect that would, with all our sound effects, we try to make them something that could be applicable or funny to be used in various court settings. So when they're sound effects that are very specific, we tend to not to go that way unless it's, really funny, like banished from the state of Georgia.
Shame on you, sir.
Can we get this? Red Pen says, can we get this? I want Kathy saying, tell me every single thing. Possibly. All we need is that sound effect with like a little bit of audio on each side with no music or no other sound in the background. And Kathy does a good job that way. It's usually just her audio on our live stream. So we should be able to get that. If somebody can just send me a clip of that. And then I'll, of course, have to get Kathy's permission. I could probably do it without, but I don't want to fight her in court, and she'd probably win. So that's all we need. See, I've got Ian's permission to use this sound effect.
Because we here in Canada hate you. and hope for bad things for you because we hate you.
That's a good one. It would be like that, but for Kathy. All right, here we go. Got some movement. Wait for it. We're hoping the audio sync is just a little.
Judge Roger Griffin presiding.
Thank you. Please be seated. Let's go on the record in the matter of State versus Grist, case number 241101170. Get my computer logged in, counsel, and we'll bring the jury out. Counsel, I put on your tables the jury instructions, the jury verdict form. Have you looked through them briefly?
Yes, Your Honor.
Any concerns?
No, Your Honor.
Mr. Mutabi?
I have not yet, but I believe the other prosecutors have their own.
Okay. All right, then. Anything else the state needs to put on the record?
No, but if we could wait for Mr. Pomeroy, he just wants to get a drink. We'll be right back.
All right. Anything that you wish to put on the record, Mr. Basemar?
Let's take a 5-minute break.
All right, thank you.
I think it takes more than that to be an appellate issue. That was not ineffective assistance of counsel. It might be reason to get a new lawyer, breakdown of the relationship between the attorney-client privilege. I don't know, but it's a little late to do that halfway through trial. How many breaks are we going to have today? No, Kathy and I would never sue each other. I would never. I have too much respect for other creators to use that without their permission. Right, Kathy? You'd never sue me, right? I was right now years old when I learned to say that I say more.
You ready for me to bring the jury in, Mr. Pomeroy?
That's fine, Judge. Thank you.
All right, let's bring in the jury, please, Ray.
I've been trying not to say it, but look at this. The judge's table is leaning. He's like sliding off to the side of the screen. He's like going to roll down towards where his name tag is. And it's getting worse. It used to be like 1 degree. I think we're a full 2 degrees slant now. Sorry if I ruined that for anybody.
I realized I didn't put in the jury numbers yet, and that's kind of...
All rise for the jury.
It's a great point, Dr. Patrice Berry.
Thank you. Good morning. Please be seated. Ladies and gentlemen, the jury, on your chairs are the jury instructions for the closing instructions for the trial. There also is the jury verdict form for the various charges. You're free to read along with me or to just listen while I go through the instructions. You, of course, will be able to take these back to you into the jury room for your deliberations. The rules do require me to read these into the record. It takes a little bit of time to do so. I will do my best not to read too fast or too slow. After I've completed reading to you the closing jury instructions and the jury verdict forms, the state will give their closing argument, and Mr. Facemer, on behalf of the defense, will give his closing argument, and then the plaintiff or the state, because they have the burden of proof, has the option to do a rebuttal closing argument. After the state has completed their rebuttal argument, if they have any, then it'll be time for us to send you back to start your deliberations. We'll give you some last-minute instructions at that point as well. Closing instructions number 1, closing roadmap. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I'll give you additional instructions that you will follow in deciding this case. Second, the lawyers will give you their closing arguments. The prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. Number 2, juror duties. You have 2 main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important. You should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend on what you decide are the true facts of the case. If an instruction applies only to facts or circumstances you find do not exist, you may disregard that instruction. Perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Number 3, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Number 4, legal rulings. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. Number 5, judicial neutrality. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Do not interpret anything I've done as indicating that I have any particular view of the evidence or the decision you should reach. Number 6, evidence closing. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they are testifying under oath and any exhibits submitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments, if any, are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Number 7, items not admitted into evidence. Transcripts, police reports, or other written audio or visual materials may have been referenced during the trial, but not admitted as exhibits. It is common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Number 8, witness credibility. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connections to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of your experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, If you are convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one or one witness against many. In deciding whether a witness testified truthfully, remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Number 9, presumption of innocence, closing. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crimes charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Number 10, reasonable doubt, closing. As I instructed you before, proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. Number 11, direct and circumstantial evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified he looked outside and saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. Number 12, defendant testifying. The defendant testified at trial. Another instruction mentions some things for you to think about in weighing testimony. Consider those same things in weighing the defendant's testimony. Don't reject the defendant's testimony merely because she is accused of a crime. Number 13, offense requires conduct and mental state. A person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act, and the law requires a person to act. As to the mental state requirement, the prosecution must prove that at the time the defendant acted or failed to act, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it is enough that the defendant acted recklessly with criminal negligence or as some other specified mental state. Later, I will instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged. Number 14, inferring the required mental state. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly, because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. 15. Motive. The defendant's mental state is not the same as motive. Motive is why a person does something. Motive is not an element of the crimes charged in this case. As a result, the prosecutor does not have to prove why the defendant acted or failed to act. However, a motive or lack of motive may help you determine if the defendant did what she is charged with doing. It may also help you determine what her mental state was at the time. 16. Do not consider punishment. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Number 17, jury unanimity and deliberations. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. If there is a difference of opinion about what the evidence there's a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. Number 18, four-person selection and duties. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all the members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict forms on behalf of the entire jury. For each offense, the verdict form will have two blanks, one for guilty and the other for not guilty. The foreperson will fill in the appropriate blank to reflect the jury's unanimous decision. In filling out the form, the foreperson needs to make sure that only one blank is marked for each charge. Number 19, jury questions during deliberations. These instructions should contain all the information you need to decide this case based upon the evidence. However, if you have a question or need clarification during deliberations, write a note and give it to the bailiff. I will review it with the lawyers. We will answer your question as appropriate. 20, deadlocked juries. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. It is your duty to consult with one another and to deliberate. Your goal should be to reach an agreement, if you can do so, without surrendering your individual judgment. Each of you must decide the case for yourself, but do so only after impartially considering the evidence with your fellow jurors. Do not hesitate to re-examine your own views and change your position if you are convinced it is mistaken. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or just to return a verdict. You are judges of the facts. Your sole interest is to determine the truth from the evidence in the case. Number 21, fact versus expert witnesses. There are two types of witnesses, fact witnesses and expert witnesses. Usually a fact witness can testify only about facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can gain their opinions in their areas of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of experts, you may look at their qualifications, the reasoning process the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. Give it whatever weight you think it deserves. Number 22, law enforcement officer's testimony. You've heard the testimony of a law enforcement officer. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give the witness's testimony whatever weight you think it deserves. Number 23, stipulation of fact. When lawyers agree that certain facts are true, it is called a stipulation of fact. You must accept any stipulated facts as having been proven. However, the significance of these facts, as with all other facts, is for you to decide. Number 24, multiple defendants or missing defendants. There has been evidence suggesting that persons other than the defendant may have been involved in the crime for which the defendant is on trial. Your duty in this case is to decide only whether the prosecutor has proven beyond a reasonable doubt the guilt of the defendant who is on trial. Number 25, separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Number 26, date or time of offense is not an element. The state has alleged that the defendant committed the charged offense on or about certain dates. The exact date is not an element of the offense which the state must prove beyond a reasonable doubt. 27. Usual and ordinary meanings instruction. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Instruction 28. Mental states defined intentionally. A person acts intentionally or with intent when her conscious objective is to 1. Engage in certain conduct, or 2. Cause a certain result.
Got some signal dropouts there.
A person acts knowingly or with knowledge when the person 1. Is aware of the nature of her conduct, or 2. Is aware of the particular circumstances surrounding her conduct, or 3. Is aware that her conduct is reasonably certain to cause a particular result. Recklessly. A person acts recklessly when she is aware of a substantial and unjustifiable risk that 1. Certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway, or 2. Her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an admission. Number 29, inferring intent. The intent with which an act is done denotes a state of mind and connotates a purpose in so acting. Intent being a state of mind is seldom susceptible of proof by and positive evidence. It must ordinarily be inferred from acts, conduct, statements, and circumstances. Thus, you would be justified in inferring that a person must have intended the natural and probable consequences of any act purposely done by her. 30. Party liability, definition of party to the offense. A person can commit a crime as a party to the offense. In other words, a person can commit a criminal offense even though she did not personally do all the acts that make up the offense. Here, Tracey Marie Grist is charged in count 1, 3, 4, and 5 as a party to the offense. Before a person can be found guilty as a party to the offense, you must find beyond a reasonable doubt that 1. Tracey Marie Grist had the mental state required to commit the charged offense, and 2. Tracey Marie Grist, A, directly committed the charged offense, or B, intentionally, knowingly, or recklessly solicited, requested, commanded, or encouraged another person to commit the charged offense, or C, intentionally aided another person to commit the charged offense, and 3. The charged offense was committed either by Tracey Marie Grist or Kevin Stanley Ellis or another person. 31. Elements of the charged crime, count 1, murder. The defendant, Tracey Marie Grist, is charged in count 1 with committing murder. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1. Tracey Marie Grist is a party to the offense. 2. A. Intentionally or knowingly caused the death of Matthew Rastelli, or B. Intending to cause serious bodily injury to another, Tracey Marie Grist committed an act clearly dangerous to human life that caused the death of Matthew Rastelli, or C. Acting under circumstances evidencing a depraved indifference to human life, Tracey Marie Grist engaged in conduct which created a grave risk of death to another and thereby caused the death of Matthew Rastelli. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Number 32, definitions applicable to count 1, murder. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates or causes serious permanent disfigurement, protracted loss or impairment of the function of any bodily member or organ, or creates a substantial risk of death. Number 33, definition/explanation of depraved indifference. A person is guilty of murder if, acting under circumstances that demonstrate a depraved indifference to human life, she knowingly engages in conduct that creates a grave risk of death and in fact causes the death of another. Depraved indifference to human life means an utter callousness towards the value of human life and a complete indifference as to whether the actor's conduct will create a grave risk of death to another. To act with depraved indifference, the actor must do more than act recklessly. However, she does not have to have a conscious desire to cause death, nor does she need to be aware that the conduct is reasonably certain to cause death. In the context of depraved indifference, murder knowingly means that the person knew the nature of her conduct, that the conduct created a risk of death, and that the risk of death was grave. A grave risk of death means more than a substantial and unjustifiable risk. There must be a high likelihood that death will result. In order to find depraved indifference, you must evaluate all the circumstances surrounding the death from the standpoint of a reasonable person in the actor's position. In evaluating the evidence, you should consider the following factors. 1, the social value of the defendant's conduct. 2, the magnitude of the risk. 3, the defendant's knowledge of the risk. And 4, any precautions taken by the defendant to minimize the risk. Number 34, elements of the charged crime count 2, conspiracy to commit murder. The defendant, Tracey Marie Grist, is charged in count 2 of committing conspiracy to commit murder. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1, Tracey Marie Grist. 2, intended that conduct constituting the crime of murder be performed. And 3, agreed with one or more persons to engage in or cause the performance of the conduct. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Number 35, elements of the charged crime count 3, obstruction of justice. The defendant, Tracey Marie Grist, is charged in count 3 of committing obstruction of justice. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1, Tracey Marie Grist is a party to the offense. 2, intended to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constituted a criminal offense, and A, altered, destroyed, concealed, or removed any item or other thing, or B, made, presented, or used any item or thing known by the actor to be false, or C, provided false information regarding a suspect, a witness, the conduct constituting an offense, or any other material aspect of the investigation. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Number 36, jury unanimity for obstruction of justice and the verdict form for count 3. Count 3 charges Tracey Marie Grist with obstruction of justice. The prosecution argues that the defendant may have committed the offense by 1, being a party to planting the knife in Matthew Rastelli's hand, and or 2, making an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli. You may not find Tracey Marie Grist guilty on this account unless you unanimously agree that the prosecution has proven that Tracey Marie Grist committed obstruction of justice in at least one of these specific ways, and you unanimously agree on the specific way in which the defendant committed the offense. If you find Tracey Marie Grist guilty of obstruction of justice, you must record on the verdict form which way or ways you unanimously agree she committed the offense. 37. Elements of the crime charged: count 4, commission of domestic violence in the presence of a child. The defendant, Tracey Marie Grist, is charged in count 4 with committing to commission of domestic violence in the presence of a child. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1. Tracey Marie Grist as a party to the offense. 2. Intentionally or knowingly committed murder. 3. In the presence of a child. And 4. Tracey Marie Grist and Matthew Rastelli were cohabitants at the time of the offense. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Number 38, element of the crimes charged, count 5, commission of domestic violence in the presence of a child. The defendant, Tracey Marie Grist, is charged in count 5 with committing commission of domestic violence in the presence of a child. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1. Tracey Marie Grist as a party to the offense. 2. Intentionally or knowingly committed murder. 3. In the presence of a child. And 4. Tracey Marie Grist and Matthew Rastelli were cohabitants at the time of the offense. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Number 39, stipulation of fact regarding cohabitation. When lawyers agree that certain facts are true, it is called a stipulation of fact. You must accept any stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. The parties have stipulated that Tracey Marie Grist and Matthew Rastelli were cohabitants at the time of the offense. Number 40, definitions applicable to counts 4 and 5, commission of domestic violence in the presence of a child. Child means an individual younger than 18 years old. In the presence of a child. In the presence of a child means A, in the physical presence of a child, or B, having knowledge that the child is present and may see or hear an act of domestic violence. Cohabitant.
The here part.
Cohabitant, as used in this case, means an individual who is 16 years or older who, 1, is related by blood or marriage to the other party as the individual's parent, grandparent, sibling, or any other individual related to the individual by consanguinity or affinity to the second degree. As Instruction 39 provides, the parties have stipulated that Tracey Marie Grist and Matthew Rastelli were cohabitants at the time of the offense. Instruction number 41, special verdict form for cohabitation. If you determine beyond a reasonable doubt that Tracey Marie Grist committed either murder count 1, conspiracy to commit murder count 2, domestic violence in the presence of a child count 4, or domestic violence in the presence of a child count 5, you must complete the special verdict form titled Special Verdict Form for Cohabitant. Number 42, jury unanimity, multiple offenses with identical elements. The prosecution is charged in count 4 and count 5 that Tracey Marie Grist committed commission of domestic violence in the presence of a child multiple times. Although each of these counts has similar or identical elements, you must consider each count separately and render unanimous agreement on whether Tracey Marie Grist is guilty or not guilty of each individual count. You may not find the defendant guilty of any count unless you unanimously agree the prosecution has proven the specific act and the elements of the offense for each count, and you unanimously agree the prosecution has proven all other elements of the count. You may find the defendant guilty of all of these counts, none of these counts, or only some of these counts, but for each count your decision must be unanimous. In this case, count 4 is based on the alleged conduct of committing the offense in the presence of SR. Count 5 is based on the alleged conduct of committing the offense in the presence of CR. I'll now read to you the various verdict forms. In the 4th District Court, Provo, Utah County, State of Utah plaintiff versus Tracey Marie Grist, defendant. Verdict form for count 1, case number 2411-01170, Judge Roger W. Griffin. As to count 1, we, the jury, impaneled in the above entitled cause, find the defendant as to count 1, murder is charged in the information, blank guilty or blank not guilty. And then below that is a line with the jury foreperson. The jury foreperson will select the correct answer and then sign their name and put their juror number by their name. The next jury verdict form. In the 4th District Court, Provo, Utah County, Utah, State of Utah versus Tracey Marie Grist. Verdict form for count 2, case 2411-01170, Judge Roger W. Griffin. As to count 2, we, the jury, impaneled in the above entitled cause, find the defendant as to count 2, conspiracy to commit murder as charged in the information, blank guilty or blank not guilty, then a signature line for the jury foreperson. Similarly, you should check the right box for the jury's decision, sign, and put your jury number next to your signature. The next verdict form. In the 4th District Court, Provo, Utah County, Utah, State of Utah versus Tracey Marie Grist, defendant. Verdict form for count 3, case number 2411-01170, Judge Roger W. Griffin. As to count 3, we, the jury, impaneled in the above entitled cause, find the defendant as to count 3, obstruction of justice, as charged in the information, blank guilty or blank not guilty. Further, having found the defendant guilty, we unanimously find, and you mark all that apply and leave blank if the defendant is found not guilty. Blank, Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand. Tracey Marie Grist made an untruthful statement to 9/11 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli, blank foreperson. Similarly, we'll check the right box, guilty or not guilty, and then after making that decision, you'll move down following the instructions and check a box as applicable or a line for the next section, and then sign and put your juror number. The next verdict form is for counts 4 and 5. In the 4th District Court, Provo, Utah County, State of Utah, plaintiff versus Tracey Marie Grist, defendant. Case number 2411-01170, Judge Roger Griffin. As to count 4, we, the jury, impaneled in the above entitled cause, find the defendant as to count 4, commission of domestic violence in the presence of a child as charged in the information, blank guilty or blank not guilty. As to count 5, we, the jury, impaneled in the above entitled cause, find the defendant as to count 5, commission of domestic violence in the presence of a child as charged in the information, blank guilty or blank not guilty, and then the signature line. Once again, the jury foreperson will select the correct answer for each count, then sign and put their juror number next to their signature. Then we have the special verdict form. In the 4th District Court, Provo, Utah County, State of Utah plaintiff versus Tracey Marie Grist, defendant. Special verdict form for cohabitation, case number 2411-01170, Judge Roger W. Griffin. As to count 1, 2, 4, or 5, we, the jury impaneled in the above entitled cause, find at the time of the offenses in count 1, 2, 4, or 5 that Tracey Marie Grist and Matthew Rastelli were blank cohabitants or blank not cohabitants. Following the instructions, select the right answer, then the jury foreperson will sign and put their name and their jury number on that line. That concludes the final jury instructions. Mr. Pomeroy, I believe you have the state's closing.
All right, that was 34 and a half minutes.
It's not already maybe published to the jury.
I'm sorry, what did you say?
Just publishing the presentation to the jury.
Okay, thank you.
And is the audio good, Faye?
Yes.
That's about average time on jury instructions for a case of this size. pulls the mic. Now he's ready. Gets out of the way so he can't hear him. Nice. I think he's wearing a mic. That's better. Yes, he is. Good.
Kevin Ellis pulled the trigger, but Tracey Grist killed Matthew Rastelli. The question isn't whether it was murder. The question is whether Tracey is tied to that murder. Under the law, a person is guilty of a crime if she intentionally helps bring it about. If she solicits it, if she encourages it, if she helps it to happen. She doesn't have to pull the trigger to be a murderer. So again, Kevin shot, but Tracey is a murderer. Fueled by her hate for Matthew, inspired by her interest in true crime, Tracey planned and executed a knockoff of the Donna Adelson conspiracy. After all, as Tracey herself put it, sometimes you have to color outside the lines. Now, in this conspiracy, Kate and her kids were the motive, Kevin was the means, and Tracey was the mastermind, the manipulator. Let's briefly address each of those three. Start with the motive. Kate was unhappy in her marriage. She viewed it as loveless. She had already moved on to other men. She wanted a divorce and custody of her kids. But when she ran away to Utah, a divorce attorney told her it wouldn't be so easy. As she put it in a text to her friend, she felt both hopeless and fucked. Tracey too gained a motive by this turn of events.
What?
Remember what Matt texted her after she convinced Kate to skip town on him? You infected Kate with the need to leave California. I will not forget your involvement in this. Enjoy your short time with them. You will not be welcome in our house again. If you don't text me the address where his children were, I will be calling the sheriff for kidnapping. Tracey not only hated Matt, but feared that if he remained in the picture, she would lose at least some level of access to her daughter and her grandchildren. Everyone understood that this was the final straw. So Tracey did what a lawyer could not. She copied an idea, a way out of the marriage with no California court, no sheriff, no shared custody, and no loose ends. It would kill Matthew. The means. Kevin's role in Tracey's plan was to shoot Matthew. He shot Matthew 7 times. 3 times in the back. Mere seconds after Matthew had come into the home, an expected and invited guest. Kevin and Tracey then waited 8 minutes after the shooting before calling 911. Time sufficient to make sure that Matthew was truly dead. Time to plant the knife. Time to stage the scene. During those 8 minutes, no one tried to give Matthew any life-saving aid. During those 8 minutes, Kevin said to be careful because Matthew might still be moving or kicking. And during those 8 minutes, as I said, the knife was planted. That gun used to kill Matthew, Tracey's. The knife planted in Matthew's hand, Tracey's. The manipulation. Tracey was the mastermind of this murder. She was at the gravitational center of this entire family. She was the one who got each and every family member to carry out their needed part. And certainly some of them did so unwittingly as to what Tracey's ultimate goal was. She was the connection between Kate and Kevin. You heard they didn't really have much of a relationship before Kate fled with the children to Utah. She was literally the voice in Kate's ear, telling Kate what to say when Kate was speaking on the phone to Diane, Matthew's mother. She dictated to Kate what Kate should say or text to Matthew as Kate was luring him to Utah and inside the home. And Tracey was metaphorically the voice on Kate's shoulder as she convinced her that this was the way out. She manipulated Kevin. She preyed on his protective instincts for Kate, but more importantly, his instincts for those 2 children. She pressured him into ambushing, shooting, and killing Matthew. So she manipulated Rachel to get Rory and Jake out of the house so they wouldn't be witnesses. She manipulated Rachel to be the lookout, speed updates as Matt drove to Utah. Remember the messages Rachel sent both Kevin and Tracey just a few minutes before the murder? Orem, find my. She was also the one who had Rachel tell Tim he wouldn't be needed that night. Why not? Because the plan Tim knew about, just to be the peacemaker, to be a presence during a conversation, that had changed. Tim wouldn't be needed to keep the peace because Tracey didn't need him to keep the peace. She didn't want him to keep the peace. She intended for Kevin to shoot Matthew, and the fewer witnesses, the better. And Tracey worked with Tara Lynn to help plant a false story of reconciliation in their text messages, presumably for the police to find. You saw Kate testify. She may have wanted Matthew out of the picture. But we can be real. We can use our common sense. It was obvious that Kate was not capable of planning or carrying out this murdering conspiracy by herself. You heard Kevin's word. Whose idea was this? Tracey's idea. At the beginning of this trial, my colleague asked you to follow the evidence. Not what he said, not what opposing counsel said, not what I say, but what the evidence says. He asked you to consider several questions as you sat throughout this trial. Did Tracey Grist cause the death of Matthew Rosselli? Did Tracey agree with Catherine and or Kevin to kill Matthew? Did Tracey help plant the knife or plant the knife? In a moment, we will review the evidence together to see what answers it gives us to these questions. But first, I want to review just a few of the instructions Judge Griffin just gave you, because the law he gave you will help you determine which narrative is letting the facts speak for themselves, and which narrative is distorting the facts to fit a story that does not reflect the reality of what happened. Jury instruction 10 is the reasonable doubt instruction. I want to call your attention to just a few passages in each of these instructions. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. You just need to be firmly convinced. And if I say anything in this closing argument that makes it seem I'm undercutting that, I'm not. If I say anything, a slip of a tongue that makes it seem like I'm shifting the burden to the defendant, I am not. She has no burden. The state has the burden. But be clear on what the burden is. You only have to be firmly convinced, not a shadow of a doubt or some other standard. What is evidence? Evidence includes what the witnesses said while testifying under oath, and any exhibits submitted into evidence as noted. The lawyer's statements, the arguments, those are not evidence. But this is important. This is what I want to draw your attention to. You may draw all reasonable inferences from that evidence. And there are many reasonable inferences for you to draw in this case. You may ask, is some evidence better than other evidence? Facts may be proved by direct evidence or circumstantial evidence. The law does not treat any one type of evidence better than the other. It's for you to apply your judgment and common sense on how you wish to weigh the evidence. Similarly, how do you decide if a witness is credible? I obviously couldn't put the entire instruction on here, but the key passages. Use your judgment and common sense. You may consider anything that you think is important in weighing the credibility of witnesses. And this is key. You may believe all, part, or none of a witness's testimony. With at least 2 witnesses, there are reasons to believe only parts of what they told you. We'll come back to that. Now, what must be proven? Now, this is just a summary. When we get to it, when you get to the deliberation and later in the argument we discuss it, use the actual instructions. This is just a summary to help us for the moment. I want to call your attention to the 4 different charges. One of them, domestic violence in the presence of a child, there's 2 counts for each of the 2 children. But you'll notice that murder, as a party to the offense, did Tracey Grist cause the death of Matthew? Obstruction, as a party to the offense, did Tracey plant the knife or make an untruthful statement to police or 911? Domestic violence in the presence of a child, as a party to the offense, did Tracey Grist commit the murder in the presence of the children? And then conspiracy is slightly different. Tracey Grist, intending that the crime be performed, agreed with one or more persons to engage or cause the performance. 3 of these charges have that language as a party to the offense. And that's important to look at for a moment. What does that mean? How can you be a party to the offense? If she has the mental state required for the offense, that's something the instruction will tell you a little bit more about in a moment. If she directly commits it, or if she solicits it, or requests it, or commands it, or encourages it, or intentionally aids it, she's just as guilty as the person who actually did it. So if she solicited, requested, commanded, encouraged, or aided Kevin in shooting Matthew, she's guilty of murder. The same for the obstruction, and the same for the domestic violence in the presence of a child. Now, with this law in mind, I want to review the facts together with you. And in these facts, we will see, as surely as the day is long, that Tracey Grist is not just a party to the offense, but the key party to the offenses of murder and obstruction and conspiracy and domestic violence in the presence of a child. Now, we admitted a lot of exhibits in this case, a substantial amount. And this is just the documentary evidence, not to mention the videos, not to mention the audio. I'm going to thank you in advance for your patience as we go through some of that. We don't have time to go through all of that. You can choose in your deliberations to go through all of it. I want to highlight the key points for you. So let's turn to the evidence. We begin with a more in-depth look at the development of the motive and origins of this conspiracy. Now, as you've heard, Matthew and Kate married in 2016, and they lived in California. They certainly had their issues. It was called a toxic relationship during trial. Regardless, by early 2024, that relationship was strained. Kate was unhappy. She viewed it as loveless. She had already had an affair, or as she called it, stepping out on the marriage. And that was a point of conflict between her and Matthew. You saw the evidence. In January 2024, Kate confided to her mother that she wanted out of the marriage. They had been fighting so much. I want out. By May, texts between Kate and Tracey again reflect continued frustration and unhappiness. I hate my life. Hate that I have kids with Matt. This is so bad. I hate him so much. Ultimately, Kate was unhappy enough to separate from Matthew, essentially disappearing without warning on June 20th, 2024. She took their 2 young children to live at her mother's house, Tracey, in American Fork, Utah, driving the rental car that Tracey paid for and arranged for her to have. After Kate came to Utah, she and the Grist family learned that separating from Matthew and getting custody of the children wouldn't be very clear-cut. It would be very difficult. The biggest problem was that California still had legal jurisdiction over the children and the marriage. You heard Kate's recorded conversation with the lawyer that she shared with the family, where she learned the reality of their situation. As Kate summarized to her friend, honestly, I'm fucked. Just dumb California law. I just feel hopeless. So the evidence is clear about the development of Kate's motive. But in the evidence, we can also see the development of Tracey's motive and thoughts in parallel to Kate. In January, when Kate confided to her mother that she wanted out of the marriage that they'd been fighting, how did Tracey respond? She called Matt. She threatened him, even though, as she puts it, she was just watering down her words. And then Kate said, "Don't call him." And she replied that she wouldn't. "I'll just drive 9 hours and strangle him." Fuck him. By May, Kate had again confided.
These F words are a little
that she hates her life. This was May 22nd. And the next day, Tracey searches the web for mountain lion. Searches the web for this. What scent attracts mountain lions to human? Tracey says, this is just a joke. I don't know about you. I've never had Google laugh at one of my searches before. This was for her and her alone. That same day, Tracey flew to California for a short visit to attend her friend Amy's celebration of life. She returned home on May 30th. And then shortly thereafter, she starts days of texts and searches that aren't just coincidence, but rather show what Tracey thinks of Matthew and what's on her mind at this point in time. So on June 4th, around 6:02 p.m., Tracey reaches out to her daughter, Tara Lynn. Can you talk? So mad at Matt. So mad. The next morning, we have this exchange where Kate calls Matt a piece of shit because of that issue with the camper trailer. And Tracey says, he's lying. And then, a little bit later that day, tells Rachel, Matt made it so I want to kill him. When Katie asked about whatever I had said about her being the camper too much, which I never said anything, he straight up lied. I'm gonna kill him. And then by the evening of June 6th, and the next morning, June 7th, she searches more. She searches more about the Donna Adelson murder conspiracy. She searches Katie Magbanwa pictures, Katie Magbanwa, Catherine Magbanwa attorney, Katie Magbanwa's second trial defense charts. You may remember that Katie was the middleman in the Donna Adelson conspiracy to murder her son-in-law. She also searches, how old were Dan Markle's kids when Dan was killed? Dan was Donna's son-in-law, who she murdered through the use of a hitman. Or we could use the defense's statements from opening, where he said, it's just a guy who got murdered by another guy. It was a messy deal. Also a conspiracy. What these texts, internet searches, and verbal conversations show is that Tracey returned again and again over time to her contempt for Matthew and the idea of killing him. Look, we need to be clear about at least one thing here. Offhanded comments and Google searches alone do not prove guilt. Back in January, the murder wasn't in play yet. But when you see the comments continue, when you see the comments followed by research, the research followed by planning, the planning followed by an execution of the plan followed by a cover-up, it tells you what was on her mind and that you know exactly what her intent was. You heard Tracey say it herself. I searched what was on my mind. And Matthew's death was on her mind. Moreover, Tracey's feelings influenced the entire family. Let's take one example. From June 16th. This is where Tara Lynn and Rachel have a conversation. Tara Lynn, referring to her husband, asking Rachel, he wants to know if you shot your .380 yet. Rachel says, no. Unfortunately, kids make it hard to get out and go shooting. Ha ha. We need to coordinate with Mom and take it out before any chance of Matt coming. LOL. There's a phrase called kidding on the square. I don't know if you've heard it before. It's a communication style where it allows someone to convey a sincere opinion under the guise of humor. It can give you plausible deniability. I was just kidding. I was just joking about what I said. But what such joking does, when it's repeated time and time again, is to normalize violence. It desensitized the family to the idea of killing Matt. It dehumanized Matthew, that they routinely joked about killing him. It takes a lot to kill another person. Normalizing, desensitizing, dehumanizing, good first steps to get there. Some of it surely started as a joke. That's gotta be the truth. That common sense tells you that. It turns out to be a lot less funny when a few minutes later someone turns up dead. With this understanding of Tracey's mindset towards Matthew, consider what happened once it was decided that Kate would leave Matthew and come to Utah. So on June 16th, the arrangements were made for Kate to come to Utah. Tracey got her on the credit card, they made the bedroom plan, etc., etc. At nearly exactly the same time, Tracey makes the following search. Utah, shoot, break-in. She said, the autocorrect must have spelt it wrongly. Use your common sense. Autocorrect doesn't fill in misspellings. This was an intentional search by Tracey. And then a few hours later, she searches how to file for a divorce, how to establish Utah residency. On the 20th, Kate then came to Utah. And as a result of her coming to Utah, we have the final text conversations between Matthew and Tracey. The ones where Matt texted Tracey after she helped Kate skip town on him. These statements. The ones where he says that you infected Kate. The one where he says, enjoy your short time with them. The one where he threatens to call the sheriff for kidnapping. And we can see as a result of this exchange exactly how Tracey became concerned about what had happened, about what she had done, about the legal implications of bringing Kate and the children to Utah. For what we will see is not a temporary breather, but a permanent break. Because the next morning, on June 22nd, she makes 16 searches related to child custody, the legal implications, and parental kidnapping. Now, what did Tracey learn from all these web searches? We can infer, remember the instructions, you can make reasonable inferences from the evidence, that she learned exactly what the lawyer told Kate on July 11th. California still had jurisdiction. Jurisdiction for the divorce, jurisdiction for child custody, and there was no way Kate was going to get sole custody of the kids in Utah. And now, at this point, after that, Kate had very real reason to fear losing at least some access to her daughter and her grandchildren. There was the lawyer call on July 11th at 3:29 p.m. Lasted approximately 31 minutes. What did Tracey search at 4:39 p.m.? When was Donna Adelson arrested? So approximately 40 minutes after the lawyer call ended, Tracey is researching how long it took Donna Adelson to be arrested for getting rid of her inconvenient son-in-law by murdering him during a custody dispute. Is it a coincidence? If you still have any lingering doubt that Tracey didn't know exactly what was going on with the lawyer or wasn't controlling absolutely everything and everyone in this family, remember her conversation with Tara Lynn from before the lawyer meeting. Tara, call Kate. Help her with what to say to the lawyer. She's happy about not going back, and she needs to take legal steps now. School starts soonish. July 1st. Does this sound temporary to you? Tracey knows Kate isn't going back, even if she testified otherwise. She directs both Tara and Kate on what to do. And let's be real. Kids don't need to be registered for school in Utah if they're going home to California. What else does Tracey say? The next day, I'll listen to the lawyer call and report. So what do we know? We know in Tracey's own words that she had contempt for Matt, hated Matt, disliked Matt. Use your adjective of choice. We know in her own words that she stewed over his supposed lies. We know in her own words that she repeatedly joked. She discussed killing him, harming him. We know in her own words that she was well acquainted with murder conspiracies. We know in her own words that she was researching about shooting intruders. We know in her own words, after Matthew threatened to call the sheriff over kidnapping, that she was concerned about parental kidnapping and the legal implications. And we know the lawyer told the family that this wasn't a legal battle they were going to win. Was there an initial plan for this family, for Kate, to pursue a divorce? Yes, that was the initial plan. But by this point, by July 11th, the backup plan took priority for Tracey, Kate, and Kevin. A way out. But that way out was to get Matthew out of the picture permanently. I want to remind you of one more thing on this point before we move on. Kate testified that the conspiracy first came together about a week to a week and a half after she got to Utah on the 20th. You should believe Kate to the extent you can corroborate Kate. We can corroborate this point at least. The Tara Kate messages were July 11th, a little bit more than a week and a half. What do we have here? On June 21st, Tracey told Kevin about the sheriff and the kidnapping issue, forwarded the message, and how did Kevin respond? How about no? They're not worried about Kevin. Sorry, they're not worried about Matt. And on the 26th, Kate texts Kevin, what day are you coming back? Wondering for Olaf, nickname for Matt. If I have to rush back, I can make that happen. June 29th, that week to week and a half. What did Tracey tell her sister and her brother? I want him to show up. He still thinks it's only for another week. And of course she wanted him to show up. You can't remove Matt from the equation if he's not there. In the end, whatever the exact moment was that the plan came together, whatever the exact moment the agreement was made, after the afternoon of July 11th, the die were cast. The loose strands of Tracey's ill will towards Matt, the lingering thoughts of harming him, the inspiration from another murder case, were woven together in that final day and a half into a conspiracy that culminated when Kevin shot Matthew. And if you believe at any point in time, whether it was an hour, a day, or a month before the murder, that there was an agreement, that is conspiracy, and Tracey is guilty of the conspiracy and the murder. Now, to be sure, this was a poorly executed conspiracy, with an even worse cover-up, what the defense called the messiest conspiracy. But a messy conspiracy is a conspiracy nonetheless. So now we are going to move to the execution of the conspiracy and its unraveling. The evidence of it, at least in retrospect, can be broken down into 4 phases. And so that's how I'll break it down for you today. They had to lure Matthew to Utah. They had to funnel him or get him inside Tracey's home. They had to ambush him and cover it up. So phase 1, luring Matt to Utah. We've already acknowledged this. For this to work, Matt has to come to Utah. But we also know Matt doesn't want to drive out to Utah. Kate had come to Utah under that guise of the temporary breather. Matt wanted Kate and the kids to come home to California and tried to assist Kate in coming without him traveling too. Matt, as you can see in these exhibits, this is what this is talking about, had arranged for the rental car and given her $600 so she could rent the car and drive back to California. So this was on the 11th that Matt had actually taken these steps, for Kate to come to him and not vice versa. But then Kate and Tracey worked together to create excuses as to why Kate couldn't drive to California and Matt had to come to Utah. They came up with at least 2 ruses that we know about. The sprained ankle ruse and the can't rent the car ruse, right? And so you can see on here the development, or not necessarily the development, but the evidence of the spraining of the ankle ruse. There's a discussion about the car rental and what does mama say? Plus, you're gonna sprain that ankle. And you saw in evidence, and you can review more fully if you wish, the entire text exchange talking about this supposed sprained ankle, about how they're going to go to the DI, and so on and so forth. And then, again, later on, the can't drive with that angle comment. And further, the excuse of not being able to do it because of the out-of-state driver's license and credit card versus debit card issue.
The DI Crutches is a thrift store.
Throughout these messages, you can see that Tracey is in control of this. Not Kate. Tracey is directing this show. At Tracey's direction, not only did Kate convince Matt to drive to Utah, but she convinced him to drive the truck, one with the AirTag in it. You heard a phone call in which Matt expressed concern about the truck breaking down and wanting to borrow the car. But Kate was insistent he had to drive the truck. We'll come back to that in a sec. That was Exhibit 13. It's around 10 minutes long, so I won't play the entire thing right now. But there's several quotes in there. One of them was, "You can't just roll the dice with the truck." Several times that Kate comes back and back, urging Matt to take the truck. And you know why, because the AirTag that had been hidden inside the truck, in the bin, under the pile of trash. One Matthew didn't know was there, partially because of the trash, and partially because he had the Android phone and wouldn't see it. Now, Tracey, Kevin, Rachel, and Tara Lynn, unlike Matt, could and did track the AirTag, including when Matthew came to Utah. We'll just go over a few examples. Right? Okay, so here is Tara Lynn telling Kate to hide the AirTag in the truck. Then we see the group message that was created between Tracey, Kate, Tara Lynn, and Rachel, where they're all tracking Matthew. Comments are made during this discussion. But you might break down the desert. Ha 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 ha. At least we can watch it. Well, watch it because they can track it. And that was Tara Lynn saying that. Rachel responds, at least we'll be able to track the truck as long as the AirTag stays there. We have elsewhere, a few days later, Kevin tracking Matt, telling Kate, hey, the tag is still active. And here's a screenshot of his current location. Even Kelly, Tracey's sister, knows that she's tracking Matt. Have you been getting hits from the AirTag in the truck? You can infer Tracey told her about it. Despite Kate convincing Matt to drive to Utah in this trackable truck, there was another problem. Matt was reluctant to come inside the house. There was a few reasons for this. One, he didn't want to turn off the truck because of the whole starter issue and the concern of would it turn back on. But the evidence also shows it was just because of what his purpose was. He just wanted to pick up the kids, get his little family, get them in the truck, and go home to California.
Next slide, please.
We turn the volume, it looks like it may not have been turned up.
Yeah, what's going on?
Good, how are you?
Pretty good, what's going on?
I was just calling to see how your drive is going.
I'm just passing that abandoned water park.
Oh, fun. Cool.
Yeah, I just like right now, I'm looking at it.
Yeah. My mom said if you're too tired, when you get here, that you can always sleep here. She said she'll keep her distance. She'll actually be asleep.
It's not like that. I'm just not gonna talk, that's all.
Okay, or if we want, we can get a hotel. She said she'll give us $100 towards it.
No, it's not like that. I just wanna see my baby, see you. I brought my pillow and everything else.
Right.
So, I'm not really worried about it. So, what do you want to do?
I want you to be comfortable.
I will be. I just become once I have my family.
Okay, well, good.
Oh,
awesome.
Yeah. So, cool. I'll just keep trucking along here.
The morning started with these text messages. Good morning, getting up and getting moving. Exciting for today, is what Kate told him. He responds, I'm over the moon. Can't wait to hug and kiss you all. You have other phone calls in the record that you can listen to from the morning. That last phone call you just heard was at 2:20 afternoon. There's another one around 8:15 p.m. You can listen to all of them if you want. You'll notice Matt's not agitated. Matt's excited about seeing his family, seeing his baby, going home. Completely different than the testimony you heard from Tracey, that he was agitated, and that explains what happened. It's not what explains what happened. Anyways, Matthew didn't want to go in Tracey's home. He didn't want that confrontation. He didn't want to turn off the car as we discussed. He just wanted to load quickly and go home. The starter was an issue, but Matt also knew what the state of his relationship was with Tracey. He knew they didn't get along. He knew they each knew what the other thought of the other. So, we have these messages that clearly show how he feels. We've seen the messages from Tracey that clearly shows how she feels. Despite this, Kate repeatedly reassured Matt throughout the drive. She gave him the gate code. She told him the doors were unlocked. She put that cardboard out. She said she just heard Tracey would be asleep. One of the phone calls, she told him, just come right on in. The door is always unlocked. And Tracey was actually involved in these reassurances. We see that in the evidence. Here's just one example of it. Tell Matt, I'll stay away, and I'll be as sweet as candy. Tracey, who had for months belittled Matthew, for months threatened to kill him in these so-called jokes, made a threat to him over the phone, said fuck him, belittled him, said he didn't have the balls to do anything. Tracey, who had gotten Kate away from Matthew, is now encouraging Matthew to come inside the home without knocking, without hesitation. What does common sense tell you about that? Meanwhile, when this is all happening, the family is monitoring the AirTag. Now, you heard Rachel testify that she watched it at least 5 times that day. We know Tara Lynn and Rachel knew about it. Here is Rachel texting Tara Lynn a screenshot of Matt's location, to which Tara Lynn replies with an expletive, "That's pretty far up there." We know Tracey was doing the same. Here's the text from Tracey to Kate with that same Apple AirTag that was being used to track him. Now, July 12th was a hive of activity amongst the family as preparations were made for his arrival. Throughout the day of the shooting, the family exchanged phone calls and messages, many of which discussed Matt. We have reconstructed, for this presentation, a timeline sourced entirely from the evidence in the trial of what all these people were doing on July 12th before Matthew's arrival. Now, I'm going to give you a note up front. This is a demonstrative. This has not been admitted to evidence. You don't get it during deliberations. So feel free to take any notes that you would like from this to cross-check those exhibits.
Take notes
on what stands out to you. Now we have a little key. There's persons involved. Matt will be highlighted in this light purple color, Kate in yellow, Tracey in red, Tara Lynn in green, Rachel in blue, Kevin in orange. Aurora, Jake, and Tim don't appear very frequently, so they're just still on white. You'll understand it. And then the communication types also get colored. Text messages in black, phone calls in purple, Facebook Messenger, whether that be a text or a call, is in blue, and web searches are in green. At the top, you'll see the time, you'll see the sender, you'll see the receiver, you'll see the message or a description of what it was, you'll see the duration or an indication that it was a text message, and you'll see a note to the exhibit number, because like I said, these are pulled from the exhibits. Feel free to refer to them during deliberations, should you so choose. So it starts out, good morning, Exhibit 8. We've already been over that text exchange. And then Tracey and Kate have this discussion about the rental car. Darn that rental place for not taking a debit card. Kate, I have to be more upset. Then they have a continued discussion about that. And then what was found on Kate's device, the audio recording that occurred sometime between 7:57 and 8:04. The recording where she goes up to Kevin, saying she needs to go make her story more believable or plausible, and that the kids know that she is upstairs. Kate then has a phone call with Tracey, then a phone call with Matt, and then we have some back and forth phone calls. Kate Tracey, Kate Matt, Tracey Tara Lynn, Kate, Kate Tara Lynn. At this point we have 3 phone calls between Kate and Matthew where she is convincing him to come out to Utah. The first one, that's the one where you can't roll the dice, you heard the segment of. Go back and listen to the entire thing. The second one, Matt says he's not going to borrow a car. And by the third one, Matt says that he got the permit, he's going to be able to drive the truck out. And then right after that, Kate texts Tracey. He's going to drive out. So the plan worked. Matt's coming to Utah. And then what happens? Kate calls Tara Lynn. Tara Lynn calls Rachel. Rachel texts Tracey. Tara Lynn calls Rachel. Tracey texts Kate. I'll call you. Then Tracey, a little bit later, does call Tracey. Have you ever seen the third Lord of the Rings movie, Return of the King? Or is that one scene where they light the beacon tower and it just goes down the chain and each one gets lit in a row? That is exactly what's happening here. At least on this day, everyone in the family that's involved in these conversations knows what is going on with Kate and Matthew.
Bingo on Lord of the Rings.
And then we have that text message we already looked at where Tracey shows the AirTag location. And then we have a phone call between Matt and Kate where Kate confirms that Matthew is coming inside.
Yeah, probably just pull right up in front of the house, you know?
Yeah, I would slow it up. How long are you going to take? Like 15 minutes to load up?
Yeah, not long at all.
Yeah, I'm not trying to rush you. I just don't want to risk the truck. That's all, you know?
No, I get it.
Yeah.
You gonna come inside? Are you gonna come inside and help me load up?
Yeah.
Okay. Yeah. The front door is always unlocked, okay?
So that entire call is about 11 minutes, Exhibit 16. There's more to it. Those are some highlights. Then we get to lunchtime. We again have a flurry of calls back and forth. Or I guess I should say messages. Some of these are Facebook, some of these are phone calls, some of these are written communications. We see that Rachel sends the image of Matthew's AirTag. Carolyn, that's where she says that's pretty far up there. And then again, we have some flurry of overlapping phone calls and messages between Kate and Tracey and Rachel and Tara Lynn. And then right at the end of this back and forth, you'll see at 12:58 there's a phone call between Tracey and Kate while on the phone with Rachel. We're not sure if that's a three-way or if Rachel's put on hold at this point. And then there's a call between Rachel and Tara Lynn, and then a messenger between Tara Lynn and Rachel. But then what do we see? Tracey and Tara Lynn have a phone call that lasts 3 hours and 56 minutes. Then they have a phone call through the Facebook app.
I think it's 3 minutes, 56 seconds.
30 minutes and 30 seconds. And then immediately after that, over 30 minutes of communication, they have a text exchange. And I submit to you that this text exchange is completely out of place to the tenor of everything else. In this text message, they continue going on about how happy they are that Kate is going back. I was calling to let you know that Matt is headed out. She already knew by that point. To pick up Katie and the kiddos. Your phone is kind of annoying because I came and had a normal conversation with you. She's going to try to make it work and be a positive experience. I told her I'm a little nervous. Heart emoji to Tracey's first message. I know he's trying, but I'm nervous and trepidation for sure. But I support her completely. I really need you to support her because she is on the fence. And she needs our love and support to do so for the kiddos. Tracey continues, my only prayer today is he's peaceful and continues to be peaceful. With her, nachos, but she corrects it. Sorry, the month to months, so I'll read it corrected. With her, not just on the drive back from California, but also in the months to come. So not just. And then Tara Lynn responds, from what Kate was telling me, it sounds like he's gotten sober and is really trying. I'm still worried about his temper. I'm still hoping that he's really had a change of heart in the last couple weeks. I'll definitely try to be supportive. It does make me nervous, though, because he says one thing and then he just does another. Submitting to throughout all of this, it's not Matt who said one thing and did another. Tracey, I love you. Tara Lynn, I know that them working this out would be the best for everybody. And I will support her no matter what. Sorry my reception is so crappy. I would have loved to have this conversation with you on the phone. Just on the phone for nearly 35 minutes. Tracey, I love you. And all I care about is that she is happy and that the kids are happy. And I feel like her giving this another chance. Especially after she came out for some time to think. It continues. The hardest part, they continue this another page or two. Tracey discussed about how she would just stay out of the way unless Matt wants to come in and say hi. I'll give them space. I feel like Matt's not happy with me. And I'll let Katie stay with us. So I'll be fine. As time goes on, I'll be fine. Probably for the best, and so on and so on. Discussion of marriage counseling. The excitement of seeing his family will be just all he's thinking about. Same. Oh gosh, don't say that, Tracey says. If he stews on the whole drive, that would not be good. I pray to God he's only excited to hug those babies. 100%, Tracey says to that. Tracey continues, hey there, I need to focus, so I love you, and I'll talk to you later. And I do not like that. Your phone is ridiculous right now. But I can't imagine how you might be feeling about that dang phone. You probably want to throw it across the room. Tara Lynn, I know, I feel like you only want to see the good side of things sometimes. And I hope that you're right about that things go well. For real. I'll let you work. But thank you for taking the time to text with me. I feel so isolated with my reception being so expletive. We know she's free to use expletives in so many other communications. She edited this one for some reason. Yet one more reason to show this is a ruse, this is planted. Does anyone really believe this? This is completely incredulous. Here's another one that we know that they knew that Kate wasn't going back. telling everyone not to engage with Matt. There won't be us after this deceptive mood. Great. That's kind of the plan, dude. That's kind of the plan, dude. There won't be us after this. Any event, after that additional ruse, Tracey and Kevin, quick phone call, they're meeting for sushi. Tracey immediately starts planting messages with Kate. What happened since the previous day? Why is she excited now about this? Well, they're excited because they lured Matt out to Utah. He's going to come in the house. So while Tracey is putting up this farce, Kate is relating information to Matthew. Tracey, you see right there at 2:13 p.m., searches the "It's Happening" meme. What's happening? Why is she so excited? And well, again, Tracey is putting up this farce. Rachel is clearing the house. You can see that she calls Jake, she calls Tim, she calls Aurora, she calls them all off. Rachel and Jake live there, so just make sure they're not there. Tim, who was going to come over, hear his testimony, he was told not to come. And then we continue to see phone calls throughout the afternoon being exchanged, some of them missed, some of them connected. But what's most important is that Kate and Tracey continued the ruse of Kate going back to California in those messages to Matt. You heard about preparations, you heard differing reasons for the preparations, but we do agree that the children's toys were cleaned up and placed in another room. You see in the photos that the blanket was placed on the couch right next to where Matt was shot. And also during all these preparations, the family monitored Matt's location. Kate consistently told Matt that she loves him, and she was excited, even though we know she had no intent to leave. Her bags were not packed. She's not leaving on a jet plane. She's not going to get in that car with him. And then at least 3 times in this last phone call at 8:13, Kate confirms, "You're going to come right in, though." That's Exhibit 18. And then Kate sends him the gate code. And then at 10:01 p.m., just minutes before Matt's arrival, Rachel texted Tracey and then Kevin and told them to look at the AirTag as Matt passed through Orem. So who's the first person she sent it to? Tracey. Who's the second person she sends it to? Kevin. But who is noticeably absent? Who does she not send it to? Kate. Kate, the one the family is supposedly worried about, the one who has an Android device, and so can only access it through the family or one of her kids' iPads, the one we're supposedly worried about if Matthew is truly dangerous, she's the only one left out of the loop. Now finally, one last point.
You called me.
Skip the wrong way. One last point before we move on. We color-coded this for you. Now I'm going to go back to the beginning. And you'll see that Tracey is in red. There it is. Here's the beginning. Tracey's in red. There she is. There she is. There she is. There she is. There she is again. Tracey. Tracey everywhere. More Tracey. She is everywhere because she is everywhere. Tracey is the hub in the middle, and her children are the spokes.
She's omnipresent.
She's the mission control. She's orchestrating the entire plot. She agreed with Kate to have Kate, lure Matthew to Utah and come inside the house. She agreed with Kevin to have him lie and wait and shoot. And then she had Rachel get Rory and Jake out of the house and call Tim off and track Matt's location. She had Tara Lynn help her plant a duplicitous story about being happy with Kate going back with Matthew, but also that Matthew might be stewing all day, so be careful. A story that no one should believe at this point. So how do you know she manipulated everyone? Because just look at what she says and then what everyone does. Look at her involvement and look at the result. You know what one of the worst parts of this is? It's that she didn't just deceive Matthew. She deceived some of her own children into doing her bidding without them ever realizing what was truly happening.
You called me.
We're going to move on to the ambush, the phase 3 as I divided this. So at 10:01 p.m., Matthew was in Orem. Within minutes, he arrived in American Fork. Just before 10:06, Matthew entered the gated community. Inside Tracey's home, Kate was upstairs with the children. Tracey waited in the kitchen, and Kevin had put on a holster and Tracey's gun in preparation for Matthew's arrival. Now, there's really no other explanation for why he'd have the gun and holster on. 10 o'clock at night, inside his own home, safe, gated community. The explanation that you should infer is that he intended to use it, and that's why he had it on under those circumstances. And having been called off or sent away, no one else besides the 2 youngest children asleep upstairs were in the home. At 10:06 p.m., the neighbor's security camera recorded Matt's truck pulling up to Tracey and Kevin's home. It took around 30 seconds to park. The video at least lasts 30 seconds, and you see him at least stopping by the end of it. And then he gets out and goes in. At 10:07 p.m., there's the parked truck. At 10:07 p.m., within mere seconds of his entry, neighbors said they heard the gunshots from the home. Now, when you look and analyze the physical, the forensic, and the medical evidence all together, it shows you what happened. So as shown in this slide, which I already had up, Matthew took over a little 30 seconds to stop. He left his hazard lights on when he got out. He carefully parked over the cardboard, took a few moments, whatever time he needed, and then proceeded inside. He walked to the front door and entered the home as he was told to. Remember, the door is always unlocked. The screen had been removed. And he took off his sandals right inside the front door as a good guest does. And then we can see from the Faro scan that immediately or within seconds of Matt's entry, Kevin began shooting. Matthew tried to flee down that hallway to the left. That makes sense because the evidence shows Kevin must have been standing to his right based off bullet casings, bullet trajectory, and all the other scene evidence put together, not any one individual thing. Now, unfortunately, Matthew didn't make it far. You can see with the black redacted box where Matthew fell after being shot in the chest, the side, the wrist, and the back 3 times while he moved away from the door towards the hall, landing that 10 or 15 feet from where he left his sandals. Now we're going to come back to that aspect in a moment and where Matthew fell. But for now, just remember what the crime scene expert, he pointed out where Kevin would have been based off a totality of the circumstances. Casings, the bullets, the trajectories, and all that. And from his testimony, you may reasonably infer that this was an ambush. 10:06, you saw it on the video, 30 seconds, more time to get to the door, 10:07 shots fired. There wouldn't have been enough time for Kevin to run around to that garage and get that gun from the safe. There would not have been enough time for Matthew to walk around as was described in some of the testimony. It was immediate or near immediate ambush.
It's coming up on an hour.
And that's the result.
About 6 minutes left.
At 10:08 p.m., the neighbors who had heard the shots texted Tracey and asked if they were okay. At 10:09, no response. They called 911. Now, around this time, Kate, who had stayed upstairs with the kids, overheard Kevin say something to the effect to be careful, because he, being Matthew, might still be moving. Interestingly enough, that's one of the few things that Kate said that didn't have some form of independent or external corroboration, until Tracey took the witness stand and said the same thing. So at least that part was true from her testimony. Tracey did not call 911 until more than 8 minutes after the shooting. 6 minutes after the neighbor had called. And by that time, police had already been dispatched and arrived 2 minutes into Tracey's call. Notice when they arrived, the lights were still off. No one in this 8 minutes turned on the lights. They were expecting him and didn't have the lights on awaiting him. Like I said, it was a bad cover-up to a bad conspiracy. We'll come back to that. In that 911 call, Tracey described Matt as armed with a knife, even though when she testified yesterday, she couldn't remember seeing the knife. To police who arrived, Kevin's first words were, "That guy had a knife and I voice turned off." These statements were not true. Matthew was not armed. He was not an intruder. Remember, he was invited. He was expected. He'd been tracked. The cardboard was out. He's given the gate code, specifically told to come in. Walk right in, because Tracey would be asleep. But she wasn't. And he did, to his death. This brings us to the cover-up, the obstruction, perhaps a better way to put that. First, there's the knife. Okay? As known in the 911 call, Tracey said Matthew had a knife. And then when police arrived, Kevin claimed Matthew had the knife. At the police station, Kevin reiterated Matthew had a knife. Tracey said the same thing at her interview at the police station. Hours later to the neighbor, Tracey also said Matthew had a knife. That's the story. A knife, as you can see, was found in Matthew's hand, but that knife was planted. There are numerous pieces of physical and forensic evidence that show this to be the case. Let's start with the photo. Just to start with common sense. Does that look like that knife in these conditions was planted? Or that he'd been holding it all along? Now, as you consider that, consider this evidence. That knife is in the wrong hand. Matthew was left-handed. That knife is in his right hand. Second, the knife is in the in the wrong position. It's backwards in the wrong hand. So the blade is facing inward, and the spine of the knife is facing the fingers, with the finger grip facing the palm. Can I get that, please? So what I have here
That's important.
is not the actual knife. The actual knife is in that exhibit box. Remember, we showed it to you. You maybe saw the zip ties. So this evidence had DNA testing. You can't touch that. You can see it if you'd like. So we have brought in a demonstrative. This is you could call it a replica if you want. You could call it a facsimile. It's just another copy of that knife. You can see what it is, a tactical knife. You can see back here the spine. You can see right here the finger grip. And you can see how someone would naturally hold this knife if they were going to use it. But you can also see from that photo that's not how the knife is being held in his hand. It's being held 180 degrees backwards because it was planted in his hand. Consider the blood evidence that was discussed. There was the discussion of the blood pooling and the patterns. To be honest, the photos are somewhat graphic, and I'm not going to show all of them. You have all the ones that were admitted into evidence, and you can review it for yourself. But you can see enough here. There's blood pooling near his shoulder. There's no blood pooling under the arm, where that gunshot wound is. Blood is everywhere else, but where the arm and the wound is. And that tells you that arm had been moved. Then there's the medical evidence. Matthew had been shot through his arm near the wrist. We had a discussion where the gunshot wound perforated the skin, the tissue, the ulna bone, and the flexor muscles. Do you really think Matthew would still be holding that knife after being shot 7 times, 1 time in the wrist, running down that hallway away from Kevin, and falling face first on the ground? And fifth, we know that the knife belonged to Tracey. I've reiterated this, and I'll keep reiterating it. Believe Kate to the extent you can corroborate Kate. Okay? Now, Kate did testify. This is Tracey's knife. She told you where it was hidden in the laundry room. She told you that she saw it beforehand. And how can we corroborate this? Well, we know it's an unusual knife. The detective discussed local stores don't sell this. We saw where Tracey gained access to it. Her friend Amy's husband, Pierre, had passed away, but he'd been getting these tactical mystery boxes from My Tactical Promo. And that Tracey, by being in the home multiple times, taking care of her friend Amy, had access to it. We learned in testimony that Tracey's not above taking things from Amy. We talked about the titles, right? So she had access, and she does that in another circumstance. So you can infer that she did it in this circumstance. And we know from the Facebook posting by mytacticalpromo.com that it is that knife. And then there's the DNA evidence, where, there's a lot you can say about DNA, but what you can say is there's very strong support that the DNA on the knife belonged to Matthew and Catherine, or Matthew and Kevin, and Matthew or Tracey. Point of that is, you may not know which of the Grist family members planted that knife based solely off the DNA, but you know it wasn't handled only by Matthew. And you know someone in that home put it in there. Okay. You also heard the expert's opinion that it was planted, right? Consider that for what it's worth. But you already know it from your common sense, from these factors that we just went over, that Matthew was not holding that knife when he was shot, and he was not holding that knife until Tracey and Kevin put it in his hands. At this point, I want to review a few of the instructions with you. I'm not going to put these on the slide. You're free to follow along. You have a copy of these. If you want to make notes, you can. You certainly don't have to. And I want to be certain of this, that you follow the exact language in these instructions. And I'm just going to walk through a few of them. And we're going to start with inferring intent, right? Tracey left a lot of digital evidence that tells you what her intent is. But you still have to infer a little bit. And you have to infer a little bit about everybody else in the family and what their intent and motivation was. And that's what this instruction tells you can do. You seldom have direct statements, so you use the statements that you have, use the conduct that you have, the circumstances that you have to see what the intent is. And then on instruction 30, we have the party liability, the party to the offense instruction that we went over earlier. And we already discussed this, that Tracey is guilty if she directly did any of these crimes, and Tracey is guilty if she intentionally, knowingly, or recklessly solicited it, requested it, commanded it, or encouraged another person to commit the charged offense, or she intentionally aided another person to commit the charged offense. Okay, so with that in mind, let's look at the actual crimes. The instruction 31 is the murder instruction. Tracey Grist as a party to the offense. Let's just focus in on intentionally or knowingly caused the death of Matthew Rastelli. If you want to look at B, you want to look at C, you're certainly free to. There's various theories. You could look at this evidence and decide that it was a depraved indifferent circumstance. But the theory the state has told you today, the theory that the evidence most closely tracks, is that Tracey Marie Grist intentionally or knowingly caused the death of Matthew Rastelli by agreeing with Kevin to have it happen, by agreeing with Kate to have it happen, by soliciting or requesting Kevin to do it, or maybe she just encouraged Kevin to do it. Really, the evidence shows she did all three. She certainly aided by aiding in the ruses of Kate, that she gave Kate the pass to Matt, by helping convince Matt to come into the home to be ambushed by Kevin. Then we look at instruction 34, conspiracy. The only one of the charges that is not a party to the offense charge. On this one, a little bit more simple in some ways. Tracey Grist intended that the murder be performed, agreed with one or more persons to engage in conduct or performance of the murder. So you could almost think of it like, loosely, as almost like a Russian nesting doll, right? That she conspired, but that's a lot less of a crime in a certain sense than being a party to the offense, right? She can agree that the murder happens without necessarily doing all the soliciting, all the encouraging, all the aiding, right? She just agrees with them to engage or cause it in any little bit of I should probably rephrase that slightly differently. She agreed and then took a substantial step along the way towards committing it. And the substantial step could be a little bit or far less than the party to the offense soliciting or encouraging or aiding. Then we have the obstruction of justice, back to the party of the offense. And you know, we have this, and it's a little bit lengthy, but I want you to compare that to 36 while we're doing this. So Tracey, as a party to the offense, had the intent to hinder, delay, or prevent the investigation, the apprehension or prosecution, conviction, or punishment of any person, regarding conduct constituting a criminal offense, and then did one of these three things: altered, destroyed, concealed, or removed, made or presented or used anything known to be false, or provided false information. 36 makes this easy by putting that in plain language, what that means. What that means is, did she plant the knife, or was she a party to the offense of planting the knife? And or did she make an untruthful statement to 911 or the police about Matthew Rostelli having the knife before Kevin Ellis shot him? And then we have instructions 37 and 38. They are substantially the same. They are both the offense of commission of domestic violence in the presence of a child. Count 37 represents Steele being upstairs in the bedroom when Matthew was shot. 38 represents Cheyenne being in the bedroom upstairs while Matthew was shot. And instruction 39 just simply points out that no one is disputing that Matthew and Tracey were cohabitants. One more thing I may want you to look at on the obstruction charge before we move on from the instructions. That is for planting the knife or the lies. And I want you to consider on that one Tracey's conflicting stories about the knife. You can see the evidence for yourself. There's no way she didn't see the knife, but think about the conflicting stories about a related point to the knife. She told Diane that she hadn't checked the pulse. She told 911 that Kevin had checked the pulse. And then her testimony is that she had checked the neck and the wrist twice. There's no way that she leaned down to check the neck or the wrist and didn't see that knife. On the other hand, there's no way that that knife was in that hand until she and Kevin planted it. So members of the jury, we're reaching the end here. Are you firmly convinced that's the standard? Are you firmly convinced that Tracey is the reason for or cause of Matthew's death? Are you firmly convinced that she did one of these things: solicit, request, command, encourage, or aid the murder of Matthew Rostelli? I want to end with the words of her co-conspirators. There were three persons involved in this murder: Kate, Tracey, and Kevin. Again, believe Kate, you can corroborate Kate. She came in, she testified. But bluntly, her testimony didn't go well. She clearly has issues, to put it nicely. But she gave a very specific description about the conspiracy and what was happening. She gave a very specific description of how she even asked Tracey to call it off, and Tracey said no. And you may think there's reasons to discount her because of that credibility instruction. But at the same time, you also have the third person in the conspiracy. And what did the third person in the conspiracy say in the recorded phone call? Kevin said also that this was Tracey's idea. Kevin admits to his involvement. And Kevin says that he tried to go to Tracey and say, "Are you sure this isn't the best idea you're having? You will affect so many, many lives."
She ruined so many lives, and I'm worried to hurt her feelings.
Yeah. Well, I can tell you something now, a little extra.
What's that?
Oh, I asked if she was sure.
She was sure?
Mm-hmm. Because she was like, she didn't tell me anything about all this stuff that happened. And I was like, "Are you sure this is exactly what's going to happen?" And I'm like, she's scheming and doing all this. And she said yes. And she beat Cheyenne. That was her response. Or he beat Cheyenne.
Oh my God.
I know I wanted to hear. I'm sorry that. Like, I don't want to tell you that for so long.
No, I know. I can't even imagine.
And I feel like I still bear so much of the blame too for all this.
And that makes me so mad that she's caused you to have to live with this.
I mean, I could have done something different. I should have started off, but I should have said no.
Yeah. Yeah. But your mom should have never asked you that. You should have never had to say no.
The same person who planned this is the same person who baked cookies. It's the same, like...
That's wild. Like, she's the one who made me my chocolate chip cookies without chocolate chips.
I know. Yeah. And blueberry muffin cakes for your birthday.
Yeah. But this is what she wanted to do. This is, I mean, she had it, and there's consequences. She had to.
I just don't think, she just doesn't think far enough ahead. She never has. And I think she just is so used to getting away with everything, she just...
I literally warned her. I said, this will change so many lives. You won't even know how many lives it's going to change.
Oh my God, you said that? That's, wow.
Yes. I said, this is a decision you can't take back. I said that to her.
Wow. Kevin.
Yeah, so there's that.
You were the voice of reason. We all wish we could have, like, seriously, that's what Rachel and I were talking about. Like, the reason she didn't want to tell us is because she didn't want to hear our opinion. But you gave her the opinion that we would have given her.
It's breaking up.
I don't remember exactly what I said, but I know I got it across very eloquently and very efficiently. Of like, this is not the idea you're having. Like, think about it for a second.
Oh my God.
So, that's why I feel so much blame, because I would step up at that point and be like, you know what, no, I need to take my own advice. I trusted her.
Whose idea was this? Tracey Grist. Whose ruse was it to get Matthew to come to Utah? Tracey. Who manipulated Kevin into shooting Matthew? Tracey. Who had Rachel clear the house and call Tim off? Tracey. Who had Tara Lynn help her create false texts claiming reconciliation and joy over reunion? Tracey. Whose gun was it? Tracey. Whose knife was it? Tracey. Who knew this would affect so many, many lives? Tracey. Who hated Matthew Rastelli? Tracey. Who was warned? Tracey. Who can't take it back? Tracey. So whose crime was this? We ask you to find Tracey Grist guilty of murder for causing the death of Matthew Rastelli by encouraging it, soliciting it, requesting it, and aiding it to happen. Guilty of conspiracy for agreeing with Kate and Kevin to end Matthew's life. Guilty of obstruction for planting the knife and lying to police. And guilty of 2 counts of domestic violence in the presence of a child. For having Matthew killed while his 2 small children were asleep upstairs. Thank you.
Thank you. Mr. Basler.
1 hour, 14 minutes, and 47 seconds for the prosecution.
That's a lot to digest. It's 2 hours.
Wasn't 2 hours.
Included words like she's not leaving on a jet plane, as sure as the day goes long.
What the heck?
This isn't a joke. This isn't an opportunity to write a novel. This isn't a benefit to come up with great little catchy phrases. This is about a man who came up from California to be with his family, and now he is dead. It is nothing to belittle, take light of. It is a serious matter and a serious allegation and a serious and devastating loss. When you listen to the phone calls between Kate and Matt on the day, July 12th, they're just happy, you know? Hey, how you doing? I passed the water park. They're just happy. You can tell, at least I can, that
he's miking up right now.
Happy to be getting this over with. What? Of the separation between him and his kids, his babies, and, 3 weeks of probably, in his eyes, hell, even though he had to sort of endure it alone. Because his wife took his kids. But there's a lot to this story that the state has produced with their big team of people and their big stuff that they have. That certainly is intimidating to anyone faced with these things. And when you look at all the red in that little figure that was presented to you, the graphing, it's because they produced it. It didn't account for all the other text and all the other stuff. They produced the red. They produced it. They present it. They intimidate with it. Law enforcement intimidates with it to try and prove their case as well. And it's intimidating. It's intimidating what could happen when you enter a plea, what could happen when you resolve a case, when they present you have no choice. Well, today we had a choice. And the choice is to plead not guilty, that I wasn't part of a conspiracy, that there was just a tragic thing that happened. And did it happen? Yeah, it happened. In my opening statements, I said that the state had a narrative, and Kate was required to follow that narrative. And Kate came here and testified about a big plan. And I referred to it as a messy plan. I was mocked for saying that, frankly. This is a crazy plan. This is ridiculous. This is a plan where they had an idea back in January or February to murder Matt because he doesn't want to go to Disneyland, or in May to murder Matt because he said that Tracey told Kate that she used the smoking camper too much, or that Tracey said to Matt, I want the kids to come for the summer California, and he got mad about that. The reality is, and I think the truth is, and that's what you're here to really weigh out, this has been a volatile family regarding Matt and Kate for a long, long time. Not just a year, not just since 2024, but 23, 22, 21, 19, 18, 17. I mean, these have been volatile about the relationship for a long, long time. It was known to all the family members. Every single one. Tim referred to himself as a peacemaker or peacekeeper. Why do you have to be one unless there's not peace? Right? Do you have a family peacekeeper? I guess we sort of do in my family, but we really don't have this kind of need to keep peace.
It's not you.
I'm a grandpa. I got grandkids. I got in-law kids. I love my grandkids. I love them all. It's great. But the truth is, sometimes I need to tread a little lightly with some of the things I say to my kids. Sometimes I need to tread a little lightly with some of the things I say to my in-law kids. Sometimes I need to tread a little lightly with my little guy who's my little grandson, just because I want to make sure we continue to have a good relationship. Because I love him. And I know all of you know that to be true. You just sometimes have to tread lightly. Sometimes, believe it or not, my kids don't follow my advice. No matter how logical I am. And believe me, I think I'm very logical. But they just don't. Because they think they're smarter than me. Or they think they have better knowledge about something than me. Sometimes it's really important. Sometimes it's, hey, you need to maybe treat your wife a little bit better. Yeah, those conversations actually occur in my family. They occur between my wife and me, too. So, it's an ongoing process of trying to get things better. But that doesn't lead to some huge conspiracy about murder when nothing said today talks about the fact that the killer is Kevin. Kevin killed a guy. He shot a guy 7 times. And that officer's testimony, that expert, he talked about how he's trained that you have to unload till the object is not moving. They're trained that because this inclination is not to do that. The inclination is just to shoot. But we never heard anything about Kevin being high on cocaine today. We never heard about Kevin being out of his mind on the impairment of a controlled substance, because that doesn't matter. That's not really a fact. That's not a fact to be considered, I guess. It's a consideration for me, because it makes me think that that guy's not thinking right, that that guy is not thinking properly, that that guy's impaired. Cocaine is a big drug. It's a big drug. Not discussed.
It's a powder.
Doesn't matter.
I guess rock? What are we talking about? Crack?
I'd like to pull out, and I'm not sure where this audio is, and maybe Faye could help, but I'd like the exhibit of Kate at the police station. And the reason I would like to pull up this exhibit is because we know what Kate did in furtherance of this plan. She had it all planned out. Indeed, she had until February to plan it out. She was ready to murder him because of the Disney fight, and she was ready to come up with all these ideas, and she included Rachel in that because Rachel, the poor little girl who got, cross-examined, direct-examined by prosecution there, being basically accused of wanting to shoot Matt too, and Tara Lynn, and all the family knows that the real plan is to kill Matt. And the best plan they have is we're just going to kill Matt. Even though we have all this time to prep for it and all this time to prepare for it, we're just going to kill Matt. Nothing else? Well, I'll tell you, I watch enough shows where I could come up with a plan a little bit better than what we see Tracey provide the police when she goes to the police station. Do we have that up?
You said you don't watch these shows.
Do you have that up?
Because you do this for work and you don't like them. I seem to remember that.
Tracey at the police station. Did I say Kate? My client, Tracey at the police station. As you might remember, Tracey was on the front yard. She was talking to law enforcement a little bit. She had her phone in her hand. She testified that she called a police officer. That's probably not true, because everything Tracey says is a lie. Tracey probably didn't call the lawyer, because everything she says is a lie. However, the lawyer appeared when she wasn't allowed to use the phone any further. So maybe it was true what Tracey was saying, right? She did call a lawyer, and the lawyer came. If we can hit play.
I am so confused.
These are unrefuted facts that you cannot challenge.
We're walking into the light. Is this the right video? Oh, okay, here we go.
Super did phone just for the meantime. Did want us to take your phone just for right now.
They took her phone.
So we'll get it back once we're done. if you need to make a phone call, so I'll give it to you. So, and I know that you had mentioned that you may want to talk to a lawyer friend that you have. So let me just give you your address again. Doesn't mean you're in trouble.
We can pause it right there. Now this is part of the plan. This is the great plan between Kate,
She's barefoot.
Kevin, and Tracey. Right here is part of their plan. You can hit play.
Hello.
So you have the right to remain silent. You say you can or use against you in the court of law. You have the right to talk to a lawyer and have him or her present while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not have or not answering questions or making statements. Do you understand these rights? Having these rights in mind, do you still want to talk to me? Do you still want to have that lawyer present when you talk to me?
I can talk a little.
Okay, sounds good. So, what exactly were you there for?
It's my house.
It's your house? Your daughter was just visiting, staying for a visit? Okay. Or were you planning on staying the night, or?
My daughter?
Mm-hmm.
She lives in California.
Oh, gotcha. So she's visiting from California. Okay. And was she there with her husband? No? Okay.
He's awful.
Mm-hmm. Gotcha. And she brought her 2 kids with her?
Yeah.
And they just have those 2 kids? Oh,
she's whispering.
Okay.
There's no paperwork or anything. She just came for a breather.
Gotcha. Gotcha. Did you go pick her up, or did she fly here or drive herself?
She rented a car.
Rented a car. Gotcha. And was that his truck outside of your house? Both of theirs?
Yeah.
Gotcha. Yeah, I know when I say his, hers, yeah, that's, thank you for clarifying that with both of theirs, but, so what kind of problems were they having? Do you know? You don't know? Okay.
We can pause that.
She's lying.
I've heard Kate talk about this relationship with Matt. I've seen the video of the wet tortillas. I've heard about Disney. I've heard about the smoke trailer. I've heard about... I couldn't even answer what their relationship is like. So when Tracey is answering that, I would imagine she's thinking, hey man, there's so many things here. They just don't get along.
No, she says, I don't know, I have no clue.
That's what I'm seeing. Maybe it's different. Maybe it's the plan to say they aren't having a problem. And really, he just came as a mysterious man at night and had a knife and we shot him. We can use common sense on that. We can hit play.
Yeah, but common sense takes me to the second one.
And that's okay, if you don't know, right? So,
I mean, I have an idea, but it's so nebulous, so I don't know.
Gotcha. Well, sometimes little details for us kind of paint the picture and to whatever that exactly happened, right? So that's why I ask. When did he get here to Utah? Do you know?
I think about a little bit after 10.
A little bit after 10. Okay. And did he call beforehand? Did he text? Did she know he was on his way?
She knew he was coming.
Okay.
And she was going to talk with him. And I was in the kitchen, and next thing I know, he was in the kitchen. He was like, hey, I go, hi.
Do you know if they had a conversation before? Or?
I have no idea.
Okay. Can I walk through me what was happening when you were in the kitchen? He showed up, and then what happened?
I was in the kitchen, and I was sitting on the counter, because I do that, and sit in the corner.
Mm-hmm.
And he said hi, and then he walked into the other room, but he was acting different.
Mm-hmm. What do you mean by he was acting
He was
different?
just,
What happened after that, after he walked away?
He walked away.
Mm-hmm.
He said, "Is Katie upstairs?" And I said, "Yeah, she'll come down." That's the last. I heard gunshots. But no more gunshots now.
Mm-hmm.
I've never heard a gun really fired. Except for I guess at the gun range.
Okay. And what were you doing when you heard the gunshots?
Just sitting on the counter.
Just in the same spot when you walked
Yeah.
in? Okay. Well, what did you do after you heard the gunshots?
I ran into the bottom of the stairs to go check on my daughter. I thought something might have happened to my daughter.
Gotcha. And what did you see when you went down the stairs?
On the ground, laying down, face down.
And then what happened?
I called 911.
No. It was 8 minutes later.
What was your daughter doing when you came downstairs?
When I came down, it's what?
Yeah, when you came
I
down the
went
stairs.
upstairs.
Oh, sorry, my apologies. I misunderstood. Do you know who this is?
This is the family.
Oh, gotcha.
Hey,
We're
talk to
here for you.
Kevin. Talk to Kevin.
Okay.
Kevin. So, could you take him to Kevin, please?
Yes.
There you go. Is that the guy you were talking about? Yeah. Oh, perfect. There you go. He's here. Do you want him present?
No.
Okay, perfect. Sorry, when I thought you said that he was downstairs. Gotcha. So you went upstairs to see her when you heard the gunshots. My apologies, I misunderstood you there.
Everything happened on the main floor.
Mm-hmm.
I was in the hallway, and then I went upstairs, and I just said, "Stay here, don't come downstairs." I don't come downstairs.
And that was to?
My daughter Katie.
Okay.
Because I didn't want her to see.
Okay, I'm gonna just, because obviously I was confused somewhere, so I'm just gonna back up a little bit. Kind of run me through you sitting on the counter in your kitchen, hearing the gunshots, and then what happened after that.
I went and looked in the hallway.
Mm-hmm.
Or I went to the bottom of the stairs, and that's the hallway.
Mm-hmm.
I don't know what else happened.
So after you went to the bottom of the stairs, then you went upstairs and
Yeah, and
with your daughter.
she said, "What happened?" I said, "Just here. Just don't come downstairs, please don't come downstairs, please don't come downstairs." I didn't want her downstairs.
And then what happened?
The slow hand moves are just crazy.
I know I called out a lot.
Mm-hmm.
And they asked if I had to see her on this. Just looking at him on the ground. And then the door will ring.
Mm-hmm.
Because the neighbor upstairs, Caitlin, heard a noise because she asked me if I was okay. So when I went to call, she said, "Is everything okay?"
And what's your daughter's name? Sorry, I want to keep referring to her as your daughter, Katie. Okay. And you probably mentioned that, but I heard Caitlin and I didn't want to get confused. Where were Caitlin's kids at when this happened? Sleeping. Okay. And that's on the upstairs level? Where was Kevin at when this was going on? Well, thank you for kind of letting me know on your side of things what was going on. So I'll step out, and if we have more questions for you, I'll let you know. Okay. Thanks.
It's 11:42 that night. Shooting taking place 10 after 10, something like that. If we can play the next video.
Thanks. Sure. You can have that seat. Okay, Tracey, I just wanted to kind of give us some time to kind of think. I know you were saying a lot of I don't knows and stuff like that, but is anything else kind of come to your mind right now? No? Not at all? Okay.
I am so in shock. Like do his parents know? Did someone call his parents?
I assume someone has at this point. I've only been here with you, to be honest, so all that information I don't even know myself. The only information I know is kind of what you've told me, and that's about it. So.
Or is Katie here too?
I believe she is, and with her kids came with her, yeah, so they're not alone by themselves.
Where's Rory?
We're at Rachel's house.
In Ogden?
Uh-huh.
Okay.
Is that another kid?
Rory's my daughter, Rachel's my other daughter.
Gotcha. Okay. So just to be like candid, I kind of feel like you do know a little bit more than you're letting on.
Nope.
Okay.
It was, he appeared, and I was in the kitchen. And
I guess I'm more talking about with kind of stuff with Kevin.
With Kevin? Mm-hmm. Nope.
Not at all.
No idea where he was. No.
Okay. Okay, well again, honestly, it's the best policy.
I almost know nothing.
Okay.
She schools me on being honest.
Well, good. We always need someone looking after each other, right? To be honest and forthright, right? So, and again, that's just kind of the vibe that I'm getting, so.
And I've told her that the most important thing is to be honest and truthful, and we can decline to answer if we want to, and she will do that, but she's not, so far as I know, withholding anything.
Gotcha. Okay. Well, I just wanted to come in here and see if you did remember me, because again, like I said, I know you were saying like a lot of I don't knows, and so I just wanted to see if you remembered anything else and talk you with a little bit, but nothing comes to mind at all.
I interacted with Matt for like maybe 3 seconds.
Mm-hmm.
And I didn't see Kevin. And Matt went around the corner, and by the time I don't even know, I didn't see anything. All I heard was noise.
What were the noises that you were hearing?
The shots.
That was the only noises. There's no conversation, no confrontation at all.
Not that I heard.
Okay. Gotcha.
Have you been to the house? Do you know the layout?
I haven't, so.
This is the plan. 3 months in the making. This is the plan. For Tracey to say, he came in the house, said, "Where's Kate?" And then I don't hear anything, no confrontation, no arguing, and then gunshots. That's the plan. That's ridiculous. If you have a plan, you're going to have some kind of plan, aren't you? I mean, just previous, it's now 1:47 in the morning on this video. Kevin had already said he had a knife and I shot him. My client said there's not even an argument. I heard nothing like that. Just where is she? And so we can pull that down. And so now we have to go into the delving of other things that the state is presenting, the government is presenting to be these reasons, sort of like leaving on a jet plane. We're just going to pull it out from other lyrics and come up with ideas. Like number one, the reason that we're coming to have Matt murdered is because of this terrible custody fight. Well, there was no custody fight. The only thing about custody in this whole case is a telephone conversation that Kate had with a lawyer who said, hey, if you're in California and then you go to another state, he can file some paperwork to have you come back if you don't agree on it. And then proceed forward in a divorce case.
She testified it took 2 months
Tracey
to
has
fight
been
over
divorced 4 times.
over custody.
Has custody, has shared time. The kids have said, I saw my dad every other weekend. The sisters didn't come as much, but I did with my brother. That sounds like something I hear all over the place. But because of some big custody fight, there wasn't a custody fight. There was going to be. Let's not confuse ourselves, right? There's going to be a custody fight. I don't think they're going to last in this marriage, to be honest. If Kate and him drove back to California, maybe they'd give it a try. But I honestly think, personally me, her substance use, smoking weed all the time, being high all the time, Matt's trying to get off alcohol and Buddy's alcohol problem, they're just such a volatile relationship. I just don't see it lasting if this horrible experience didn't happen. Just don't see it lasting. I see obviously a divorce coming on the horizon. I also think that's the reason they have a storage unit, that she had stuff that she left in California, knowing that at one point California is going to have to be a home plate somewhere in relation to the divorce of the kids. So some ruse of this being a big custody fight, it's not a big custody fight. Frankly, we all know where most kids go in custody fights anyway, don't we? Goes with mom. Dads get the weekends and holidays. Matt's not working. Mom's working for an Airbnb sort of as a side hustle job. But the divorce just isn't a custody fight. It's the preliminary. You know what you have when you do a divorce? You have a conversation to talk about the stuff and the kids. That's what you do. The real estate, the TVs if you care, the DVRs if you care, and anything of value if you care. And then the personal things. You always talk about those. Because there are some things that are personal, you know. My mom's ring and my dad's ring and those things. But the big plan, this is it. My client is referred to as the hub, right? And the kids are the spokes. And she's the conspirator trying to get all of them to be included. I don't think that's what you heard at all. We heard in the closing that they had time to stage the scene. Well, that's a pretty terrible staging of the scene to say that no one's arguing, no one's fighting, and all we have is gunshots. And the question was the final straw in the battle between Mom and Matt. Mom being Tracey. They had a Disney battle because Matt, and the exhibit's there for you to see, Matt was going to decline the Disney trip, and because he declined the Disney trip, the two little kids aren't coming either. Well, guess what? They went to Disney. And they had a fun time. And it was a good time. Oh, there was an incident that Tara Lynn saw where Matt was abusive towards his kids. But over the time of the Disney, everyone had testified it was good. Everyone got along. Now, before that, Matt was very angry at Tracey. And he didn't want to go to Disneyland. And then later, in May, Matt and Tracey got into it again. As Tracey testifies, she testifies that I talked to Matt about coming to Utah with Kate and the kids. Matt did not like that idea. We needed the money to stay in California. Kate needed to work. I guess Matt was trying to work. I don't know. It just seemed like that volatile relationship, right? And then the text where Kate says, hey, Matt said it's okay if you come here. So the scenario of that is all pretty simple. Tracey had a friend, Amy, whose husband died. She was an invalid in a lot of ways. All of her kids knew this person. She'd known him for 38 years. Tara Lynn had been there. Kate had been there. People had been there to Amy's house. And my client flew in. On the way to flying in, and you look at the text, look at the times. I'm getting on the plane early in the morning. A little bit later, after she said I'm getting on the plane, Kate texts, Matt said it's okay, you can come over to the house. And my client spent the night at the house. So this, once again, plan of, Disney, she wants to kill him and strangle him, and then in April or May, she goes and spends the night at the house. And spends time with Matt. This relationship, torn apart a little bit, patched up a little bit, sounds like family, doesn't it? And it happens. It doesn't resort to a murder. But it happens. And so Matt said, yeah, I'd come to the house. And so she did. She spent time at the house. Then had the conversation with him. And then he accused Kate. Let me get this right. He was mad because there was a conversation about Kate spending too much time in the smoke truck, in the smoke camp. And Tracey says, he's lying. That's not what I talked to him about. I talked to him about going to Utah, which is probably not what Matt wanted Kate to hear. So I had to give it a reason why he's ticked off at Tracey. But is that surprising? I mean, if you think about Rachel had said, we'd always had a confrontational family life between Matt and Kate and us. Terrell, the same thing. We've always had a confrontational family life with Matt and Kate and us. Even Tim, I had to be the peacemaker because Matt and Kate and us. It's a common theme. Everyone knew. It was just a hard marriage. And that video that we showed of those two just battling about the stupidest thing. It was very normal for them. And the whole family knew. But they got over it. Indeed, they got over it enough that they're going to go to Las Vegas, Matt and Kate, go with Diane, Matt's mom, and spend some time in Vegas, but then that got canceled. And it got canceled because they just weren't getting along. And Diane probably just didn't want to be around that volatile relationship. And frankly, it seemed obvious Kate was ready to call it. Kate was ready to go. Shortly thereafter, Kate did go. And that was a big plan. It was a big plan. It was a plan to go and murder him. No, it wasn't. It was a plan for Kate to go and talk about how am I going to get this divorce thing figured out. Indeed, in June, after Kate got there, you saw a text today where my client sent to Tara, can you talk to her about talking to a lawyer? I think the day was June 29th. He's talked to her about talking to a lawyer and what she should say to a lawyer. I think the reality is I'm not going to trust Tracey to have much conversation with a lawyer, to be honest. She smokes weed, she's high all the time, she's volatile, she's all over the place. You saw her in the stand. Tara Lynn seems to have a much more demeanor about herself to be able to handle a good conversation. So is it uncommon when these guys talk every day anyway to say, hey, you talk to her about having a lawyer? Yet that gets construed so that the narrative of the prosecution can imply that this is a big plan. So you can follow that narrative to make sure the narrative is followed. And the narrative is followed so much to the point that it becomes unbearable. Unbearable for Kate. She realizes with all of this narrative and all of these scenes whacked into a big web where all these colors are pointing to her. You can just imagine when it's pointing to Kate, all the colors in this spreadsheet are all red. Look, Kate, you. Look, Kate, you. Look, Kate, you. You're red, you're red, you're red, you're red. Look what you did. And Kate needed to make a deal because she was afraid of this big environment coming after her. with all of these prosecutors and all of their equipment at their disposal, sometimes it just gets overwhelming and you need to cut your loss. And Kate did. I had a blow-up moment in this trial where I couldn't believe Kate was saying the amount of sentencing time she was saying. If we can pull up the matrix, which I think is defense exhibit number 2, at the matrix.
Are you talking the Reloaded or the original? I think it's Reloaded. Tell us more about how divorce court works, though, sir. You had me at that point.
So I lost my stuff for a minute, and I had to ask for a break, and I had to leave the room.
Which time?
I had to go get my stuff so that I could really, honestly, help Kate be honest. Because at the bottom of this box, it shows 108 months. You could show the bottom of that box. For her life, she wouldn't agree to that. No, it's not 108 months. It's for life. No. If you look on the left side, aggravated murder, 300 months, category 1, then first degree murder, 240 months. We all know what Kate was charged with. She was charged with first degree murder, and she ended with a deal of second degree death, second degree murder. 10 years off of her sentence. But there was a caveat. And the caveat for her to get 10 years, because Kate's 40, for her to get 10 years, is she had to tell the truth to the prosecution. That was a caveat. She had to tell them their story. And so as part of that, she came up with her proffer of evidence letter. And that's an exhibit too. In that proffer of evidence, she talks about never talked to Kevin, never did this, never did that, but yet we had a plan. It was just nonsense. Indeed, not only did she have to have a proffer, which her attorney provided for her, but she also had to give an interview. And when she gave the interview, it didn't go well. And the reason it didn't go well is because police told her, you need to be honest. And I asked her that. But you had to do something with the plan for him to come to the house. Right. So you knew that, correct? Yes. I want to hear it. Yes. Boy. I made sure he would come inside the house. Yes. Was that part of the plan? Yes. So even in an interview where she's there to tell the truth and give justice for Matt and give justice for her kids, the officer says, I want to hear it. Well, why do you want to hear it if she's saying it? It's because she's making up whatever plan you're telling her to make up. And she'll agree with it. Because she wants the 108 months. She doesn't want the 240 months. She's willing to do that. It's unrefuted. Unrefuted evidence that she said that the officer said that. I want to hear it. And then, of course, at the end, it said, the plan isn't on, right? It's the officer. And she says, I feel like it was 50-50. She was just willing to say what she needed to say. She felt overwhelmed by what was presented against her. By a team of lawyers, by a team of law enforcement, by texts. She was overwhelmed with it. And she had to take the deal. She wanted to get out and live. And she wanted the 108 months. Well, she declined it for a time until we took the break, and then I came back and I said, didn't you say that you were getting this deal for 108 months, and then she talked about, well, I'm in prison now, and things are different now.
It's gone 40 minutes.
These jury instructions don't get printed and figured out overnight. These jury instructions I've seen many, many times in my career because they're sort of standard. They're standard in a lot of ways according to the case. Some are case specific, like what is the charge. But most of these instructions are over years, and decades, and centuries of instructions to juries to get refined to what we have before us here. Some of these instructions I would ask that you look at with close attention. Instruction number 10 is the reasonable doubt instruction. And just for a very quick, I know time's going on, very quick evidence. Evidence has to be decided based on a certain standard. And there's many different standards depending on what kind of case you have. A lot of people don't really realize this, but being a lawyer, I've been trained and I went to school and I figured it out. In criminal cases, it is required that the evidence be proven beyond a reasonable doubt. In America, with TVs, we've heard of that many, many times. But there are many cases that do not require proof beyond a reasonable doubt. But in criminal cases, we want the highest level of proof possible to ensure justice is served. Because if we don't get it right as a community, as a people, the harm of getting that wrong is extreme. But there are other evidences. And so going down the tier is usually, you have to have clear and convincing evidence if you want to have your kids be, or not have, but if the state wants to have the kids be taken away in shelter and provided foster care for some time. You don't need beyond a reasonable doubt, but you need clear and convincing evidence. And then if you get in a car accident, you break your leg, and you want to sue the guy for driving inappropriately, you have to prove by preponderance of the evidence. And preponderance is sort of like a little bit more than 50%, you know. You just need to prove your case better than they prove their case. And then if you want, if you have some other law enforcement things like a search warrants or things like that, you need probable cause. It's less than preponderance, it's less than clear and convincing, and it's all less than the highest standard of beyond a reasonable doubt. In this, it says, the second sentence, it says, there are very few things in the world that we know with absolute certainty. I always wonder about that. You know, I know the lights are on. I know my car's out there. But this instruction says we know very little things, very few things with certainty. Okay. In a criminal case, the law does not require proof that overcomes every possible doubt. Then at the very end it says, on the other hand, instruction 10, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt. And that's reasonable doubt. That's beyond a reasonable doubt. If there is a possibility, that benefit must go to the defendant. Instruction 8 is about witness credibility. Witness credibility is a very common witness instruction or jury instruction that most people I talk to are not aware of this, but in summary, it says this: you as a jury are to decide a witness's credibility, whether they are believable or not believable. It's not our job, it's not the judge's job, it's not anyone's job but you, and that's your job as you go and deliberate as a jury. In this instruction, it does say that if you find that someone has lied, and this is the second last paragraph, you may believe part and disbelieve the rest. You may believe nothing they're saying if you think they have lied. In other words, you may believe all, part, or none of a witness's testimony. And I know a lot of this case is involving Kate, because she's a co-conspirator, according to the state. I think the testimony of Kate was so full of lies, it discredits all of her testimony. And I'll give my reason for that on one very simple question I asked.
Whoa.
did you love Matt? She couldn't even say yes to that, even in the beginning of the relationship, because she was planting in her mind she needed to hold that 108 months. She needed to support the state's position. She couldn't even answer a simple, then why are you dating the guy if you don't love him? Why are you having a baby with the guy if you don't love him? I'm not talking about during June and July of 2024, and I'm specific. Did you ever? And she could never just say, I love Matt. Of course she loved Matt at one time. They spent years and years together. Volatile at times, I get. But there's just a time when it's what we call the softball, you know. They'll throw you a softball pitch so you can hit a home run. Even the softball she couldn't hit out of the park. She's just so filled with the need to support her position because of all the things that were built up against her. And she did not want to mess that up. She had to make sure. And in the end of her testimony, she basically lied about almost everything. Almost everything. And I asked her time after time after time, isn't it true that you said this? And isn't it true that you said that? And time after time, she would disagree. And then time after time, she just started to say, I lied about that. I lied about that. So at the beginning of your testimony, you say, I'm going to meet with the law enforcement and the prosecutor to be truthful. And then at the end of your testimony, you're saying, yeah, I'm lying about the whole thing. On the other hand, there are some things that are irrefutable. My client spoke to police the night of the event. Irrefutable. You can't dispute it. Unless someone wants to say that was AI who developed it, no one's going to say that. She did. She voluntarily. You have the right to remain silent. Do you want to remain silent? No. Do you have a right to have a lawyer? Do you want to have a lawyer? No, I don't care. Send the lawyer to Kevin. What do you know? What do you remember? She's trying her best to know and remember. And she says, I didn't hear anything. I mean, after he spoke to me, I didn't hear anything. In her testimony here, we had her testimony. She said, I expected Kate to come down when he got here. Now, one thing that some of these texts and exhibits that you saw in the closing was all this communication day of, and how they're finalizing their great plan of murder. But we all know that Tracey wasn't in American Fork. Indeed, Tracey was in Salt Lake at work when she got a text saying he's coming to Utah. It didn't say, we need to get ready. It didn't say anything like that. It just says he's coming to Utah. Do you know why that was an important thing? Because no one thought he was coming to Utah before that. Everyone thought there was a different idea. A car rental, I'll fake an injury so I don't have to come. I can't do the car rental. He's not going to come to Utah in the truck. His neighbor's not going to give him a car to do it. He doesn't even have a license on his truck to come to Utah. But the way it's presented and slighted is just not common sense. The truth is that no one thought he was going to come to Utah until he finally says, I'm coming to Utah. Should I come with the starter busted, or should I get the starter? Should I put a new starter in? Do you remember that part in the phone call? He said, I have the starter. The starter should be good and take me time. And so he doesn't leave California until like noontime. And he has to drive from Temecula all the way to American Fork, beginning at noon. I mean, it can be done, and it was done, right? He did it. I've almost done that. You know, it can be done, but man, I usually want to leave earlier in the day. He had nothing going on. I guess he had to take care of the dogs or take care of the truck or those things, but there's no plan for him to come to Utah. There's no plan for him to come to Utah and let's murder him today. Although, in the closing, we hear about it all being a huge plan. There is no plan. The plan was simple. Kate, you need to get off your ideas and just figure out what you're going to do with Matt. Because you're in my master bedroom, you're taking your space away from me, you need to have some finalization. Love ya. But there has to be something done. Because it's not working the way it's working. That's reasonable. Witness credibility. I always like to say closing arguments because I just want you to know that everything I say is not evidence. It's just argument. Even though it might sound like evidence, it's not. It's just argument. And the prosecutors is just argument as well. My client chose to testify. She chose to tell you what she wanted to. She didn't have to. She could invoke her Fifth Amendment right and not say anything. And I could have said, ladies and gentlemen of the jury, my client chose not to testify. However, she did testify. She testified when she spoke to those police officers. And here's what she will say about that. Could have always done that. But she wanted to tell you the truth. She wanted to tell you, I have a confrontational relationship with Matt. But sometimes it's not. I love my kids, and Matt's part of the family. We all got a t-shirt. And the truth is that we do have confrontations. And the truth is, yeah, I said, I want to strangle him. He's going to cancel the Disney trip. And then I want to kill him for lying about saying that I'm mad about her being in the pot house or the pot camp or whatever it's called. She said, I never said that. I said to him that, hey, be good if Kate came to Utah in the summer and spent some time with the grandkids and the other cousins, which he did not like. I could go on and on about the lies that Kate provided in not only her testimony with us, but also her testimony in the other case and also her interview testimony with the officers on June 16th. I could go on and on about that. But I think that's very clear that her just testimony was filled with fear, non-truth, defeated her own alleged purpose for coming forward of truth and justice, and really falls in the face of fear that she's going to spend a lot more time in prison. Instruction 13 is mental state. In the third paragraph it says, for each offense the law defines what kind of mental state, intentional and knowingly. And in this case, that's required as well. Sorry.
You are at 53 minutes. So.
In instruction 28, it's titled Mental States Defined. And this gives really some good instruction. A person acts intentionally when they engage in certain conduct or causes a certain result. Well, I know someone who engaged in certain conduct, and it was Kevin Ellis. Kevin Ellis grabbed a gun and he shot an unarmed man that he said had a knife. And he shot him 7 times.
Oh, unarmed? You're conceding unarmed?
As a result of his death.
Are you admitting that...
A person acts knowingly if he is aware of the conduct, aware of the particular surroundings, aware that the conduct is reasonably certain to cause a result. My client testified, to be truthful to you, that she was not aware of that conduct, that she was not aware Kevin was intending to get a gun and kill Matt. Indeed, she was hoping that Kate would be coming down soon to greet Matt because she wasn't exactly sure when he was getting there, but he's going to be there soon. And the inference of that intent. The elements of the crime are then provided in instructions.
He just said that Kevin shot an unarmed man. But his client said he had a knife. That means his client must be lying.
Instruction 31. This is the instruction of the elements of murder. That Tracey intentionally and knowingly caused the death of Matt Rastelli. It is surprising to me in this case how people are minimizing the actions of Kevin Ellis. He shot a man.
That's because he had his
He
own
was
case.
high on cocaine.
He was found guilty.
He made lies. And it seems to be minimized in this. In fact, I'll get to that in a minute. Instruction 34 is conspiracy. Conspiracy is if Tracey Grist intended that conduct constituting the crime of murder be performed and agreed with one or more persons to engage in the cause of performance of conduct. The state would have you believe that this is a long-time plan. This is a long-time plan for certain decided well before July 12th, well before July 11th, and that the whole plan on Kate coming to Utah was to murder Matt. That is not what the unrefuted facts show. Indeed, if that were, this is the messiest murder I can think of, murder plan, where my client says, no, he didn't have anything. I didn't even hear a fight. When I saw him, he didn't have a knife in his hand. When I saw him later when he was dead, I did. But when he said, hey, I didn't see a knife in his hand. Why would she say that? Why don't you just say, yeah, he came in agitated, had a knife in his hand, he threatened me. Well, the word agitated is a little interesting. I just drove 10 hours, and I pull up to the front yard, and my wife's there with my kids who I haven't seen in 3 weeks, and she ain't there to greet me. The heck. I'd probably be agitated if I walked into, like, well, Kate, I mean, you know I'm here. So for my client just to volunteer, just off the cuff, he seemed agitated. Didn't say angry, mad, just seemed off. She did say he didn't have a knife. Did not have a knife. That's because she's helping the plan, helping the conspiracy. And the obstruction. The obstruction that she planted the knife. Her testimony is when I first saw the body, I looked at it. I don't remember what its real visual was. I went upstairs. I knew Kevin had shot him. Kevin said he had a knife. Went upstairs and said, Kate, don't come down, don't come down. Came downstairs, had to find my phone, called 911. There's a confusion about 911, frankly, because they used the name Caitlin. And are you Caitlin or something like that? And my client was confused on the 911 call because there's Katie and there's Caitlin, and Caitlin had already called. It is confusing. But on the obstruction that she planted the knife or lied to the 911 call. Her testimony was Kevin said he had a knife. She didn't say he had a knife, Kevin. No, she said he didn't have a knife. And then when she went over to where the body was, Kevin said he had a knife. And she's relaying that to 911. That all of a sudden comes up to another charge the state can charge against you, right? Well, there's another one. Obstruction. There's another one. Unless you follow our guidelines of a plea. Unless you agree to plead to murder, and conspiracy, and discharge of a firearm for Kate. On the elements of murder, that you intentionally and knowingly caused the death of Matthew Stiller. And there is someone who did that. It's Kevin. And there's an audio between Kevin and Tara Lynn. And he says, I have something I need to tell you. I talked to her. And Tara Lynn is just, oh wow, that's so hard. That's so hard on you. I don't know about you guys, but murder is the last thing in my mind. If I'm mad at someone, that's the last thing in my mind. And I don't know that I'm saying to a person who's been in jail for like almost 2 years, that's so hard for you. I think more of the question I'd be saying is, why'd you shoot him 7 times? What happened? None of that was talked about in that tape. I had the gun, he had the knife, he came at me. None of that. I was on cocaine. She doesn't even say to him, you use cocaine? When did he start using cocaine? None of that conversation was talked about. She said on the stand, I didn't know he used cocaine. Rachel said on the stand, I didn't know he used cocaine. Tracey got on the stand, I didn't know he used cocaine. No one knew he used cocaine. They're all very surprised. Kate said, I didn't know he used cocaine. I know he didn't like weed. None of that kind of conversation took place between Terrell and him, but he was offering this information to her. And I suppose that he's offering this information to her for one reason. And it's something I know because I'm in this world of the criminal justice system. And that is, jail is hard. When you go to jail, you have one thing, and that is called time. You are doing time all day. When you sleep, you get to sleep. And when you wake up, you're doing time. And you have these little respites while you're serving your time to have phone calls. They're all recorded. Sometimes you get letters, but it's mainly phone calls. And as you have these phone calls, you can establish relationships with people and confirm relationships with people and reestablish and make sure those relationships are positive, because frankly, those are the only positive relationships you have in prison and jail. The relationships in jail and prison are scary. It's a scary place. It's where hard people live.
Is he warning his client
and
now?
to establish those relationships and to try and garner some good relationships that you can do with one another on the phone is hugely valuable. And Kevin wanted to provide his sister a continuation of that relationship so that she'd take his calls, that she'd be available, so that she can just talk to him, so that he can have a reprieve from the jail and prison where he is. Because it's hard. I'm not saying it's not supposed to be hard, because it is supposed to be hard. But the truth is, it is hard. And it's hard because that's what you want. You want to lock people up so they don't have the opportunities to hurt. But he never accepts real responsibility except, I should have said no. I should have this. I should have that. And then Tara Lynn says, that's so wild while you gave an opinion. I should have given Mom that opinion. With Rachel, we would have given our opinion. And I'm listening to this thinking, what are you talking about? An opinion about a plan to kill someone? Is that how you're talking to this guy? I mean, come on. If I'm having that conversation with anyone, whether it's my firstborn or my neighbor 16 blocks away, I'm not saying those kind of things about the idea of murder. I could have had a different opinion. A different opinion? She felt sorry for him. She felt sorry that he was convicted. She felt sorry that he's going through his hard time. Because he is. Because he killed a man. Because he killed a man while he was high on cocaine. Because that's what happened. There's plenty of talk of harm. I'm going to strangle him. I'm going to kill him. I'm mad at him. Got my tortillas wet. There's plenty of talk about harm and anger and volatility. But there was no plan to kill Matt. The plan for Matt was to come and have a conversation with Kate, and she was intimidated by the whole process because her name on their spreadsheets was red, 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 red. You're going to do a lifer. And you know what? We'll give you 108. And you've already done 2. No, that's wrong. 108 months, you've already done 2 years. We'll give you that. But you need to give us what the plan is. And what she said, as a 50-50. That certainly doesn't seem like a plan to me. That seems like you just don't know until a dude on coke decides to grab a gun and kill a man. I would ask that you find Tracey Grist not guilty. The state has not proven this case. What they've done is they've created a huge web to to try and create a narrative that they got some people to follow. It's just not what is the truth.
Thank you, Mr. Faystar.
1 hour, 5 minutes, and
Mr. Pomeroy up here for me.
20 seconds. Judge calls a little sidebar, looks at the clock, says it's 12:12. How much rebuttal do you need? State does have the right to go last if they choose. They could waive it if they want. Haven't seen that done
All right,
very
ladies
often.
and gentlemen, I know we've been going 3 hours. Mr. Pomeroy just confirmed to me he's going to be under 10 minutes, and then we'll do our recess and we'll start the deliberations. We will have
10 minutes. That's all I need.
We are ordering in lunch for you. So
Oh, good.
We will have food.
Can you tell us what we're having, Judge?
Mr. Pomeroy, rebuttal.
Yes, Your Honor, we're just putting up one exhibit and I'll be ready.
Thank you.
Wait for your exhibit. This counts against your time, by the way.
You plugged in?
If you try turning it off and on again, it's just slow.
Make it full screen.
Make it big. And biggin. There's the victim.
That works. That works. Thank you.
On the picture from his wedding day with Kate.
So this is Matthew Rastelli. It's pretty obvious what he's doing in this photo. It's a wedding photo. This was Matthew at one of his best times in his life. Matthew was a husband, father to 3 children, son to Diane. Unfortunately, in this trial, you also saw Matthew at his worst. But what Matthew was at his worst is what earned him the nickname Olaf. The talkative, friendly, yet obnoxious snowman from a Disney movie. No one feared Matthew, not really. They made fun of him. They didn't fear him enough to be that worried when he was coming up. None of the family who wasn't in the home and part of the conspiracy thought to call the police. No one checked up on him after he got there for a long time. So why is it that Matthew Rastelli ended up dead? Reasonable doubt is the standard you have to apply to answer that question. The thing about reasonable doubt, it's not imaginary doubt. You can't just say a whole bunch of stuff and distract from the evidence. You have to base it in the evidence. If you have doubt, it must be grounded in that evidence. But when you look at that evidence, you don't see reasonable doubt here. There's a lot talked about the plan. See, never said it was a long-term plan. There was a lot of stuff that built up to that pivotal moment when there was a plan. There was a lot of bad blood, so to speak, that built up until Kevin was willing to shoot Matthew. A lot of bad blood that built up, things that happened until Tracey had had enough of that annoyance she called her son-in-law. It was called the messy plan. Quite frankly, looked pretty good. Utah, shoot, intruder. He had a knife. No one was home. Problem was the neighbor who called 911 too soon. Everything went haywire after that, and the plan fell apart. Not for that, we might not be sitting here today. So when we call it a messy plan, it doesn't mean it wasn't a plan. When we call it a failed plan, in the cover-up sense, it doesn't mean it wasn't a plan. And it doesn't even mean that we're saying that the entire family knew about this plan. That's not at all what we've said in this case. What we've said is that everything that got shared in the family was shared among the entire family, and that Tracey knows to say what to say to get the reaction she wants from her children. And that's what happened here. Without Tracey, this doesn't happen. Without Tracey, Kate didn't lure Matt to Utah. Without Tracey, Kevin is not lying in wait. Without Tracey, Tim would have been there to keep the peace. Without Tracey, Rory and Jake would have been home. Without Tracey, there would have been no gun. Without Tracey, there would have been no knife. Without Tracey, Matthew Rastelli is alive. And to acknowledge this does not minimize Kevin or Kate's involvement in any way. You know, you want to talk about the cocaine? Fine, we can talk about the cocaine. Isn't it a reasonable inference that Kevin did cocaine so he had the nerves to do what his mother asked him? There's a jury instruction that hasn't been looked at too much. Instruction 24.
5 minutes.
There has been evidence to suggest that persons other than the defendant may have been involved in the crime for which the defendant is on trial. Your duty in this case is to decide only whether the prosecution has proven beyond a reasonable doubt the guilt of the defendant who is on trial. Kate pled guilty. Kevin was convicted. Your only duty to ask Tracey was tied to this murder. And Tracey was tied to this murder. The plan went to hell. The plan didn't work. And Kevin was mad at her. Exhibit 131. Please tell Kevin that if he is mad at me and doesn't want to talk to me, he doesn't have to. I'm mad at me too. The defense said this is a case about a man who came to be with his family. There's truth in that. This case is also about control. Tracey's control over her daughter, Kate. Tracey's control over her son, Kevin. And Tracey's control over her entire family. And ultimately, her control over whether Matthew Rastelli lived or died. The evidence in this case shows how she used that control. The law in this case tells you what that means. And your verdict should reflect both. Thank you.
Thank you, Mr. Pomeroy. Ladies and gentlemen of the jury,
you only use
we're
6.5
almost ready
minutes.
for you to start your deliberations. There are a few housekeeping matters I need to go over with you first off. As you all know, the jury notice that was sent out to you stated this is scheduled to be 3 weeks. It's not been 3 weeks. The attorneys tell the court how long it's going to be, and I scheduled the time for them. They were more efficient than they anticipated. But because we had a 3-week trial scheduled, it's not uncommon. In fact, it's prudent for us to select what are called alternate jurors. Indeed, about 2 months ago, I had another multi-week jury trial scheduled, and partway through that trial, we lost a juror. But for having an alternate juror, we would have had to start the trial over again. So it's very prudent to keep the case moving forward. It's a prudent use of judicial resources, which means it's a prudent use of your taxpayer resources. We selected 2 of you to be alternate jurors in this case just because of the length of the case. The 2 of you that I'm going to identify in a moment or two, your jury duty service is not over, even though I'll be excused you to go home, grab your belongings and go home. Because the jury is still working, there still is, although probably remote, there still is an opportunity or a chance that one of them may have an emergency at home. Say, I have 5 kids. I remember getting a call from my wife one day, and one of our children had fallen off the bicycle and broke his arm, and she was on the way to the hospital with him. I don't want to jinx any of you with young children, but if that were to happen, we would, of course, excuse you to go to the hospital and check out, make sure your child's doing well. And that what would happen then is that we would call the next alternate juror in line to come back to the courthouse, and they would start deliberations with you so that we wouldn't have to retry the case over. So for our 2 alternate jurors, the admonition order about forming an opinion about the case, talking about the case, researching the case, using social media, that is still in play, and that order is still there until we call you when the jury has reached their decision, or if we need you to come down. Now, before you leave, I'll ask you to give to my bailiff your cell phone numbers, and we'll call you one way or another unless it's late. If it's late, we'll call you the following morning, but we'll call and let you know what the jury's verdict was or is going to be as a courtesy to you. And once you receive that phone call, then my order to the 2 alternates, or 1 if we need to bring you in, or none if we bring you all in, will go away at that point. And then you'll have the freedom to talk about the case, do research, or just move along.
Did say we'll tell you what the verdict is going to be?
But the 2 alternate jurors that were selected randomly, this isn't something I do or the attorneys do.
Let's do numbers or I have to mute.
Assistant that does it. Is juror number 40, Mr. Ballard.
Nice.
And juror number 41, Ms. You can raise your hand. So you 2 are our alternates. Please make sure that you give to my bailiff your phone numbers, and with your names, of course. We'll call you if we need you, or we'll call you, as I mentioned, once we have a final verdict. Please take my order about not talking about this case seriously. And please also do not feel like your time is wasted, that you just spent 7 days doing nothing and now you're going back and wondering what that was all about. If you think about how many days we've spent and how many witnesses you've seen, and you've seen how much time and energy the attorneys have put into this, it's an extremely complex and expensive proposition to try a case. If we had to do it again, it would be several months out before my calendar would accommodate this length of a trial. And because of judicial resources and taxpayer resources, we try and be efficient in that time frame. So your service was valuable, is valuable. The advantage is that you don't have to complete the jury deliberations, and more importantly, you're done for state jury selection for the next 2-3 years in Utah County. However, if you move out of the county, the clock starts all over again and you can be selected. So if you move up to Salt Lake or down to Juab, you get that notice, you start all over again. Of course, federal court is a separate sovereign, and they can call you in regardless of your service. And if you have a justice court in your city, you may be called in for that justice court. With that in mind, that is the process. And so you 2, you can grab your belongings, say goodbye, don't talk about the case, and then give the information to my bailiff and we'll escort you out. The other 8 of you, we've got pizza, is that correct?
Ooh,
we've got pizza
Little
ordered
Caesars,
in. It should
cheese
be here
only.
shortly if it isn't here already. You take your instructions back in with you. The attorneys and my staff will put together the exhibits. It'll take a little bit of time, but we will get those back to you. Electronic exhibits will be brought back on a neutralized laptop so you can look at those as well. With that in mind, if you'll swear in our deputy, please.
I think we could start deliberating
I
at
solemnly
lunch.
swear that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them, no do so yourself, unless ordered by the court, and return them into court when they have reached the verdict. So help you God.
I did. Thank you. All right, deputy, if you'll take the jury out, please.
All rise.
I guess we're starting our deliberations right now. We'll get a clock started on this one. Has a jury ever acquitted after pizza? No, it's always guilty on pizza. Unless it's Hawaiian pineapple.
Thank you. Please be seated. Thank you, counsel. Appreciate the 4 of you and how you tried the case. It's very professional. I watch as I'm listening. I hear you use your first names. It shows me how professionally you're working with each other, that you're not fighting even when you have disagreements. This would be a good case for young law students to study on how to get along and work and try a case. For instance, the state's paralegal was doing all the exhibits for Mr. Facemeyer. That just once again shows the professionalism for both teams. So thank you so much.
Well,
anything from the state we need to put on the record?
No, Your Honor.
Anything from the defense?
No, Your Honor.
Thank you. Once again, well done. If you would, counsel, come up and meet with Faye briefly to make sure that we have all the exhibits organized and put together. Also leave with us your best cell phone number and make sure you're no more than 15, 20 minutes out.
Not the burner
If
phone.
I do have a question from the jury and you're out and you're at your office, Mr. Facemeyer, is your office in Provo?
Freedom.
Freedom? All right. We may just call you on the phone and get permission on the record that way, or if it's more complex, I may ask you to pop in. That in mind, then, thank you so much, counsel. We'll be in recess.
This judge does things a little differently. With that, we are in verdict watch. Let me update the title here. Wow. We are in verdict watch. Can't you just zoom in? Yeah. Let's do a poll. Let's do a poll. How long will the jury deliberate? Right. That's what we do right now. Some interesting observations I made here. First of all, it surprised me that the state in their closing was dropping what I will refer to as unnecessary F-bombs. They were not quoted out of context. They were added as an expletive or used as like to sum up a situation. It was not the wording that we heard during the trial. That surprises me because Utah specifically, we're talking about Utah County in Utah, is one of the most conservative. And I'm talking, morally, religiously, you name it, politically, conservative areas in the nation. And swearing like that, dropping the F-bomb, is not normal in that area. So, yeah, it would be a potty mouth situation. And so for him to do that in the closing, it surprised me. Another thing surprised me, and this goes back to the video that the defense showed of Tracey in the police station. She shows up and she's, "Oh, hi, I don't know what to say. What do you want to know? Well, ask me questions." She's just whispering this timid, slow movements of her hands as she slowly sets them down. I'm just in shock is what I am. I'm in shock. And then her friend, the lawyer, shows up. Sorry, I'm working on the poll. Her friend, the lawyer, shows up. The lawyer knows her. And she becomes a different person. She becomes a different person. The timid, I just don't know. It may have worked for the officer. He didn't know who she was. But she's somebody else for the lawyer. She's somebody else for the lawyer. Okay, give me a second. Let me get this poll. How long will the jury deliberate? We're going to start with the shortest time first, and we're going to say that this is going to be, let's see, it's 2 o'clock now. That means it's noon. I'm going to do, let's do less than 2 hours. That's really short. Under 2 hours is the shortest. 2 to 4 hours. That pretty much takes us to the end of today. Sleep on it. That's going to be tomorrow morning. And the last one would be there we go. So we're going to start the poll. How long will the jury deliberate? How do I spell deliberate? Deliberate. I think that's right. All right, the poll is up, and it goes like this. How long will the jury deliberate? Question number answer 1 is under 2 hours. Answer 2 is 2 to 4 hours. Answer 3 is to sleep on it. That means following morning. And answer 4 is I could use another lunch, which means they'll be here a while, and this won't be the last lunch they eat at the judge's expense. So let's also need to account for pizza time. Pizza's going to be brought in, but I think they're going to work through it. I vote for lunch. Voted sleep on it, and I'm always wrong. I'm sorry, but I'm not beyond reasonable doubt on her guilt. That's okay. That's okay. I could use a first lunch, says Red Pen, as a hint. People need to gather over swear words, in my opinion. Otherwise, we talking like YouTube wants us to. I think we're missing a word. I think people need to get over swear words, in my opinion. Otherwise, we'll be talking like YouTube wants to. I choose not to use them. It's rare you'll catch me using one. I think excessive use of swearing shows a limited vocabulary. It doesn't mean that just because you swear you don't have a good vocabulary. I'm just saying excessive use does. And I think there are other words that sometimes are better descriptors than that. Everyone talks when eating pizza. Tracey didn't want her screen Velcro curtain ruined by bloody murder. Yeah, don't put holes in my screen, then the bugs can come in.
If you could just use your words.
Use your words. Thank you. Use your words. Who said that? Teresa. It's punctuation. Yes. Yes, but I sprinkle a little bit of the F word in for flavor. This is Legally Blonde. I know, like 4 words. Can we go over the counts again? Yes, that's a great.
Remember in the beginning
that's a great one.
when we
Carolyn.
started 110 years ago?
I do remember that. Let me turn those down so it doesn't interrupt. The counts are as follows. This is what she's charged with. First of all, murder. Second, conspiracy to commit murder. Third is obstruction of justice, and with that, they have to find whether she was party to planning. She made an untruthful statement to the police. And 4 and 5 are identical charges, and they are commission of a domestic violence in the presence of a child, because there were 2 children there in the home. And then there's a special verdict form about cohabitation, which impacts verdict or charge 1, 2, 4, and 5, and the jury has to determine whether Tracey and Matthew were cohabitants at the time. And I think with a stipulation in place, the answer is going to be yes. Because there is a stipulation.
When are we going to break for lunch, Judge?
I've been cussing a lot less since I was unbanned. That's good. I like it. I appreciate that because we do have, not all of our audience talks in chat, but we do have individuals, even students, who in a homeschool setting use watching court on our show as an educational means to understand how the court system operates at a local level and a state level, how the judicial system works. And I like to be able to tell them we've got, we're about as family friendly as murder can get here. And it's awesome to be able to have that for them. I like that young people get interested in the court system and in true crime in general through this. All right. I'd rather you be interested in true crime than going out and doing crime. I have pearls just for clutching. These are my clutching pearls. Yeah, that's what I meant. I'm not dissing people who don't swear, just expressive words. It's a trial, right? However, I swear a lot, so I meant desensitized. I appreciate it, misconduct. Thank you very much. I get what you were saying there. I just think that in that particular environment, it seemed odd. Both because I know the area and I have a good understanding of what's. I've spent a lot of time in Utah County, done a lot of fishing down there, done a lot of everything from political work, work. Been down there for a family that schooling, all sorts of things. I'm very, very familiar with the area, and but also on a legal front. You saw in court, I think it was even there during this trial, a witness was on the stand. It's like, can I say the word? Can I swear in court? And there's that question because in court is a proper setting, right? It's a professional setting. It's a respected setting, and so there's an expectation of we're held to a higher standard here. And he added words that hadn't been used in the text messages. And it's like, that was, that part. He was quoting her, but it wasn't in the text messages. He was reading the quotes. He was reading the text messages. That wasn't in there. All right. Let's see. We do have a timer going. Give me a second to get that built and put on screen. What's this? Don't need that one. All right. Let's go to our super source and turn on a couple layers for you. Box 2 is going to be cam 3. Does that work? It's there, but it's not in the right spot. We'll move it around. Lift it up a teensy bit, not that far. Need to make it a ton bigger, like so. Need to get rid of the milliseconds off the end, and chop down the edges. Okay, there's our timer. They've only been deliberating for about 12 minutes. Once this hits an hour, we'll adjust this so it'll all fit on the screen again. How would you rate both closings? Defense was a little bit random, but honestly, that's sort of par for the course for this case for him. He's been a little bit different throughout the entire trial, and maybe that's to keep them on their toes and keep people, guessing as to what comes next. It did seem a couple times, both in the prosecution, both during the case in chief of the defense as well as the defense closing, that he blended in arguments that I would expect to see in a prosecutor's closing, not a defense closing, presenting as a maybe this is the case and using the state's argument as an option. Seems like a weird one to tell the jury, as this might be true when you're trying to get them to select something else. It was a little bit weird with I didn't need to know that his wife sometimes tells him he needs to treat women better. That those conversations happen in his home. I didn't really need to know what happens in divorce court as couples are litigating over, grandma's ashes or whatever else is in the house. That seemed like he was sort of lost in the weeds a little bit while mentally preparing for another part. That part was weird, but he also, during the direct questioning of witnesses, both state's witnesses and his own client, just came off as just angry at them personally during the trial, which was strange. It didn't seem warranted. So there was a lot that was weird in this one. I'm fascinated by the disappearing comments. You have to look quick. They disappear quickly. Seems that the defense wants her to go to prison. I think he was right when he said that the prosecution seems to point the finger of blame at the family members who haven't been charged. The questioning definitely led that way or leaned that way. It seemed to insinuate that the prosecution, though not prosecuting, Tara Lynn and the other family members who are not direct, right there in this case and already with convictions, was insinuating that they were involved, or at least you could draw that conclusion and the state wouldn't be too unhappy about that. He wanted to kill Matt, right? Yeah. Crazy. Can we at least agree Kate should never have got such a sweet deal? Yeah, I wish we had a clearer picture of what the deal was, because my understanding is that the defense lawyer wants us to look at the deal and saying you went from murder 1 to second degree death, and that took you down. It took 10 years off the sentence. Yes, but the state kept the discharge of a firearm that resulted in death on the charges, didn't drop that one. That's still first degree, and that carries a life, up to life sentence. So if you focus just on murder and say, wow, you got a sweet deal. Yeah, you did, but she still could serve life on the other charge. So I wish it was a little more clear, and honestly, we won't know until the, years down the road when the parole board meets and decides what to do with her case. And they do have a ton of power in deciding, just what happens going forward, and if she gets out, and if she doesn't. Has Kate been sentenced? Yes, but it's one of those sentences that's after a certain number of years, according to the Matrix, the parole board will look at your case. She already has her tentative parole hearing date, on her calendar. She's counted down. It's like in 2036. Okay, it's way out there. But she already has that, and they could at that time release her. She could be done, and it would be serving. I think it's like 11 years or something times is what she'd have. But they could also say no, come back in another 10 years, or come back in another 20 years, or just doesn't add up. If you look at the math, you look at the Matrix, and say other people with these similar convictions got out after this time, there's a good chance that after 10 years of prison, 10 more years of prison time, she's out. That's highly likely. Nicole, you missed this trial. This is a wild one. I am finally, after 7 months, moving back into my house. I'll be attending Stacey Wandra's trial, and I'm looking forward to seeing justice for Monkey Michael Vaughn. Don't know the facts on that one, Nicole. You'll have to fill me in. And is there a feed for that? Was this a spicy trial or just ho-hum? It was spicy. Nicole, you missed out. You missed the defense attorney just going off like crazy in this trial. You missed it. Let's see. Matt's brother has the kids. Matt's brother is the one who spoke out at Kevin's sentencing and just let it rip. Just did not hold back. We'll see what happens with this one, when sentencing happens and stuff, and we might go back and watch that later. Let's see. Oh, you're in Canyon Country? Is it by College of the Canyons? Caroline Taterville? Do you know where College of the Canyons is located? Oh, Middleton, Idaho. I was thinking it was in California. Yes, he did, and it was on his own client that he went off. It was wild. She's like, "Can I speak?" "No." "Shut up. I'll tell you when you can talk." Wow. All right, Maya Docs. Yes, let's do lunch first. Can we do that? Because we're fairly confident we take lunch right now, they're not going to come back with a verdict.
I'll tell you when you can talk.
But let's take a lunch break for a little bit, and we'll come back and talk about some Maya documents. We'll do some read through of some Maya documents, as well as we keep an eye on this court as well. And we'll be good. We'll be good. We've got some great stuff to go over. Give the mods a break for sure. I have imaginary numbers in my head. I need to erase that meeting from memory. All right. Guys, we're going to lunch. Have a good one. Don't go too far. We're going to read some Maya docs. We're not going to break. We'll keep the video rolling. We'll keep it rolling. We have audio live from court. We have live court feed from our pool feed. And we'll keep it up. So what are we going to watch next? Well, there's... in a little over a week, maybe I guess it's sort of 2 weeks, there's another court case out of Ohio that's a big one that we want to follow. It should last 2-3 weeks, something like that as well. That's our next one we're trying for. There might be something in the meantime and between times, but yeah, Caleb Flynn is where we're going next. The poll, did I end the poll? Let me do that. Let me end the poll. How long will the jury deliberate? The answers come back as follows. 2 to 4 hours, 65%. Sleep on it, 20%. Under 2 hours, 12%. And I could use another lunch, just 3%. So most of us saying today or tomorrow morning. Tomorrow morning. We'll see what happens. All right, tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. Well, we'll be live all through lunch, but I'll be back after lunch, live here from the Little Man in the Corner in about an hour. We'll see you guys in a little bit. Bye. We're not going anywhere. I'm going to lunch, but I'll be back in just a minute.
stubby little pencil.
I'm not a cat.
Are we going to address subject matter jurisdiction?
Hello, hello. Hello, hello.
You don't put a diplomatic plate on a hoopty.
stubby little pencils.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Hello?
Happy birthday. You look good.
It's bigger than you. It's bigger than me. It's bigger than all of us.
In front of the Walmart.
Have them send someone with more experience.
are banished from the state of Georgia.
I saw a chicken fight.
Because he's the guy.
Hello? Hello?
Happy birthday. You look good.
Hush! Now I'm trying to have court. Don't raise your voice again.
Bring the jury.
Are we going to address subject matter jurisdiction?
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm going to sustain my own objection. Remember in the beginning when we started 110 years ago?
Sucks anyways. I got a stubby little pencil.
Hello?
Procedural matters, and unfortunately you have not.
Hello?
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. We're sitting at 1 hour 31 minutes.
Remember in the beginning when we started 110 years ago?
Fix the timer there just a little bit.
Matters, and unfortunately you have not.
Hello?
All right, there we go. Sorry, it took a long lunch there. Talked to Mrs. R.A. Had a little bit of leftovers. A little bit of leftovers for lunch. Did the it's like a lasagna casserole thing, which I'm a little bit partial to. I like it. It's pretty good. All right, we're back. Let me fade the music out here. Let me correct how long the jury was out for Kevin. They actually began deliberating about the same time as today, and the verdict was read at about 6 p.m. that same day. Ooh, like a tree planted. That'd be interesting if we mirrored that one. Josh did send me a palate cleanser. Where'd my phone go? It would be embarrassing if I'm like sitting here looking at it, but I just can't see it. I think it's in the other room. Gonna see if they'll bring it to me. All right, welcome if you're new here, especially. We've got a lot of new people here from recommendation from Kathy over at Gossip Rumor and Innuendo. Thank you, Kathy, for that, and appreciate you guys being here. We are on Verdict Watch. No verdict yet. No news yet. We're waiting. I was actually hoping to get word, checking my phone, to see if any word had come in on the Twitterverse. And nothing I can see. 2 o'clock straight up in Utah right now. 4 o'clock on the East Coast, 3 o'clock Central, and it's only 1 o'clock. Just early afternoon if you're on the West Coast. So, got a couple more hours left of deliberation for sure in us here today for this jury. Thank you. All right. Did successfully manage to get all my gear AirTagged during the lunch break, so I was productive. Just Amy Beth, thank you very much. Welcome. Seeing a lot of hearts for Kathy in here. That's awesome. Is Stubby broken? It worked just a minute ago. I heard it working just a second ago. You could probably try it again. It will work. What if I'm old here? Well, a couple of us are old here, so that's all right. No worries.
There's nothing in the order that restrains you from talking to cats.
Thank you.
All right. Nothing new on the Twitter front. Let's see. I don't see anything new at all there, so we're just waiting. We'll apparently, if the jury has a question, the judge is going to call the lawyers in their office. Don't bother coming down. I'll just read it to you over the phone. And then you just give me the go-ahead if you're good with what I decide to do. So that'll be interesting. Andrew, JC, member for 36 months at the 3-year mark. That makes you an OG by a long shot. New color, yay. Congratulations. Nice red courthouse there. Did you bring AirTags to show us? I did. I showed them this morning. And now they're all successfully installed in my Pelican cases, the travel kits for my gear. So a couple of them I don't think I'll be able to get out again, maybe even to change the batteries. That adhesive is something serious. Did you know that you can't spell documents without you and me? Also Doc, and also Doc and the degree I have, but got nothing for NTS. But I heard you have something to read. Yes, I do have something to read. I was going to pull it up because there's been a couple updates in the Maya trial. Attorney Greg Anderson has filed some spicy documents in that trial. He's been accused of a couple things. One of them is for inappropriately using funds that were obtained through a bridge loan that the family, or Maya specifically, may have signed off on and then given money to the lawyer for. So please resend the affiliated link for the AirTag holders. I have not sent it to anyone yet.
I got a stubby little pencil.
Stubby? See, Stubby works just fine. All right, let's do a quick look. Let's see, Saratoga.
jury.
That's New York. That's the wrong one. I do have a login for this page, but I always forget what it is. Let's do a quick search here. I think Greener sent these to me as well. Just 1 second. Let's see. Holy smokes. Hang on. Is Brandon, are you here, Brandon, with us right now in chat? Brandon, you know which Brandon you are. Law school Brandon. I just got the most amazing email, and I hope I can share it. Man, I don't think he's with us right now. Oh my goodness. Okay, I'm gonna reach out to him and see if I can get permission to share what he shared with me. So hold that thought. I'm sorry. All right, still looking for my email from Greeners. I've got one from Mathis. That counts. Mathis, you're here, right? Let's see. Which brief is it? 1 or 2? Those are the Florida Supreme Court ones. Looking for the Maya ones. There. All right, got it. Sorry, it took a little bit of hunting. Probably should have done this during the break, but I was distracted. Okay, where are we going to run this from? Do you guys want to be able to read it as well? Yes, show it. Okay. I'm going to have to turn chat off for just a minute because I can't show everything at once. Yet. Let's open this with preview. It's a tiny app, much lighter weight, and it just works better. Okay, there we go. Full screen. We're going to change this to be continuous scroll. Oh, that got really bright. Can you guys see this? Okay, give me a second. Let me get the courtroom in the corner so you can see that we're not missing anything with court. And we'll do a little bit of reading here. Just one second. Super source 1 is going to be camera 2. So now we've got ourselves in the corner, and box 4 is going to be our chat box. How about that? Does that work? All right, yay. Let me resize a couple things so it's not taking up all the space, and we'll do a little bit of light reading here, which promises to be quite interesting, especially if you follow the Maya Kowalski case, which we did. We're going to move this one right down into the corner over here. There we go. And now we'll do some reading. All right, this is a response from Attorney Anderson, who was Maya's main attorney during the trial, the civil trial against Johns Hopkins All Children's Hospital, et al., whatever, and where they won over $200 million settlement. Since then, that settlement has been appealed and was rejected. It was overturned by the courts and pared down to just a few issues. But during the process of fighting this and having won and waiting, there was a loan taken out by Maya against her verdict. So now there's like a lien on her verdict. It's the weirdest thing, which means that she's now no longer the owner of her case. She can't decide to settle now, and now it's going back to court because there's a bank that now has a vested interest in the outcome of her trial. All this came about allegedly under advice, whether it was appropriate or not, from Attorney Anderson, and that's alleged. He says he didn't do anything wrong, and this is the response to some of those allegations, specifically regarding the money. And I'm going to need some water for this one as well. All right. Pursuant to the court's March 2nd, 2026 order from Case Management Conference, which directed former counsel Gregory Anderson, Jennifer C. Anderson, and Anderson Glenn LLP, collectively called Anderson, to file a response to plaintiff's brief on legal issues relating to the disposition of disputed funds from the advanced funding loan by April 13th, 2026, Anderson hereby submits this response brief. So he says, "You made me do this. Here it is." Summary of the argument. The plaintiffs seek the complete forfeiture of all attorney's fees while simultaneously retaining tens of millions of dollars in non-recourse, tax-free liquidity, a financial recovery made possible exclusively by Anderson's 8 years of self-financed litigation and post-judgment structuring. That position is inequitable, legally unsupported, and should be rejected. Basically, Maya's team now is saying we shouldn't have to pay Greg Anderson anything for anything he did. First, the advanced funding loan, also known as the bridge loan, was not a prohibited pre-suit consumer loan of the type addressed in the bar's ethics opinions. It was fully insured, post-judgment financial structure designed to monetize an adjudicated recovery while protecting plaintiffs against appellate risk through a $60 million judgment preservation insurance policy. The authorities cited by plaintiffs are factually and legally inapplicable. It's not the type of loan you guys said it was. This one was insured against... I didn't know you can insure a judgment, but I guess somebody's on the hook for that. Second, any deviation from the standard to contingency fee schedule creates only a rebuttable presumption of the excessiveness under Rule 4-1.5F. It does not render the agreements void. Void ab initio. That's a Latin term, I think. Void at the start. think that's what it means. My Latin's rusty. Florida law requires evaluation of the totality of the circumstances, including the novelty and difficulty of the issues, the risk assumed, and the results obtained. Anderson is entitled to an evidentiary hearing to rebut that presumption, and a summary forfeiture is not available as a remedy. Third, because Anderson's efforts produced a massive, realized, and irrevocable financial benefit for the plaintiffs, i.e. millions of dollars the plaintiffs have accepted and continue to enjoy, the contingency was satisfied. Anderson is entitled to fees under the contract or, alternatively, through quantum merit. Fifth. 5 is fourth. Paragraph 5 is number 4. It's funny how they're off one by one. Plaintiffs' claim failed because they cannot invoke equity to compel fee forfeiture while retaining the precise financial benefits that Anderson's work created. You can't say I don't deserve the fee while you're enjoying the money that I earned you, says the lawyer. The party most appropriately subject to an unclean hands analysis is the plaintiff's current counsel, who participated in structuring the bridge loan, accepted a $250,000 bonus from its proceeds, and thereafter moved to challenge the same transaction as improper. Whoa! Okay, this is pot meat kettle type accusation. Greg Anderson now turns to on Nick Whitney and team, and says, you guys helped structure this bridge loan. You took a $250,000 bonus from it, and now you're challenging it, saying that was illegal. Fifth, the $4 million held in account 5153 was separated and treated as earned fees prior to the issuance of the court security orders. Ooh, this is tricky. This is a timeline issue. Anderson's exercise of dominion and control over those funds, including pledging them as a collateral for a personal line of credit, established their character as earned fees before any court order placed them at issue. So basically, before the court said, lock all the funds down, don't do anything with them, Anderson said, this portion of the funds go to us as earnings, which I can now do with as I please, and they may have been used to secure a personal line of credit before the court said, don't do anything with the money. Counterstatement of facts. The extraordinary representation and financial risk. This action arises from extraordinarily complex and protracted litigation spanning nearly 8 years, involving allegations of significant medical, legal, and institutional misconduct. Anderson was retained in May 2017 pursuant to a series of contingency fee agreements. From its inception, the representation required Anderson Glenn, and in particular Gregory Anderson personally, to assume complete financial responsibility. Hang on. Let's see who's buffering me and why. Let's see who this is. Hang on. Hello, who's this? I don't know who it was. Who buffered me? Let's see. Red Pen buffered me. Can you resize the doc so we can see it and read along with you? Can you not see it? I show you guys can see it. This is the biggest I can make it. It's full screen. I'm blocking half. Your head is blocking half. Oh, can I resize my? You want to read ahead is what I'm hearing. Okay, fine. I'm just kidding. I'm just going to shrink down a little bit. Maybe if I go in the top corner. I'll try to keep it at the top of the screen. Does that work? Okay, so Anderson was retained in May 2017 pursuant to a series of contingency fee agreements. From its inception, the representation required Anderson Glenn, and in particular Gregory Anderson personally, to assume complete financial responsibility for prosecuting the case. There's an evidentiary note here that says, to ensure the protection of the Kowalski parties and the preservation of Anderson's work product, certain evidence has been withheld from public filing at this juncture. Anderson remains prepared to present this underlying documentation either through in-camera inspection at the court's direction, so basically in the judge's quarters, in his chambers, or as a part of a formal evidentiary hearing. By deferring production until the court can establish appropriate safeguards, the parties avoid the risk of unintentional waiver while ensuring that a full and accurate record is ultimately established for the court's consideration. At this time, Greg and Jennifer Anderson can and will testify, if necessary, in open court to any and all allegations against Greg Anderson by their former long-term clients. Goes on. Multiple experienced attorneys and law firms had previously declined representation due to its complexity, risk, and financial demands. This was a huge case, and Greg did put up the money to fight this one and put up his house. He sold his house to fight this one. Anderson advanced significant litigation costs throughout the representation without guarantee of recovery, committing more than an estimated 40,000 hours of combined attorney and paralegal time to investigation, discovery, motion practice, trial preparation, and trial. I would be surprised. I would be very, very surprised if those 40,000 hours are billed at anything less than $1,000 an hour. I would be extremely surprised. You do the math on that. That puts him over $4 million in earnings there, if it's 1,000. The case proceeded through 8 iterations of the complaint, was presided over by multiple judges due to successive judicial reassignments, and generated over 4,000 docket entries, including more than 50 dispositive motions, over 100 motions in limine, and 14 separate hearings on electronic discovery alone. More than 100 depositions were taken, and dozens of expert witnesses were retained and deposed. Anderson's financial commitment was not theoretical or limited to routine cost advancement. The representation required sustained, real-world financial exposure over nearly 8 years, including the use of personal firm resources to fund ongoing litigation obligations in the absence of any guaranteed recovery. See the affidavit of Terry Durkham attached as Exhibit A. The firm operated under continuous risk that it would receive no compensation whatsoever, despite the scale of the investment required to prosecute the case. It was an extended, high-risk undertaking in which counsel bore both the operational burden of the litigation and the financial uncertainty inherent in pursuing a novel and heavily contested matter through trial. These challenges were compounded by the COVID-19 pandemic in 2020 and 21, which disrupted court operations, scheduling, and trial preparation during the most intensive phase of the pretrial proceedings. The case simultaneously attracted extraordinary public attention through the Netflix documentary Take Care of Maya, viewed by approximately 50 million people worldwide, adding further logistical and strategic complexity. This court presided over the full scope of these proceedings. It observed firsthand the volume of filings, the contested motion practice, the complex evidentiary disputes, and the sustained effort required to bring this matter to trial. Against that backdrop, the attempt to deny Anderson any compensation for nearly 8 years of successful representation, and after the full benefit of that work has been realized by plaintiffs, is the central inequity, I think it meant quality, inequity that Anderson asks this court to correct. Transparency and informed consent. Contrary to plaintiff's characterization, the fee structure and bridge loan were the subject of ongoing transparent communication. The Kowalskis executed formal written waivers specifically acknowledging the fee arrangement. The bridge loan closing statement, executed by plaintiffs with the benefit of the independent transactional counsel from the firm of Stoneburner, Barry, and Jacksonville, expressly ratified the fee deductions now in dispute. At the time of the loan closing, plaintiffs had multiple attorneys available to advise them: closing counsel, trust counsel, transactional counsel, and appellate counsel. Gresham, Stoneburner, and James Purcell, 2 experienced transactional attorneys, represented the plaintiffs' interests in the loan. The lending parties were represented by Skadden Arps, New York, and London offices. The suggestion that plaintiffs were unadvised or misled is not supported by the record. At least 4 statements of client rights were executed by Maya and Jack Kowalski, along with at least 3 contingency fee agreements and waivers. The fee agreements were presented to and approved by County Guardianship Judge Williams in connection to the Suncoast and Smith settlements. Now that's the Smith you know and love. See, in regard to guardianship of Maya Kowalski with the case number, in regards to Kyle Kowalski with the case number. Additionally, Greg Anderson's July 22nd, 2024 email to the Kowalskis openly acknowledged the applicable bar rule requirements and provided a candid explanation of why this litigation's unusual complexity and duration justified the fee structure. Maya Kowalski's last text message to Anderson, dated November 19, 2024, read, "We love you so much. Please keep me posted on Jen. That's all that's important right now." That message immediately followed a detailed explanation of the bar rules and the fee approval hearing timeline. The record does not support a narrative of concealment. Strategic decision regarding fee approval. Anderson's decision not to seek a pre-suit judicial approval hearing for the above cap fee was not an act of deception. It was a deliberate, strategic choice made to protect the Kowalskis' privacy. A formal approval proceeding would have exposed the clients to aggressive discovery by the defense into their financial circumstances and would have invited more of the invasive media scrutiny that already surrounded this case. That judgment, whether or not one agrees with it in hindsight, was made in the client's interest and was disclosed to them. In stark contrast to the contemporaneous signed agreements and communications reflecting this disclosure, plaintiff's current claims rest on after-the-fact declarations prepared in the context of a fee dispute. The plaintiff's current counsel and the bridge loan. The conduct of Nicholas Whitney, plaintiff's current counsel and former junior partner at Anderson Glen, is directly relevant to the equitable issues before the court. Mr. Whitney was personally and substantively involved in structuring and implementing the bridge loan. His involvement included direct communications with the lender and participation in the underlying transaction strategy, much of which was conducted without Anderson's knowledge. At one point during the loan process, broker Evan Torrell offered to meet with the Kowalskis in person to review the transaction in detail. Mr. Whitney declined that offer, citing publicity concerns, thereby limiting the client's opportunity for independent direct review of the loan terms, the very conduct he now attributes to Anderson. Following his departure from the firm, Mr. Whitney initiated contact with plaintiffs. Under Rule 4-42, that communication with parties he knew to be represented by Anderson raises serious ethical concerns that cannot be resolved simply by asserting that the plaintiffs called him first. Attorney Nick Whitney, who now represents plaintiffs in attacking this transaction, actively participated in the Kowalski litigation while at Anderson Glen and personally accepted a $250,000 bonus derived directly from the bridge loan proceeds he now claims are ethically tainted. He subsequently departed the firm, initiated contact with plaintiffs, and became deeply involved in drafting the motions challenging the bridge loan and Anderson's fee entitlement. Having participated in and benefited from the very transaction he now attacks, Mr. Whitney advances positions directly contrary to his prior conduct. The equitable doctrines of unclean hands and estoppel apply with particular force to this posture, and they are addressed in the argument section below. The security orders and the $4 million in account number 5153. So look at that. It was $4 million. It's $1,000 an hour for 4,000 hours. Following the bridge loan closing, funds were deposited into escrow accounts at Hancock Whitney Bank. On October 21st, 2024, $4 million was transferred from the 0759 account to a business savings account ending in 5153. This transfer occurred before the court security orders issued, and Anderson treated these funds as earned fees at that time. In December 2024, Anderson pledged the funds in account 5153 as specific collateral for a personal line of credit to purchase a home, an unequivocal exercise of dominion and control establishing their character as earned fees prior to any court order affecting their disposition. It is August 13, 2025 In its order, the court directed Anderson Glen to retain the approximately $4 million in account 5153 and reserve the right to redirect its distribution. Anderson has complied with that order and addresses the proper disposition of those funds in point 5 below. The legal argument. Point 1. The fee agreements are not void ab initio under Rule 4-15. The plain language of Rule 4-15 creates a rebuttable presumption, not an automatic forfeiture. Plaintiff's central premise that any deviation from Rule 4-1.5F's percentage limitations renders a contingency fee agreement void ab initio at start overstates the rule and misreads Florida law. The rule does not declare non-compliant fee agreements illegal or void on their face. By its express terms, fees exceeding the stated percentages are presumed, unless rebutted, to be clearly excessive. That language is unambiguous. The presumption is rebuttable. The distinction is controlling. Florida courts have constantly held that evaluating the reasonableness of attorney's fees requires consideration of the totality of the circumstances, and we have a lot of case law there. The Florida Supreme Court has further held that the amount of an attorney's fee must be determined on the facts of each case, accounting for the time and the labor required, the novelty and the difficulty of the issues, the skill required, and the results obtained. Contingency arrangements must additionally account for the heightened risk that counsel receives nothing if the client does not prevail. The rule structure itself confirms this flexibility. Subsection F4B2 expressly provides mechanism for exceeding the standard percentages where a client cannot otherwise obtain competent counsel, reflecting the rule's recognition that complex, high-risk litigation may justify fee arrangements outside the standard schedule. Moreover, Florida follows the no surplusage canon. Every word in the rule must be given meaning and effect. Rendering the rebuttal clause meaningless would violate that principle. Miami, Beverly, and Harmon Parker do not establish automatic forfeiture. So these are case laws he's citing. Plaintiff's reliance in the Miami, Beverly, and Harmon Parker cases argue that agreements are void ab initio, ignores the plain language of the rule. The rule expressly states that fees exceeding the standard schedule are presumed unless rebutted to be clearly excessive. Miami Beverly did not establish a categorical rule of automatic forfeiture. Rather, the bankruptcy court in that case considered the specific circumstances before it found that the attorney had simply failed to rebut the presumption. This is a fact-specific determination, not a categorical legal rule. Miami Beverly arose to in a bankruptcy context involving an attorney who provided minimal services and whose fee was objectively disproportionate to the work performed. Like Sarah Boone's attorneys, right? Those circumstances bear no resemblance to the record here. Federal courts applying Florida law have explicitly recognized that an attorney must be provided the opportunity to make proper showing to rebut the presumption of excessiveness after the fact. Got some case law with Wright v. Ford Motor Company from 2013. The sheer scale of Anderson's 8-year self-financed prosecution of this case, which secured a $261 million verdict after over 100 depositions and 51 dispositive motions, presents precisely the extraordinary circumstances required to rebut the presumption. The fee agreements do not warrant automatic invalidation under the rule. While Florida Supreme Court has recognized that contingency fee agreements must comply with the rules regarding the Florida bar, courts have cautioned against applying broad language from judicial opinions in mechanical fashion, divorced from the facts and the circumstances at issue. Let's see, some case law that explains that general language and judicial opinions must be read in context and not applied to materially different circumstances. The structure and language of the rule further confirm that not every deviation renders a contract unenforceable. The rule provides that fee agreements are ordinarily enforceable according to the terms of such contracts unless they are illegal, prohibited, or clearly excessive as defined by the rule. I still want to know what the amount is that they're talking about here. Because $4 million out of $261 million does not seem to be excessive. Let's see. Notably, the definition of illegal, prohibited, or clearly excessive does not equate to technical or procedural noncompliance with facial illegality. See the rule regulating Florida bar. Consistent with this framework, the preamble to Chapter 4 states, violation of a rule should not itself give rise to a cause of action against a lawyer, nor should it create any presumption that a legal duty has been breached. In addition, violation of a rule does not necessarily warrant any other non-disciplinary remedy, such as disqualification of a lawyer in pending litigation. The rules are designed to provide guidance to lawyers and to provide a structure for regulating conduct through disciplinary agencies. Courts applying these principles have recognized that not all violations of the rule carry the same consequences. Rather, the enforceability of a fee arrangement depends on the nature of the materiality of the alleged violation and the factual context in which it arose. Courts should exercise extreme caution before declaring contracts void as against public policy and should do so only where necessary to protect a dominant public interest. Recognizing the need to balance public policy concerns with fundamental right to freely contract, that's the case law there. Indeed, courts have emphasized that technical or immaterial defects in compliance with the rule do not automatically render an agreement unenforceable, particularly where the underlying relationship and services performed are undisputed, and that a contract under the rule is still enforceable if the violations are technical or immaterial. When these principles are applied to the present case, it is clear that plaintiffs' request for a wholesale invalidation of the fee agreements is unwarranted. This case does not involve prohibited conduct, overreaching, or an agreement that is illegal on its face. They're arguing about the $4 million. Seriously? That's too much? Usually you think an attorney takes like 30%. What's 30% of $260 million? Instead, it arises from an extraordinary complex high-risk presentation spanning more than 8 years, involving tens of thousands of hours out of attorney and paralegal time, substantial firm-funded costs, and a result exceeding $200 million. Anderson undertook this representation when multiple other firms declined, assumed the full financial risk of litigation, and prosecuted the case through trial, post-trial proceedings, and appeal with nearly a decade of hard-fought litigation. Under these circumstances, the alleged failure to obtain prior court approval does not justify the drastic remedy of a complete fee forfeiture. At most, it triggers a presumption subject to rebuttal through fact-intensive inquiry into the reasonableness of the fee in light of the risk undertaken, the work performed, and the results obtained. To hold otherwise would elevate form over substance and produce an inequitable windfall to plaintiffs, contrary to the principles of equity and public policy that govern attorney compensation in Florida. In sum, Rule 4-15 does not compel the automatic invalidation of the fee agreements at issue. Rather, it requires a contextual and fact-driven analysis, one that fully accounts for the extraordinary nature of the representation and the substantial benefits conferred upon the plaintiffs as a direct result of Anderson's efforts. This case exemplifies the extraordinary circumstances contemplated by the rule. At least 3 experienced firms declined this representation due to its complexity, cost, and risk. Anderson undertook it nonetheless, committing to finance the litigation for nearly 8 years, advancing substantial costs without guarantee of recovery and expending tens of thousands of hours of professional time. This case involved unprecedented factual and legal challenges, over 100 depositions, he says this over and over, 51 dispositive motions, and over 100 evidentiary motions, and 14 separate electronic discovery hearings. These are precisely the circumstances in which rigid application of Rule 4-1.5F as a forfeiture mechanism would contravene both the rule's purpose and Florida's long-standing equitable principles governing attorney compensation. I have to say that Greg's argument here sounds pretty sound. It sounds like there's wiggle room in the law for an agreement. Desk and my chair are in a fight. There's wiggle room in the law for an agreement that differs from the standard payouts. And it sounds like also the 4%, Mathis, I think you're saying, the issue is that Anderson argues that this is clearly a 33% case, but Florida law has brackets where the share falls to something like 25%. Yeah, but this did not fall in any brackets, right? This was an outside the brackets type result. The Kowalskis were not pressured into the fee agreement. They had multiple attorneys available throughout their representation and could have terminated the engagement at any time, particularly during the 4-year period from 2017 to 2021. They executed multiple fee agreements and waivers with full knowledge of the terms, and the fee structure was presented to and approved by county guardianship, Judge Williams, in connection with the Suncoast and Smith settlements. The record does not support the conclusion that any inequity occurred that would warrant the extreme remedy of total forfeiture. The loan, point number 2, the loan does not violate Rule 4.18E or the bar's ethics. The opinions are as follows. Sorry, my burner phone is blowing up here. Let's see. Let's see. Yeah. The plaintiffs conflate pre-suit consumer loans with an insured post-judgment financial structure. Plaintiffs' reliance on Rule 4-18 and the Florida Bar Ethics opinions is misplaced because those authorities address materially different circumstances. The cited opinions concern attorneys who assist clients in obtaining pre-recovery litigation funding for living expenses, arrangements that create conflicts of interest or compromise the attorney's independent professional judgment during active, unresolved litigation. None of them addresses a post-judgment, fully insured financial structure of the type at issue here. When he says fully insured, does that mean? I mean, I was left with the impression when I saw the, I guess it was the Maya side filing, that the family was left owing tens of millions of dollars more than their loan was for, and just no way to pay it. That was how. But now when he says fully insured means if something goes wrong, which it did, it got reversed, it would be covered. The transaction at issue arose after entry of a substantial jury verdict and judgment. It was not speculative litigation funding. It was a post-judgment financial agreement supported by a $60 million judgment preservation insurance policy, under which third-party insurers agreed to indemnify plaintiffs for any loss resulting from a reduction of the judgment below a defined threshold. Okay, hang on. This is getting interesting. Because I can now see where getting a loan, an advance loan for a settlement, would be a smart thing to do if you think that your settlement is going to be reversed, especially if it's insured. In functional terms, the insurer stepped into the position of bearing appellate risk with respect to a portion of the judgment. This structure has no analog in the ethics opinions plaintiffs cite. Florida courts have recognized that the ethical concerns underlying Rule 4-18E are context dependent. There's a case law where it says discipline not warranted, where attorneys' financial assistance did not create improper influence over litigation decisions. Those concerns are not implicated in the same manner, whereas here the underlying liability had already been adjudicated and the financial arrangement was undertaken to secure and partially monetize the adjudicated recovery during the appellate period. So he's saying that the rules that they're citing were designed to prevent lawyers from making decisions in the case based on the money, the loan money. And he says that didn't happen. The case was decided and then there was a loan, so it doesn't apply. Neither the non-recourse structure nor Anderson's role in the transaction implicates Rule 4-18. The ethics opinions plaintiffs cite are concerned primarily with agreements that impose financial burdens on clients or create coercive pressure that distorts litigation decision-making. Neither concern applies here. The bridge loan was non-recourse. Plaintiffs bear no personal obligation to repay if the judgment is reduced or reversed beyond the insured threshold. Wow. That basically means that if it's reduced, I imagine that also qualifies through a retrial. If it's reduced below $60 million, they don't owe anything. They just keep the amount they have. The Kowalski's control over prosecution, appeal, and settlement was expressly preserved and unconditional. Anderson held 4 formal roles in the transaction structure: process agent, subordinated creditor, grantor of collateral, and deposit account holder. Each was assured at the lender's insistence as a structural requirement of making the transaction available to the Kowalskis. The transactional documents were prepared by Skardon Arps. The Kowalskis were represented by Stoneburner Berry of Jacksonville. Anderson did not control the final terms. As process agent, Anderson agreed to accept service of legal process in New York on the Kowalskis' behalf, a role required by the lenders to ensure the borrowers had designated an agent in their jurisdiction. As grantor, Anderson Glenn granted the lenders a first priority perfected security interest in the loan's collateral and obligated itself to defend that interest against competing claims, not to acquire an interest for itself, but because the lenders required it as a condition of funding. As deposit account holder, the firm maintained the designated proceeds account through which all judgment proceeds and insurance payouts were required to flow, again at the lender's insistence. As subordinated creditor, Anderson Glenn's interests are subordinated to HPS as administrative agent. Okay, that's it. It's getting heavy into the who owns what and has control where there, but it seems like it was a requirement by the lender to structure it the way they did. The plain purpose prevents attorneys from acquiring interests that compromise their independent judgment. It's not implicated here. Each role Anderson assumed was structural requirement of a transaction that delivered tens of millions of dollars to the clients. None of those roles gave Anderson a proprietary interest in the litigation itself. Anderson had no guaranteed right to compensation for structuring the bridge loan. That work fell outside the scope of the contingency fee agreements entirely. The bridge loan closing statement was the only mechanism through which Anderson could be paid for that effort, and it was the Kowalskis who chose to execute it. Anderson's willingness to perform substantial post-judgment transactional work with no contractual guarantee of payment is inconsistent with the portrait of self-dealing that plaintiffs now advance. The transaction served three legitimate and interrelated objectives. The bridge loan was designed to accomplish three legitimate objectives: to provide plaintiffs with immediate access to a portion of the value of their adjudicated recovery, to ensure continued funding of the litigation and appellate process, and to mitigate appellate risk through procurement and judgment preservation insurance. These objectives are entirely distinct from the concerns emanating. Is it emanating or animating? I think it should be animating. Red pen, help me with the words here. I think it should be emanating. Yes, not animating. Animating is when you like draw pictures and you make them come to life. Emanating means it's like exuding from. The ethics opinions plaintiffs cite. At the time, plaintiffs were emerging from years of demanding litigation. The loan provided financial stability, including the ability to relocate from a residence associated with significant trauma. Maya Kowalski suffers from CRPS, a condition that can relapse and cause serious harm if left untreated, and the loan enabled her to access necessary care. The family had also lost Beata Kowalski's income. Providing clients with candid advice about available financial structures, including advice about the economic realities they face during a lengthy appellate process, is not only permissible under Rule 4.2.1, but as an obligation of competent representation. Chapter 4 of the rules regulating the Florida Bar do not provide a basis for disqualification. The rules regulating the Florida Bar are not designed to serve as procedural weapons in litigation. Rather, they exist to guide attorney conduct and to provide a framework for professional discipline. Attempts to invoke these rules as an independent basis for disqualification improperly expand their intended purpose and risk transforming disciplinary standards into tactical tools. He's saying that these rules are being used as a weapon when there should have been just a guideline and, not hard and fast limits, but it's going against the spirit of the rules themselves. As previously noted, the preamble to Chapter 4 makes clear that a violation of the rules regulating the Florida Bar does not, standing alone, create a cause of action, give rise to a presumption of a breached legal duty, or justify non-disciplinary remedies such as disqualification. Rather, the rules are intended to guide attorney conduct and to establish a framework for professional discipline. Accordingly, reliance on alleged rule violations as a basis for disqualification of Anderson's entire fee is misplaced. To hold otherwise would invite routine misuse of the rules and undermine both the integrity of the disciplinary system and the orderly administration of justice. Point number 3. The loan proceeds constitute a recovery, satisfying the contingency and permitting quantum merit. Okay, this might be a stretch for me. This is basically saying the Kowalskis they got this ruling, okay, but the ruling was that they won $260 million. It was sort of put on hold as it got appealed, and during that hold, as it got appealed, they went out and got a loan saying, "Hey, we've won this. We just haven't been paid yet. Can you pay us in advance? And then when we get paid, you'll get the money, and it'll be this nice little deal." So it's like a payday lender for a court case. So to have the loan proceeds constitute a recovery, meaning like the payout, the J-Hatch was supposed to ultimately pay out if Kowalskis were entirely successful in this case. This might be a stretch. Let's see where this one goes. The August 2, 2024 email must be read in context. The closing statement controls. Really? Okay, that means that there's something in the email that he doesn't want to be weighted very heavily. And just look at the last words. That's all that matters. Deer Park Water, not a sponsor yet. Plaintiffs rely on Scherer v. Austin Rowe Basquill, PA, to argue that the advanced funding loan does not constitute a recovery from a judgment debtor, and they point to an August 2, 2024 email from Anderson stating there was no recovery. However, that correspondence must be read in its proper context. Okay, so if he said there was no recovery, now he wants to say there's a recovery. Let's see how that shapes out. The August 2 email was directed to appellate counsel, whose specific fee trigger required a final, non-appealable judgment or settlement. Anderson's... Whoa. So the appellate counsel didn't get paid? Anderson's statement that there was no recovery was a reference to that specific contractual trigger, not a general characterization of a bridge loan transaction or an admission that no compensable benefit had been conferred on the clients. I'm concerned about this. This part just... It sounds like Greg Anderson in his argument here is saying the appellate guys shouldn't get paid, but I should. Is that what you guys are reading? Is that how you see that? In stark contrast, the Kowalskis executed a bridge loan closing statement that explicitly authorized the disbursement of $9,937,125 in attorney's fees from the loan proceeds. By signing that document with the benefit of independent transactional counsel and by accepting and utilizing tens of millions of dollars in tax-free, non-recourse liquidity, benefits or plaintiffs effectively agreed that the loan proceeds functioned as a recovery, justifying immediate fee distribution under the employment contract. That signed authorization is the operative document, and it cannot be undone by selectively citing correspondence addressed to a different attorney regarding a different fee trigger. Whoa. The bridge loan was not, I'm not sure if Judge Carroll's going to see this the same way. The bridge loan was not peripheral side transaction. It was the functional equivalent of a statement of a settlement monetization, one the clients accepted, ratified in writing, and used to purchase homes. Because Anderson's efforts were produced a realized and irrevocable financial benefit for the clients, the contingency was satisfied and the cause of action for quantum merit under Rosenberg v. Levin is fully ripe. So because the Kowalskis got money and were able to use it to purchase homes, then Attorney Anderson's firm should have been paid. But because the settlement was still revocable, and it was revoked, then the appellate attorneys should not get paid, according to this argument. Court sitting in equity looked to substance over form. Plaintiffs argue that the bridge loan proceeds do not constitute a recovery within the meaning of the fee agreements, relying on the formal argument that the funds came from a lender rather than a judgment debtor. So it wasn't J-Hatch dollars they were getting. It was the bank's dollars. That argument elevates form over substance in a manner that equity does not permit. Through Anderson's directed efforts, plaintiffs obtained tens of millions of dollars in an immediate non-recourse liquidity. That financial benefit was directly and causally tied to the verdict. The resulting judgment was the essential asset the lenders and the insurers required. Without Anderson's labor, there would have been no verdict, no judgment, no leverage to obtain the non-recourse funding, and no transaction. The funds plaintiff received exist solely because of Anderson's work. I agree to that part. Transactional attorneys routinely structure post-closing financial agreements that generate immediate value for clients from adjudicated or negotiated rights. The characterization of those proceeds as a loan rather than a recovery does not diminish the value derived to the client. The court sitting in equity should not be constrained by that label, particularly where, as here, the client's own executed closing statement authorized the fee deduction from those specific funds. Rosenberg does not bar recovery where counsel's efforts produced irrevocable financial value. Plaintiff's reliance on Rosenberg v. Levin is misplaced. Rosenberg addresses the standard scenario of discharged contingency counsel seeking fees after complete failure to achieve any recovery for the client. So the Rosenberg case is an example of my lawyers lost and they're still trying to get me to pay. They lost the case and now I fired them and they're trying to get me to pay. It does not address and does not preclude recovery in complex multi-stage litigation where the attorney's efforts produce substantial, tangible, and irrevocable financial value for the client prior to discharge. So he's saying it doesn't fit in our situation where we won, you got money, you got like cash in hand, it was through a loan, and that happened before you fired me. Here, Anderson's strategy produced a $261 million verdict and a bridge loan that derived tens of millions of dollars in non-recourse liquidity to the plaintiffs. Those funds have been accepted and used by plaintiffs. They cannot be reclaimed. They are fully insured under the credit agreement and the Ambridge policy. Therefore, a final recovery for the client, therefore, a financial recovery for the client occurred, and the contingency was satisfied. The subsequent appellate reversal of the underlying judgment does not undo the financial benefit already realized. They don't lose their money. The insurance company, it sounds like, is out of pocket, $60 million or whatever it was the loan amount was. Copies of the HBS credit agreement are being provided to the court under separate cover for in-camera inspection, so that's going to be sealed. The critical distinction from Rosenberg is that this is not a case where former counsel produced nothing. It is a case where former counsel's work and strategy produced a substantial, concrete, and permanent financial benefit that plaintiffs continue to enjoy. Denying any compensation in that circumstance would produce a windfall for plaintiffs that equity does not sanction. So they're saying if you deny Anderson Glenn their money, basically that's another free $9 million for the Kowalskis. They basically get all this money without having to pay any lawyers at all. I mean, obviously, they're still going to be paying their current lawyers, I think, but quantum merit is not limited to formal judgment recoveries. As an equitable doctrine, quantum merit focuses on the value actually conferred upon the client, not the formal label attached to the vehicle through which that value is delivered. Got some case law there. Anderson's strategic work product, i.e. the verdict, the judgment, and the bridge loan structure, put tens of millions of dollars in plaintiffs' hands. That is a compensable benefit regardless of whether the proceeds are characterized as a loan proceeds or a judgment recovery. Even if the court were to accept plaintiff's position that the fee agreements are unenforceable, the quantum merit claim survives independently. Anderson performed substantial work on behalf of the plaintiffs over nearly 8 years, advanced millions of dollars in costs, and secured a result that generated massive realized value. Permitting plaintiffs to retain that value while paying nothing to the attorneys who created it is precisely the unjust enrichment that the doctrine of quantum merit is designed to prevent. Point number 4, equitable principles preclude the relief plaintiffs seek. At its core, plaintiff's position asks the court to separate benefit from obligation in a manner equity does not permit. Plaintiffs accepted and continue to retain the substantial financial advantages created by Anderson's work, including tens of millions of dollars in non-recourse liquidity derived directly from the verdict and subsequent financial structuring. Having done so, they now seek to invalidate the very fee agreement that made those benefits possible. Florida law does not allow a party to affirm a transaction for purposes of receiving its advantages while simultaneously disavowing it to avoid its corresponding obligations. You can't be on both sides. He says they're arguing both sides. That fundamental inconsistency underlies each of the plaintiff's claims and weighs heavily against the relief they seek. Unclean hands. Here's where we start slinging some dirt. The clean hands doctrine requires that the party invoking equity have acted equitably with respect to the matter in controversy. See case law. Plaintiffs cannot satisfy that requirement here. Plaintiffs, and I'm talking about you, Nick Whitney, says Mr. Anderson. Plaintiffs accepted and have retained tens of millions of dollars. The plaintiffs in this case is the Kowalskis. Plaintiffs accepted and have retained tens of millions of dollars in non-recourse tax-free liquidity. So they're not taxed on it. It can't be taken from them. And it was generated by the bridge loan, the very transaction they now characterize as improper. Jack Kowalski purchased a home in Odessa, Florida. Maya Kowalski purchased a home in Southern California. Both purchases were made possible by the loan proceeds. Plaintiffs cannot simultaneously denounce the transaction that funded these purchases and invoke equity to recoup the fees paid in connection with it. Furthermore, the party must appropriately subject to an unclean hands analysis. Is plaintiff's current counsel, Mr. Whitney, was directly and substantively involved in structuring the bridge loan. He accepted a $250,000 bonus paid by Anderson from its proceeds. He thereafter departed the firm, initiated contact with the plaintiffs who were represented by Anderson, and became the lead architect of the challenge to the very transaction in which he had participated. His current posture of attacking the bridge loan as improper while having participated in and benefited from it is precisely the inequitable conduct the doctrine of unclean hands addresses. Says, it's don't throw rocks from glass houses. Who's saying, Mr. Whitney, you're in a glass house regarding this. Equitable estoppel. Estoppel is a great word. Anderson reasonably relied on the closing statement executed by the plaintiffs with independent counsel as authorization for the fee distributions. Plaintiffs accepted those distributions, made purchases and financial commitments in reliance upon the loan proceeds, and for months afterward expressed no objection to the fee agreement. Having induced Anderson's reliance and accepted the benefits of the transaction, plaintiffs are stopped from now disavowing it. Unjust enrichment. Even if the court were to find all fee agreements unenforceable, plaintiffs cannot retain the financial benefits generated by Anderson's work without compensating Anderson for that work. He's basically saying, I could still sue to get paid. The unjust enrichment doctrine prevents a party from retaining benefits conferred by another without paying for them. Anderson's 8 years of labor, millions in advance costs, and strategic structuring of the bridge loan are direct cause of the financial position plaintiffs now enjoy. Retention of those benefits without compensation would be unjust. It is a foundational principle of equity that he who seeks equity must do equity. Plaintiffs cannot invoke the court's equitable jurisdiction to compel fee forfeiture while retaining the fruits of the very work for which they seek to avoid payment. Point number 5. The $4 million in account 5153 was established as earned fees prior to the security orders. This is important. I remember this hearing. I remember Judge Carroll asking Greg directly if the money in this account, in 5153, was treated as earned fees or not. And the way I remember it, there was a bit of equivocation in the response. Now let's see what he says here. Plaintiffs asked the court to distribute the $4 million held in account 5153 to them. That request should be denied. The character of those funds as earned fees was established before the court security orders issued, and the court's order directing Anderson to retain those funds did not adjudicate the question of their ultimate ownership. Whoa. Okay, so there's two parts there, and the last part threw me. He says the funds were earned money before the court said, save those dollars. And the court saying, save those dollars, didn't change the fact that they belonged to Anderson Glenn, not the family. The sequence is undisputed. The bridge loan proceeds were deposited into the loan account. From there, $112,440 was transferred to the 0759 account. That's the Anderson Glenn Kowalski fee and cost accounts. They took $15 million. On October 21st, 2024, $4 million was transferred from that account to business savings account 5153. This transfer occurred before the court security orders and reflected the Andersons' treatment of those funds as earned fees. So let's just doing the math here. $15 million in fees from a $60 million bridge loan. At the time of the transfer, those funds had been earned and appropriated as fees. Plaintiffs may point to the fact that tax returns had not yet been filed reflecting this income, but that circumstance reflects routine accounting practice, not uncertainty about the character of the funds. On the advice of the firm's CPA, the $4 million was recorded as fee income effective January 1st, 2025, and corresponding tax liability will be satisfied in the 2025 tax cycle. Whoa. Okay, that means we basically didn't report it in 2024. Look at this. They moved $4 million in 2024 And the way the tax year works, it ends at the end of the year. So December 31st is the end of the tax year for 2024. They would file 2024 taxes in 2025, but here they say the $4 million was recorded as fee income effective January 1st. So they hadn't recorded it. This might be a little sticky situation. And they're saying, but we're going to pay taxes on it in the 2025 tax cycle, which is basically due the same time they filed this. So we're going to pay taxes in April of this year, 2026. In December 2024, Anderson pledged the funds in account 5153 as specific collateral for a personal line of credit in connection with the purchase of a home. So he's acting as if this is his money, he's in charge of the company and this is the earnings. So he says, I got a loan saying, here as collateral, I have $4 million in this account. This account constituted an unequivocal exercise of dominion and control over the funds. Such an exercise of dominion is inconsistent with the treatment of funds as client property held in trusts and is probative evidence that the funds had been earned and appropriated as fees to the security orders, prior to the security orders. So buying the house is an example of what you would do with money that you own, that is yours. It would be very, very wrong for Mr. Anderson to have taken, $15 million of this money that they're supposed to hold and then use that as collateral to do anything personally. If it's supposed to be held, if it still belonged to the client or someone else. That's how you lose your bar license. He says, I didn't do that. We took $4 million of earnings out of the $15 million, stuck them in our personal account, and used them as we would our personal money, in this case, to secure a loan for a home. Okay. The complexity of the account structure was further compounded when this court security orders in April 2025 directing disputed funds into a court-controlled trust account directly conflicted with the DACA's requirement that all proceeds flow exclusively to the account 7668. Who's 7668? Hang on. That's a new account. We don't know who 7668 is. HPS responded with a formal notice of additional events of default on July 30th, asserting that the security orders materially undermined the lender's security position. This conflict was not of Anderson's making. It arose from the intersection of the lender's contractual rights and this court's orders, a collision set in motion by the substitution of counsel and the fee dispute that followed, neither of which Anderson initiated. So the movement of the money, the change in counsel and everything, and now his bank that he got a loan from for the house, it sounds like the HPS, is like, hey, that's our money. You can't be moving that to some other account because that's our collateral. The court's August 13th, 2025 order no legal basis exists for complete fee forfeiture. The court's August 13, 2025 order directing Anderson to retain the $4 million preserve the status quo pending the determination of the merits. It did not resolve whether those funds belonged to Anderson or to the plaintiffs. For the reasons set forth throughout this brief, Anderson is entitled to retain those funds as partial satisfaction of earned fees and advanced costs. Even assuming, arguendo, that some violation of the rules occurred, complete forfeiture of all fees is an extreme remedy that Florida courts do not impose automatically. Under the Searcy-Denny standard, courts evaluate the totality of the circumstances to determine whether the specific egregious misconduct warrants reduction of or forfeiture of earned fees. The alleged violations here are disputed and denied. Even if accepted for the sake of argument, they constitute at most technical or regulatory infractions, not fraud, theft, or intentional wrongdoing rising to the level that would justify the total elimination of compensation for nearly 8 years of successful representation. Florida courts routinely reject complete forfeiture even where ethical violations are found, and instead award compensation under quantum merit. The unprecedented complexity of this litigation, the magnitude of the risks Anderson assumed, and the substantial financial benefit delivered to the plaintiffs all weigh heavily against the draconian remedy of total forfeiture. Anderson respectfully submits that the appropriate course is an evidentiary hearing at which the court can assess the full record under the relevant multi-factor standard and determine whether contractual or equitable or both require evidentiary determination. And in conclusion, for the foregoing reasons, Anderson respectfully requests that the court deny the plaintiff's request for complete forfeiture of all fees from the bridge loan proceeds, schedule an evidentiary hearing at which Anderson may present evidence to rebut the presumption of excessiveness under the rule, and establish the quantum merit value of the services rendered, deny plaintiff's request for distribution of the $4 million in account 5153, and reserve that question pending the outcome of the evidentiary hearing, and grant such other and further relief as the court deems just and equitable. Respectively submitted, Greg Anderson. Wow, let me go look at this attached, Exhibit A. This is an affidavit of Terry Durkham. I, Terry Durkham, do hereby depose and say that I make this affidavit based on personal knowledge and the facts contained herein, and have called to testify at hearing or trial, will testify as follows. I am over the age of 18 and competent to testify to the matters contained herein. The facts set forth in this affidavit are based upon my personal knowledge. I am an accountant, practicing since 1997. I have over 28 years serving as an accountant, primarily for law firms, though also with other professional organizations. I began as a contract accountant for Anderson Glenn LLP, the firm, not related to John Clancy or whatever. In 2010, serving as a primary accountant and completing the work on budgets, accounts receivable, billing, and an overview of financials for the firm. I work on an outside/remote basis, but also work closely with the firm's in-house administrators, including Marietta Case, Jill Petrovich, and recently Jennifer Glass. During the pendency of the Kowalski case, the firm experienced significant financial strain. This was a direct result of substantial upfront costs and litigation expenses advanced by both the firm and Greg Anderson personally. I reviewed the firm's financial ledgers during the Kowalski litigation. The firm advanced substantial out-of-pocket litigation costs for this case. The ledgers show the firm ran monthly financial deficits to sustain these costs. The firm carried this debt through 2024. The firm funded these advances using its commercial lines of credit. These commercial lines of credit were secured by Greg Anderson's personal stocks and bonds. In May 2024, the firm received proceeds from the Kowalski bridge loan. The firm used a portion of these proceeds to pay off its commercial line of credit and fund firm operations. The firm recognized approximately $4 million of these specific funds as fee income on its 2024 financial records. Okay, here they're saying they did take it as fee income on 2024, even though they didn't show it on their taxes. In October 2024, the firm transferred a separate $4 million into a business savings account ending in 5153. I spoke directly to the firm's certified public accountant regarding the tax treatment of this specific $4 million. The CPA noted that the 2024 tax returns were already completed. The CPA instructed me to record this $4 million as fee income in January 2025 rather than modifying the 2024 tax records. Whoa! It's okay, we'll just fix it on the next one. Who's the CPA? Who's the CPA? Oops, we found a $4 million error on your return. It's all right, we'll just add it to next year's numbers and call it good. I don't think the IRS looks happily at this type of behavior. It's like, oh, as long as, over the next 10 years or so, it all evens out. It's a wash and we're good. That's not how audits work. I followed this professional advice. I entered the transaction fee as income for the 2025 financial year. The corresponding tax liability for this $4 million will be satisfied in the 2025 tax cycle. Further affiant saith not. Whoa. Okay, that part got me. Who is the CPA? It's like, oh man, I already had your papers done. Just put it on next year's, okay? I don't want to redo the math. I don't want to open up QuickBooks again. Man, I've got to get in Quicken. I have to log into TurboTax again and change the number. Man, just put it on next year's. That blows my mind. I'm a little guy, right? I'm a little guy on in the world of taxes, and it blows my mind that a CPA would be like, oh man, $4 million, just add it next year, put it in January, and just call it good. It was October, so it's just you held it for a few months, and then cashed the check. Whoa, especially when there's bank records showing that you used it. Oh my goodness. All right, that being said, we're back to court watch right here. Nothing has happened in all the time. That's not how taxes work. It's not how taxes work, I'm telling you. Okay, let's see where are we at? I need that turned off so we can see. Let's turn off cam 1. And box 2 is the counter. That's going to stay on. Box 4 has to go back to camera 2. And now we can take this. There we go. Now we have our timer back. 2 hours, 48 minutes, 48 seconds on the clock for the jury and deliberation. Those of you who selected under 2 hours, you were wrong. I'm sorry. I shouldn't have made that option. It never comes in under 2 hours. It never does. I think from now on, we should do 2 to 4 hours is the first, or 0 to 4 hours is the first option. Oh my goodness. Forget it. We'll fix it in post. We'll do it live. Thanks for sticking with me through reading that. That was fantastic. There's a short response, 6 pages. Check your emails again. I got an email from Red, but it didn't have any attachments on it. Is that what you're talking about? I was looking at, that was from Greeners that I got that one. Oh, here's the plaintiff's response to Anderson. By short response, it's only 6 pages. Give us a second here. All right. Oh, yeah. Super source, box source. 4 is 5. Oh, I hate this. I hate this part. Hang on. Open with. Let's do preview. Boom, boom, boom. There we go. And we'll view this as continuous view. All right, here's a short response. Plaintiff's reply. This is Maya's team responding to what Greg just wrote and we just read. And the font is different. Okay, we'll handle it. Plaintiff's reply to the Anderson party's response regarding legal issues relating to the disposition of the advanced funding loan. Plaintiffs submit this brief reply to the Anderson party's response to plaintiff's brief on legal issues for 4 purposes. 1, to emphasize the absence of any legal authority cited by the Anderson parties on the most critical issue in the case. You neglected to address the elephant in the room, they say. 2, to highlight a key admission on the response. Oh, you confessed to something? 3, to respond to a factual assertion in the response. We contest the facts. One of us is lying. And 4, to address the disposition of the $4 million being held in account 5153. All right, number 1, lack of legal authority. The most important legal issue raised in plaintiff's brief at page 14 is that Florida attorneys are prohibited from participating in advanced funding litigation loans by 3 Florida bar ethics opinions. The rule and a decision from the Florida Supreme Court. Accordingly, Anderson parties are prohibited, as a matter of law, from taking attorney's fees from proceeds of the advanced funding loan. In addition to these legal authorities, plaintiffs also cited the opinion of expert Gary Lesser, a former president of the Florida Bar and former chair of the Professional Ethics Committee with decades of experience representing plaintiffs in personal injury cases, who explained that because Florida attorneys are not even allowed to participate in advanced funding loan arrangements, they certainly cannot take fees based on the amount of the loan proceeds or from the loan proceeds which do not constitute a recovery, as Anderson himself has admitted. Mr. Lesser also stated, I've never seen an attorney take fees on an advance funding loan transaction because doing so is patently unethical. The Anderson parties addressed this issue on page 15 through 18 of their response without citing any relevant legal authority or expert opinion to the contrary. The only legal authority cited by Anderson parties is the Florida Bar v. Taylor, in which the court held that attorneys' gifts of $200 and used clothing to a client did not violate the rules of professional conduct. The Taylor case does not even involve an advance funding loan and has no bearing on the present case. The admission they made in argument number 3 of the plaintiff's brief, the plaintiffs explained that the advanced funding loan proceeds do not constitute a recovery under the express terms of the fee agreements. While on page 18 of the response, the Anderson parties admit that their work structuring the bridge loan fell outside the scope of contingency fee agreements entirely. They didn't connect the dots there for me. Not knowing what the contingency fee agreement was, I'm not sure what the impact of that is. Okay, I get it. Whoa. It fell. They're saying it doesn't constitute a recovery under the terms of the fee agreements because the bridge loan wasn't covered under the fee agreements. And if it wasn't covered in the fee agreements, we can't take fees out of it. We can't we can't get paid from that. Factual issue. That could be a problem. Factual issue. In paragraph 13 of their response, the Anderson parties indicate that the plaintiffs were represented by multiple attorneys in an advanced funding loan transaction. However, previously, the Anderson parties filed an affidavit of Jack Kowalski, in which Mr. Kowalski testified, "We have communicated virtually exclusively with Greg and Jennifer Anderson on the post-trial matters, the appeal, and the handling of any of our financial matters." About the $4 million in the account number 5153. A critically important issue is this case involves the disposition of the $4 million of the loan proceeds currently being held in an account ending in 5153 at Hancock Whitney Bank. Plaintiffs addressed this issue on page 29 of their brief, and the Anderson parties address it on pages 8, 9, 26, and 27 of their response as well. We're missing a comma. As well as an affidavit of Terry Durkham. It is undisputed that the $4 million is part of the loan proceeds, as explained in the letter dated August 4th, 2025, from an attorney who represented Anderson Glenn at that time. And the Anderson parties do not dispute this basic fact in their response. Rather, the Anderson parties argue in paragraph 72 of their response that in December 2024, Anderson pledged the funds in account 5153 as specific collateral for a personal line of credit in connection with the purchase of a home. This act constituted an unequivocal exercise of dominion and control over the funds. Such an exercise of dominion is inconsistent with the treatment of funds as client property held in trust and is probative evidence that the funds have been earned and appropriated as fees prior to the security orders. That was Mr. Anderson's claim. While Anderson parties contend that their exercise of dominion and control over the funds somehow establishes their right to keep them, the plaintiffs contend that these acts constitute conversion of trust funds. Conversion is not a good thing when we're talking about it in the legal sense. As explained in footnote 10 on page 29 of the plaintiff's brief, Craig Anderson assured Jack Kowalski that those funds were being held in trust on December 20th, 2024, which is after the Kowalskis had discharged the Anderson parties as their attorneys. The critically important points concerning the $4 million in account 5153 are that 1, those funds constitute part of the advance funding loan proceeds, and 2, the Anderson parties' claim to those funds is based on their theory that they were entitled to receive a fee for obtaining and structuring the advance funding loan. As explained in the plaintiff's briefs, the Anderson parties have no right to take fees from loan proceeds. Thus, it is legally irrelevant whether the Anderson parties exercise dominion and control over the funds. The Anderson parties have no right to keep any of the loan proceeds for legal fees, and they have no right to continue using the $4 million as collateral for a personal line of credit in connection with the purchase of a home, where the funds are being used for the exclusive benefit of Anderson parties rather than for the benefit of the Kowalskis, who are the sole borrowers of the funds. Conclusion. Plaintiffs respectively submit that nothing in the response filed by Anderson parties alters or changes the position of the plaintiffs. Accordingly, the plaintiffs respectively ask the court to grant the relief requested in pages 28 through 30 of their brief. If the judge agrees with them, to date the plaintiffs are permitted to engage in very little limited discovery, but they have received documents relating to the account. These documents were produced pursuant to a confidentiality agreement, and they will be provided to the court in camera. These documents show very clearly how account 5153 with $4 million is being used to benefit the Anderson parties. All right. And then we have this is the worst part about all this. The certificate of service, because this is involved in this case, because this is a matter in this J. Hatch Kowalski case, copies of all this fighting back and forth are sent to Nick Whitney, Ethan Shapiro, David Hughes, Mandy Carvis, Hill Ward Henderson. You've got all of Johns Hopkins attorneys there. You've got Anderson Glenn on there. Man. You've got the attorneys for Maya, co-counsel. Attorneys for Ambridge Partners, LLC. Underwriting represented for certain insurers. That's related to the loan, I believe. You've got co-counsel for the plaintiff there. Yeah, the J. Hatch is laughing all the way to the bank on this one. They're just chortling in their shorts, I think. Is that something you can do? All right. Takes us to 3 hours on the verdict watch. Let's see where our text. Where did our chat go? We lost it. We'll bring it back. Some good light reading there. Hopefully some of you got a little bit of a nap during that. Thanks for the jewels and things that were sent during that. I could eat some cake. Lemon pound cake. Cut you a slice. Let's see. We should have a verdict by now, says Texas Brand. It is 3:25 jury time, right? They do have a little bit more time to deliberate today before they're done. Have you heard about Oswego, New York, TikTok, DoorDash girl case? My husband asking if you're going to cover it. Tell me more details. First of all, New York is a tough one. New York is not one we are easily able to get access to. I can't think of the last case we covered out of New York. They have 1 hour or else. Okay, y'all, it's safe to come back to the audio. What was it terrible? Was my audio terrible? You just didn't want to hear the reading? Three hours right there. I was enthralled. Legalese is always... I tell you, I really enjoy reading Greg Anderson's filings. Mostly because I think he's a smart man as far as like knowledge goes. He's a good writer, and he doesn't write way over my head. Oswego. No verdict yet, Tiffany. We're still holding out here. It's been 3 hours. Paula says, maybe it's just me. I'm over Maya's case. Don't come after me, folks. It was a long one. It was a very long one. They wanted my palate cleanser. Let's see what we have here. Josh, just 1 second. Got to scroll back through a lot of texts here. It's 84th District. Let's see if I can find it here. '84th District. 3638. We've got 3646. You said to start at 12. 1329. Is that right? Start at 1210. Okay, we've got a palate cleanser courtesy of Josh. Give me just a second to get this pulled up for you. But get some audio here.
This is case number 26819FY. Ms. Dull appears on behalf of the people. Mr. Leffers appears in the courtroom but refuses to enter the well. I do remember this from the last time we were here last week. The court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right?
Your Honor, is the court going to reset the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments under the United States Constitution. What say you, sir?
Was that a paper shredder?
I addressed you last week about about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case, which once again is why Article 3, Section 2, Clause 2 of the Constitution exists. The state cannot prosecute this because it always going to rule in favor of itself. That's the law. Also, discovery hasn't been met because I was never given a full accounting about the bond relationship, any accounting on the bid bonds, performance bonds. And I am not a 14th Amendment citizen. I am a Michiganian, state national.
I'm a Michiganian state national.
I have corrected my status. I have spent a year doing it.
What do you mean by that? No, you tell me what you mean by that. I don't need you to look at paperwork. You said you corrected your status, so what do you mean by that?
Upon finding out about jurisdictions, 14th Amendment citizen is bound by your jurisdiction, sir. I am not a 14th Amendment citizen.
What are you?
I'm an American state national.
And what is that?
That is a man or woman born to the state in the territories of the Confederation of the Republic that made up this wonderful place and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the U.S. Constitution.
No, sir. This predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Great question.
In the First Amendment, we are one. This is my wife, Jelaine. She's been with me for 24 wonderful years. She has had my back. She has helped me grow and understand and overstand so many wonderful things.
Understand and overstand.
People do not get to have it their way.
The Constitution is set up to protect rights. And I have the right to use everything at my disposal. The Constitution is at my disposal, in addition to the supreme law of the land. So is the Bill of Rights. Not to be in dishonor.
How does the Michigan Constitution play against the U.S. Constitution?
The Michigan Constitution, as wonderful as it may be, is not a Constitution. The corruptness that went into it
is corrupt.
Destroyed it. Though it may hold some lingering truth, if you change 10% of 100% of the story, you have deceived everyone that you tell that story to thereafter. And they will never be able to defend themselves properly. They will never know how to manage themselves properly. If the truth was to be told, then the decision, the rightful will choice would fall on the people. And I am one of the people. Which is why there's also another conflict of interest. The state cannot prosecute me because I am the people. So is my wife, and so are our children.
We are the people.
So it's your
Courtney Arleo, welcome.
Belief that the state cannot prosecute criminal laws against its citizens. But if you were a citizen of Texas and violated a Michigan law, would the court then be able, or would the state of Michigan then be able to prosecute that person?
State of Michigan. The Texas.
No, hold on. It's Mr. Leffers is the one who has.
Well, as I stated,
we are one in our
First Amendment right.
Okay.
We are one. You ask a question.
Mr. Leffers is the one who's before the court. Mr. Leffers is the one who gets to speak on the record.
That would be against my First Amendment right.
Okay, I can see how this is going to go.
It'll hold you in contempt.
Mr. Leffers, you are not releasing any rights that you have, but we're going to reset this then for another probable cause conference next week. And hopefully by then we will have counsel appointed for you and you can discuss your issues with your appointed attorney.
So I do not accept. Also, I am here on special.
All right, Mr. Leffers,
in the case.
Mr. Leffers, you need to stop. All right.
I'm here by special appearance.
I need you to go out to the front window where you checked in. Get a copy of your next court date. Because I'm not going to allow you to interrupt the business of the court. And as you can see, you're getting pretty close to that. I'm not saying that you're wrong. I'm not saying that you're right. I'm just saying, again, this is not the forum That's not what we're here for today. There's a procedure to go through for motions to be filed and to be heard. And as I said, I've appointed counsel, even though that hasn't happened yet, to make sure that you are fully apprised of all the options, the way the court works, the way the laws interact with each other.
He doesn't want counsel.
And I highly encourage you to listen to that counsel, that attorney, once they're appointed. You're not the first one to have this situation before the court. You're not the first one to assert these rights. But
you would be the first one to win.
There's a way that things work, and your grasp of it right now, I believe that you are mistaken in how the laws interact with each other and how the constitutions interact with each other, how jurisdiction works. So once again, I'm going to ask you to go out to the front window where you checked in. I understand you're not waiving any of your rights, but I'm going to ask you to go to the front window where you checked in and get your next court date, and then we will have, again, we will continue working on getting counsel appointed for you.
Judge asked, it's going to be well. Nope. Rather go yourself. It's going to be okay. Thank you, sir.
Thank you.
Have a nice day.
You too.
Have a nice day. You and your wife.
Yeah, well.
He refused to come into the well, so we couldn't see him on camera. But we get some of those occasionally with you think they found something on the internet that gives them a way to escape the consequences for the crime they have committed. or sometimes the financial debt they have incurred. It doesn't work that way. It just really doesn't. Going back to court. There's we wait. Turn off camera 1. There we go. The patience of that judge to actually entertain, not just listen to his argument and let him ramble, but to then engage him on an intellectual basis and saying, okay, so you're saying that the state of Michigan can't prosecute members of its, citizens within its boundaries. What if it was somebody from Texas? Can Michigan prosecute them? He's maybe. Oh. You guys want to see what Middleton's courtroom looks like now? Let's see if we can find that here. Judge Jeffrey Middleton. Judge Middleton has this is a test run. Let's go to this really quickly. We're going to be on 6. This is his new courtroom, and he's not in his judge outfit right now. He's wearing his New Balance hoodie, got his sunglasses on. The flags are leaning in the corner, but that's the background. This is the new courtroom he came back to.
I think we're live.
Yeah, Judge, we are.
I'm not sure.
That chair does not look comfortable. Looks like it was built in the 1800s.
I think we're live. I'm not sure.
If we can get one more echo, then we'll know we're live. His new courtroom. It looks like the inside of a psychedelic yurt. I don't know how else to describe
Apparently we are. Came in early from vacation to test this out before
don't know where he went, but he caught some sun.
we go live tomorrow morning. We have a full docket tomorrow morning. The bailiff said, hey, look at this. Got a lot to do. Yes, the angles here are odd and peculiar. That's hand-painted stenciling that was done when they refurbished this courtroom. Cameras are at an odd angle. There's no Michigan seal. But we're here. We will start tomorrow morning.
You don't have your Admiralty flag either, Judge.
And gonna go check out my office, see if they got that set up correctly. Anyway, it looks like this works. Had a wonderful 10 days in Siesta Key, building sandcastles. Be back tomorrow. Humbled that all these people are clicking into this. I was just checking it out. All right, it looks like it works. We'll see everybody in the morning, and you get this kind of a tan sitting in the sand, chasing small mermaids and building sandcastles.
There you go, Judge. Thanks for the great advice there. All right, now we're back to court. So that's his new courtroom. He got a new courtroom because his old courtroom, which he's been in for decades, is being renovated, and the chalkboard's going to be gone. That terrible wood paneling is going to be gone. They're going to redo it, and in the meantime, he's moved over to the old courthouse where they've set up this courtroom, which was renovated previously, sometime in the 20s or 50s. I don't know when. And so now that's what he'll have, possibly until the end of his term. I don't know if they're going to finish the renovation before he's done with his term. So what happens at the beach stays at the beach. He's a great judge. We're going to miss him for sure as he's finishing up his last little bit. All right. Can't see him. I'm guessing he's dressed like a pilgrim. He was in like a New Balance quarter zip hoodie and sunglasses. So definitely not judicial robes by any means. Courthouse opened in 1978. Yeah, I was just being a little facetious with the dates, the 20s and the 50s. It just looks very out of style. But we've come to love it. All right, yesterday the judge told the jurors to set up life things in preparation for deliberations. Does that mean they can go beyond 5 p.m.? Caroline Taterville, yes, but we don't know how much further beyond 5. The judge said it could be a very long night. Depends how things go. And I think that depends part is on the hands of the jury. The jury gets to choose how late they want to deliberate. They'll probably be asked around dinner time if they like the options of food that the judge is providing for them, if they'd like him to choose their dinner, or if they'd like to go home and try again tomorrow. So we'll probably have, let's see, right now it's 3:47 right now. Probably around 4:30 or 5 o'clock, they'll probably consult with the jury and see what they want to do. The jury's wearing Depends. They might be. They could go into the evening. I think it's very likely. What's the longest deliberation you've seen? Oh man, I wish I had tracked these for all the cases we followed. Sorry, I'm running over cables with my chair, and that's never a good thing. I don't know what the longest one is. Days and days. I don't think we've gone over a week in deliberations with anything we're following. Is RI wearing Depends for these long streams? Not a sponsor. No. I was just blessed with superhuman abilities in some areas. Any juror questions? There may be questions, but if there are, we have not been notified. That's the best I can tell you. The judge said if we get a question, I'm going to call you guys at your office, talking to the counsel. And if it's something you need to come in and talk about, we can. Otherwise, we'll just handle it over the phone. So I'm not holding my breath for the judge to actually give us much information on this. Get that little period off the screen. There we go. All right. Mr. Poll, what were the results? Most of us think it's going to be either today or tomorrow morning as far as a verdict, Smiley. Are they going to want whiteboard markers? and hopefully a lot of Post-it notes, maybe some binders and some string and tape and scissors. 63% for 2.5 hours. 2 to 4 hours. Yeah, over half of us are in our last hour for a pick. I didn't really pick one, but I do always tend to think it will be fast. Thank you, Red Pen, for the exact results on the poll. There it is. How long would the jury deliberate? 2 to 4 hours was 65%. Sleep on it, 20%. Under 2 hours, 12%. And I could use another lunch. That's 3%. That particular poll only really going through lunchtime tomorrow. Matthew Paul. Oh, man, I'm trying to remember who that was. Sounds somewhat familiar, but some of the cases just run together in my mind. I will say this, because we have a lot of new people with us on this Verdict Watch. We have a tradition on Verdict Watch where as soon as we know that a verdict has been reached in a trial, we play what we call verdict music. And it's not a celebration of the decision itself as far as which direction they went, so much as it's just getting people's attention. We have a lot of people who watch while they lurk, or maybe in another room of the house, and have this going in the background. And it's just to let people know that this is the moment that sort of they've been watching this trial for, to see what the conclusion is. So we have verdict music, and it's a upbeat song that we only play when there is a verdict. And it's just, we try to just play it the one time. And hang on a second. There we go. Anyway, verdict music is a thing, so don't be surprised when you hear that. That's your indication that that's the moment that I heard that we have a verdict in the case. And it could happen as early as half an hour or so before a verdict is actually read, depending on how long the judge waits for people to arrive in the courtroom for the actual reading of the verdict. So it's not meant in any way to detract from the solemnity of the proceedings, the legal proceedings. It's just our way to let everybody know that a verdict has been reached. The verdict music is a very important part of my life. It does bring closure. It's almost like you can't be done watching a case until you have that to bookend the tail end. Can we hear a song, Gray's the New Green? We might do some songs. Gray's the New Green is a good one. Your DJ skills are impeccable, sir. I've just got these colored buttons to push. We can do Gray's the New Green. You guys know I've loved music. I play the guitar. I've written some songs back when I was going back all the way out to like high school. I liked writing songs, both lyrics and music, and done a little bit of singing here and there, national anthems at festivals and things like that, and so it was only natural to bring in a little bit of singing into court watching, and we try to do that in a respectful way. But sometimes there's just something that happens in court that's just funny, that's just too good to not etch into the halls of history with song. And so we do write a few songs occasionally to celebrate things that happen either on the channel or in court cases as well. So I have some songs that are pretty good. Like this particular trial, we came up with a song called After Sushi because they asked what happens after sushi, and I thought that was a great question to have as the title of a song. We had, from the Hawaii trial, we had a song about the hole in the bush, which is probably one of the more risque songs we've ever had. We've got one called What Not to Search For, which is about Google search history. Daisy in the Walls. That's probably one of my favorite songs. And then one specific just to the channel, which is called Gray's the New Green. And Gray's the New Green is just a song about the fact that as we're all sitting here in chat, you can see the names. Some are green, some are blue, some are gray. The green ones are members on the channel. They're either were gifted a membership or they purchased one themselves. The blue ones are moderators who I can't thank them enough for what they do. And the gray ones, Grandpa's OnlyFans, that was a fun song too. The gray ones are everybody else who's just a wonderful member of the channel who, for some reason, has dodged the gifted membership, or is just a lurker or something like that. So we'll play gray as the new green one time as we wait for this verdict here.
In the land of pixels, here we meet. Gray's the color of our simple seats. No flashy lights, no fancy scheme. It's low-key love in a cyber dream. Slow-mo life, we're taking it easy. Calm in the chat, everything looks breezy. No golden throne, no crown on screen, yet still I feel like royalty unseen. Gray is the new green, don't you know? In the digital glow, we take it slow. No need for emojis or special code. We're riding high on this mellow road. Gifted green lights up the scene. A ticket to a world unseen. But here in gray, we find our creed. No extra flair, just what we need. No temp seats, no quick retreats, just hanging out in these cyber streets. Gray dust clouds, our silent beam, a hidden treasure in the live stream. Gray is the new green, don't you know? In the digital glow, we take it slow. No need for emojis or special code. We're riding high on this mellow road.
There you go. And a flood of green memberships coming in from so many generous people during that song, Gray's the New Green. Thank you for your generosity. Thanks to everybody who's here, both gray or green. We appreciate all of you and for the what you bring to this channel and make it what it is. So Pam Graham says, "Already wrote that one for me." So we've got a couple. Thank you, Greeners, by the way. He said he sent some fireworks or something. Oh, there they are. A fireworks show. Greeners, a headliner. Thank you, my friend. Appreciate it. Missy Pants, thank you as well. All right. Anyway, we do have a couple songs that we play. We try not to do too much during a court session itself. Obviously, we're all here to watch court. Okay, we love court. I love that I can bring you trials like this without interruption and just try to bring you the best audio and the best watching experience I can. That's what I'm all about, right? I don't have the sharpest legal mind on YouTube, and I definitely don't have the most experience in this, but I do have a little bit of tech know-how, and in the breaks where we like to have a little bit of fun, we let our hair down a little bit and play some songs. So, let's see, rained memberships there. That was crazy. That was a bunch of memberships. I guess we should warn people about tomorrow as well. If you've never been here before, tomorrow morning is not a good day to wear headphones, at least first thing in the morning. Wednesday is hump day, and hump day deserves a hump day yell. And we do that every Wednesday. So if you want to be here for that, be here early. We might still be in jury watch. It's possible, in verdict watch. Duke says, love this channel. Thank you, everyone, for making this the best one on YouTube. Duke, 24 months. OG. You are the original GOAT. Thank you very much, Duke. Appreciate your support. I rarely repeat the hump day yell. It's usually only once a day. But there was the one time when I was in a hotel on vacation and the fire alarm went off and I had to do the hump day yell outside with holding my phone, and you guys said that it didn't work. I still haven't gone back to watch to see if it actually worked or not, but you made me do it again. And like the firefighters are running around and all the hotel people are out there, all the guests of the hotel. I'm out there yelling in the parking lot. I'm surprised I didn't get arrested on that one. I forget what town I was in on that. I don't know where we were, but it was funny. Anyway, good times. If you do like music like that, some of the songs we actually wrote all the lyrics for ourselves. Some of the songs, I have a song or two on there I actually wrote the music and the lyrics. Some are created with the help of a helpful computer. But you're able to find all of our public songs on our Top Mark Media page, or you could go directly to Suno, where we create these songs, and you can find a whole list of fun songs. My personal preference, I'd say Daisy in the Walls is a great one. That's about the trial. Well, I can't say it's about the trial. It was inspired by a trial where a woman became pregnant in jail by another inmate who she never met. So the air vent is featured prominently there. That's a fun one. Would love a mod song. Can I write it? No. I don't know where the mods want to go with that. We might look into that. Let's see. Click on your profile. Go to Google account. That's for somebody else. Mamau, welcome to the gallery. I'm sorry. Mamau 992, welcome to the gallery. Thank you very much. 16 months. It would go something like this. Use the birthday form. Dang it. Mods already have a song. That's the I Quit song, right? It's basically my version of Take This Job and Shove It. I think, Amber, that's the one we made for you guys. Darlene is making lemon pound cake today. Hope it's delicious. Mabe says, okay, I'm doing it. Membership bound. Mabe, thank you very much. Appreciate it. Let's see. Crazy Mary Joe, parachuting in and out. Welcome. Thanks for saying hi while you're here. Still confused about the wall, baby. Thought air diffused the fish. Okay, Cass, if we have to go into the details, maybe I should play the song. If we play Daisy in the Walls for you, it might clear it up, because I'm just going to get embarrassed trying to explain it. That case was a tricky one. The actual case itself was just a murder trial. It had nothing to do with the fact that she got pregnant in jail after she was arrested. So, Daisy in the Walls. Rather you explain. Whoa, that's not the right one. Pause. That was Sovereign Blues. Let's do this one here. Daisy in the Walls by popular demand.
Through the cracks in the stone, I heard your voice, a whisper in the dark, no other choice. Metal bars can't cage the dreams we spin. The air vent carried you, and I let you understand this kind of fire in a concrete tube. We built our empire. Daisy in the walls, reaching through the night. Planet in the shadows, growing toward the light. They'll call it madness, but it's just our way. Daisy in the walls, blooming every day. Your letters came in secret, folded tight. Promises of freedom under the moonlight. A strange kind of love, but it felt so real. Through the vent, your touch was all I could feel. They say I'm a sinner, they say I'm a thief, but in this gray box, love's my only belief. A package of hope in a world so grim. Life from the void, I carry him. Daisy in the walls, reaching through the night. Planet in the shadows, growing toward the light. They'll call it madness, but it's just our way. Daisy in the walls, blooming every day.
Daisy in the walls. All right, we're done playing songs. I don't want to make this a music stream. Suno was a lot of fun. We have some fun with that, and it helps us remember some of the cases and some of the fun moments we've shared together, and some of the harder moments, honestly, that we've shared together as we've followed a lot of trials together over the. It feels strange to say this, over the years. Let me just tell you a little bit. Let's see if I can find the numbers here. I think we're getting close to 1,800 live streams. Let's see. I know we've had over 16.6 million views, with an average view duration of over 40 minutes, which is unheard of. Just crazy. Wow. All right. Red Pen, thanks for the gifted memberships as well. And look, Tisha, you got hit. You got hit. You were just saying, Tisha, that you said to Red Pen, I've been gray so long. Red Pen gifts 5 memberships, and boom, you got received a gifted membership. That's about as targeted a strike as you can get. That's a precision gift strike. I vote for Big Dill that started it all. Big Dill is probably the only other song I'd be willing to play today. It has a funny funny little history to it. Let's see if I can find it here. There it is. Big Dill was a song we wrote after we were watching a court case in Georgia in Judge McBurney's trial. And this was a trial that heavily featured two gangsters and gang activity. This was a home invasion robbery. And it was crazy. And we spent almost an entire day learning about the colors the gangs used and the flags and the signs and the symbols and the songs and the rappers and how music in general was tied up in the entire gang culture. And by the end of the day, all of us were gang experts. And I said, at this point, all we need to do is basically form our own gang. We know how to do it now. We've learned through going to court how to make our own gang. And gangs, of course, use rap music as their music of choice. And I realize a lot of you might not be a big fan of rap, but hear me out. I wrote a song just for the channel. I wrote all the lyrics myself. The lyrics were not created by, I might have had a little bit of help from some members as well. But the lyrics were not created by AI. The rendition, the singing of it was created by AI. So this one is called Big Deal because on the channel, we like to say pickles, not politics, because we can always find reasons to fight about politics, and so we prefer pickles instead, which most people like. The sane ones anyway. A few of you don't, but so we had our little sayings. The RA gang. It was fun. Anyway, so because it's pickles, not politics. My gang name was going to be Big Dill, like a pickle, Big Dill pickle, and this is the song that ensued. And of course it's not working. Hold please. Let me find it over here. All right, I think it's going to be this one. I think it's this one right here. Let's give it a try. Yeah, I've got a phone call. Let's take the phone call first and then the song.
Call from Meg Osborne.
Meg, are you here for the Big Deal song?
Kind of, not really.
I was about to play it. What's on your mind?
I know, I'm waiting for it. But listen, I tried to call the other day because I forgot to tell everybody in chat. We drive 5,000 miles a month. And you are all I listen to.
Wow.
My husband thinks, how can it be that interesting? I'm like, you have no idea, bro. You have no idea.
That's a lot of
for
miles.
5,000, yeah.
Are you long-haul truckers? What's the...
You would think, but no, we do interior plant stuff, like hotels, basically
so it's
hotels.
You're traveling from job to job. Okay.
From Marco Island to Tampa once a week, we go to each direction. So yeah, I live on RA all day.
Wow, that is awesome. That's awesome. And occasionally you're able to join us in chat. So I'll know that when you do that, you're probably breaking the law with your phone. So,
absolutely, 100%.
We won't
and it
tell
wasn't
anybody.
premeditated.
Meg, that's
so,
awesome.
and also, I'm the one that has a son that's constantly deployed.
Right.
So the fact that we finally had another somewhat long trial, I really appreciate you. If you could keep that going, I'd appreciate you more, please.
I do like some long trials. They're really fun, especially if they're fun to get into. I like them to last. It's almost like you don't want them to end a little bit just because you're starting to really understand the players and, somebody gets in and you're like, oh, I know who this is. I've been waiting for that. I like that part. So, all right.
Very
Meg.
true. But the music is epic. Come on.
We might get it tonight. There's still a chance. All right,
I'm
Meg,
praying. All right, let's go play our song.
Big Deal. Here it comes. Thanks, Meg. We'll see you.
Big Deal.
Right,
Bye.
bye. All right, here we go. This is going to be, this is the Big Deal song. Give me a second. Songs. Why is it not? It just doesn't like me today. Let's see. It is 2 minutes long. That's the one. Whoa. That's not it. Can't find the right version. This is driving me nuts. Okay, let's try this one. Send it to the MacBook Air. Show in Finder. And let's play that one.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise and pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a bead. Take the stand and the jury chooses not to believe. Because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're the good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
There you go. There's our rap song, Big Deal. Took a minute to find that one. I haven't played it in a while. This one bumps. It's a good one. All right, Pickle Posse unite. There we go. Now we're done. All right, what fun we've had today. We're coming up on 4 hours of jury deliberation time. And yeah, we have some fun times here. Anyway, 4 hours, that seems like it's enough time to reach a verdict in this case for some of us. Tammy Lee says, keep me in your thoughts tomorrow as I go to my second heart cath in 2 weeks. Kathy, sorry, not Kathy, Kath. Heart cath, Tammy Lee, we definitely will. Our thoughts and prayers will be with you as that goes on. Thanks for letting us know, and do when it's all done and in hindsight, and you can say, "Yay, that's done," and everything was great. Let us know as well, because we'd like to celebrate with you then. Let's see. What was the case about the inmate getting pregnant in jail? Very curious about that one. That was Daisy Link was the defendant. And the case was it was a murder trial where her ex showed up. It was outside the house and banging on the door, and there was a broken window, and he had tried to break in, and she had a gun and went outside, and basically there's a encounter outside where she shot him, and she's like, "Oh, you're fine. You're just acting up." Well, he died, and there's some video from the outside of what went down, and the jury said murder on that one, but that conviction was overturned.
From
Allison.
Hey, Allison, this is RA. How are you doing?
Down because I don't know when I call.
Hello.
Simultaneously call.
Can you hear me?
I can hear you now.
Is that better?
That's tons better. Now I can really hear you.
Okay,
What are you saying?
I can call tomorrow if you're about to shut it down. I didn't know because I can't, I don't have to like not listen to you and get on the phone and call you.
Yeah, it's fine.
I don't know if we shut it down.
We're going to
it took me
stick
a few
here
minutes.
until the jury gets excused for the day or until the live stream shuts off, whichever happens first. But what's on your mind?
Okay, so this trial, I had a new experience. I usually listen to you or, other trials that you may not be covering, like Emily.
Yeah.
And in the background, I'm doing stuff around the house and stuff. And I always thought she'd say she's taking notes. And I go, why would anybody take notes? This trial, I tuned into you yesterday. And I'm like, let me see that daughter. And she kind of weirded me out. Like, it was a different thing. It was just weird. And I didn't watch her whole testimony. And I fast forwarded and kind of looked at day 3. And I think that's when they were doing the videos of the yard when they pulled him out of the house. And and then the interviews in the interview room. And I got on this, my mother's bipolar. And sometimes, like every other year, I kind of wander in that vague area. And I got into a whole rabbit hole with this because I thought I was being punked. I thought we were all being punked by this trial because the people were so weird. They're like synthetic. I'm not trying to be weird on purpose. I'm saying just my brain kept going to one thing after another, like extreme. And at the end, I thought, this isn't real. Like it is, but it's not. Like it's a mockumentary type thing. It could be like Best in Show or The Office.
Someone's going to jump out from behind the judge's desk and be like, surprise, gotcha. You're on candid camera.
Right. So I'm not saying it's like a different reality. I'm saying these people are just, they're so bizarre to me. Like the little things, they're like, I think thought they were smart enough to get away with whatever, like the bad planning and bad cover up. But their whole MO is, like they talked about it once and said, whatever you do, don't make eye contact when someone's talking to you. Be real still, minimize yourself, and do short answers. Do not give anything up, and blurt out like disjointed half sentences.
Keep it simple.
It's just bizarre.
Yeah.
They're like weird looking, and I thought, no way. It just went on and on and on. I thought
it's not just you.
Maybe something.
It's not just you. Look at that interview that Tracey did the first time she was there. Well, she was only there for a little while, and the cop's already like, look, I've got to tell you, I'm getting this vibe that you know more than you're letting on here. This just doesn't feel right. And this is an officer who's familiar with, interrogations and everything. He's like, this just isn't normal here. My spidey sense is tingling with you guys.
Right. And so what I did, and I didn't mention this, I'm looking out. I got so pulled into this, I couldn't stand it because I think it's so obvious. It's so obvious. And when you're listening to it, I didn't listen to every single thing. When you're listening to them, I'm thinking first I thought, are they that arrogant? Do you think we believe them? They could do this? And I think, no, I think they're not that sharp. And they didn't plan, it's a mixture of the two. It's weird. And so I watched the interrogation and I'm like, what? I can't hear because he's not very good at it, the cop. Mm-hmm. And he's talking over her, giving her multiple choice, going, yeah, gotcha. Believe me, I'm telling you this because what I'm looking at, I got so pulled into it. I went and I went to law and crime, and I know I sound like manic or something, but I have to get it. When I stop talking to you, it's done. Mm-hmm. I have a printout of the transcript of day 3. I was highlighting the prosecutor during school. I said, ooh, I already did that with this. Mm-hmm. And so everything, I couldn't understand what Tracey was saying. And the way they were acting in the front yard, it was childish. And they would only start acting upset or it was like they were at the principal's office outside waiting to be called in.
Yeah, it was.
And they're trying
strange.
not to. It was.
I don't know what's
strange,
going on. Don't say anything. That's just
it was
weird
she said it out
moment.
loud. Right. And so the cops,
I don't know if they're young or inexperienced or jack of all trades, so they didn't know a lot about one thing. But I don't think they trusted them. But the point is, I wanted to know what she was saying in the room, and then when her hokey attorney came in and cut it down, but there's no. Okay, so here's my conclusion.
Let's hear it.
We're being punked, but not really. I just really think it's a weird thing. And then I'm not being mean, like personally mean to her. She's not that bright. I think, is that a public defender? Because if it is, okay, but if it isn't, I think it's almost unethical that he told her she should go to trial with this. It's weird.
I think it is a public defender. I think it is. It's a strange one. It's strange. And
I've never seen a weirder lawyer than him.
The way he handled it was weird. Like he despised his client and openly throughout the case.
Well, the weirdest thing about him is talking to witnesses like he drove a white van talking to people. But he literally was, all I saw, I didn't watch all of it, it was trying to go at them about not their job, not their job duties, not their performance, but about their job and like, get it straight. That's your job. That's what you did. It wasn't criticizing them. It's really weird what he did. Like strange. The whole. Anyway, I could go on and on, but now I'm letting you go.
My favorite part about this call is that you said that mid-trial you printed out a transcript from court.
I do. I have it. Happened. It's all highlighted like the prosecutor did the thing, and I'm like, uh-oh. Oh, but one thing.
I love that.
A lot of weird synchronicity going on. So you were talking about the AirTags, and I go, oh, yeah. So long time ago, like more than 10 years ago, I don't have AirTags, but I got like the Kickstarter version of it.
Oh, yeah.
But I never used them because they had an app that like nobody really did. That's it. I don't know. I had that in my brain. So I'm letting you go, and I'm going to have to like shake this all off now. But I'll watch for the verdict.
Hopefully verdict music will just let all this just escape from your brain. You'll be able to just move on to the next trial and love it. So, Allison, thanks for the call.
It was just weird. Thanks. Bye.
Bye. Oh, that's funny. Synchronicity is a word I love too. It's a good one. Texas Lawcat, thank you very much for the gifted membership. Looks like we're getting a call.
Call from
Peter.
Peter, this is RA. How are you doing?
Hey, man. How's it going?
It's going absolutely fabulous. How are you doing? We just passed the 4-hour mark on deliberation, so 67% of us were wrong.
Oh, wait. Hold on. I got to turn my TV down.
You can leave it on, and then we'll have two conversations at once, but it's easier for us if you turn it down. Just giving you a hard time, Peter. What's on your mind?
You know, all right, I often have two conversations at once.
That's cool. What are you thinking about today?
Well, I was thinking if she was such a Donald
the Adelson?
an Adelson fan. Did she ever realize that they were all in jail except for two of them?
That's an interesting question. We still have the loopback echo happening. That's causing the delay. But yeah, I don't think she read the end of the story. Like she just found something that she heard the first part and wanted to mirror or learn from their experience, but it didn't work. I mean, this is like a sob sit seeing somebody appear in Judge Simpson's court and saying, yeah, I want to do that. Well, if you wait 2 weeks till the end of all his appearances or whenever he stops appearing in court, it ends up with them losing every time. And she just ignored that part. So it was crazy.
Wait, I'm with you on that echo thing going. All right.
No worries, Peter. Thanks for the call. It's a great idea. Listen to the end of the story before you decide to emulate one of the characters. Just see if you like where it goes. Peter, I'll let you go so you can sort out that echo thing. Yeah.
I'm going to be red tomorrow.
What? You're going to be red?
I think so. I think I'm full.
36 months? That's awesome. I can't wait. Send a really cool super chat, or not super chat, but just an anniversary message. We'll make sure we highlight it. Red Courthouse.
How could I be cool? Oh,
have AI write something for you, like like Tracy's attorney did. I'm sorry. It's a low blow. Peter, congratulations. Can't wait for the message tomorrow.
Okay, talk to you later.
All right, we'll see you. Bye. All right, yeah, the echo got a little confusing there a bit, but yeah, red courthouse is as you see next to Amber's name, like this right here. That's symbolic of 36 plus months of support on the channel, and it starts off blue and works its way through the colors, and so that's huge. That's huge. That means a ton to me. Let's see. This is like RA After Dark. It does get a little loose on jury verdict watch things. Reds are true OGs. Yeah. If my family, me and my 4 sons group text were ever read in court, oh my goodness. You know you've got that one person you text, right? That's like, no one can ever see this. Because although we know it's harmless and everything's above board, the average person just picking up a random exchange on this text chain is going to call the police, right? They're going to call the authorities in a heartbeat on this one. So let's see. AC's Wildflower, congratulations. Pink looks great. If my texts are ever read in court, my goose is cooked. Like Bryce's pants text. Yeah, I guess that's what happens, you know. It happens. Thank you for the butterfly. Loves true crimes. You can see in chat there's a butterfly flying around. Appreciate that. It's a new addition YouTube just gave us. We're not sure if we like it all the way yet, but we're trying it out. We're giving it a fair shake. Hello, little Miss R.A. How are you doing? All right. Texan says, well, I'm on this channel on my phone. I'm on text channel on my TV. Good news, Ari gets 2 likes from me. Thank you. We got another butterfly from Carol Melifont. Thank you, Carol, for the second butterfly. All right. Now what? Now after 4 hours of deliberation, we are officially at 4:30. Court has ended at 4:30 previously in this trial. Like, this has been the time the judge is like, well, let's call it quits for the day because it's 4:30. So, holy cow. Oh, my goodness. Things are being sent all over the place. Let's see, we've got a clapping seal from Katie Bug. Thank you, Katie Bug. A sundae, and this is Katerina. I accidentally called this heart-flavored ice cream, which it's not. It's heart-shaped ice cream. It's an important difference. Distinctions are critical. Use your words. Sunset Seeker sent the laughing disco ball. Thank you very much for those. Do we watch Josh's cleanser? We did. It was very short, Laura. It was a Sovsit who did not appear because he refused to go into the well. He yelled from the gallery, and he's going to make an appearance next week as well. Did you guys, speaking of true crime shows and Hallmark movies and everything else, did you guys see during court the defense attorney made a big deal of pointing out that one of Tracy's daughters was a big fan of true crime, and they watch these podcasts and shows, the murder shows and everything. And he's like, I don't do that because that's my job. You know, this is what I do. So I'm not one of those. You're weird, basically, is how it came across. And then in his closing, he literally said, I've watched enough of those shows to know that, you know, you could have done differently here. This is how the plan would have worked had she planned it out. You can't have it both ways. You can't say I don't watch those shows and then say I watch tons of them. Let's see. Thank you for the gifts. Let's see what this is. Sunshine, beautiful sunshine. Thank you. The points gambling was very invasive. It was. We had to turn it off. Not that we don't. Well, first of all, the channel is called Recovery Addict, and so to support an addictive behavior just didn't fit with the channel. But knowing that that it was just something that was in fun and it was a game, I was okay with it. The problem is it causes chat to scroll like 10 times faster than it currently does. And that was just, it was too fast. All right. Do they have a verdict? By me, not yet, Rebecca. Not yet. But hopefully here soon. Peter says, I never watch. Never. Tomorrow, Peter. Tomorrow you're going to be red, right? That's exciting. Lawyer knows also going to cover the Caleb trial out of Ohio. Yay. That's awesome. If they watch true crime, they learn nothing about evidence. Caleb Flynn. His name keeps escaping me. Thank you, Red Pen. If you tell me enough, I will remember. Tomorrow's the horrible FedEx driver trial. That's a rough one. We did not cover that for reasons, for those very reasons. It's funny. We all like true crime, and you know we can all unite around a good murder trial, but most of us are parents, or have nieces or nephews or something that it's just too hard to sit through a trial like Letitia Staux again. I mean, that was just soul-crushingly heavy to sit through those. So we try not to watch trials like that on this channel. There are occasionally times that we feel it's important to follow a case like that, and it's tough. It's really, really tough. But Caleb Flynn was a contestant on one of those TV show talent shows, and he won the, I can't say golden buzzer or the golden ticket or whatever the prize was to move on to the next round. He won that. But now he's accused of murder. And I think he wants the jury to do a juror view of the scene, sort of like the Alex Murdaugh trial, where the jurors went out to the scene, to the kennels, and went around the property. So that'll be interesting. American Idol golden ticket, that's what it was. Okay. Yeah, so we try to stick to murder trials that are not terrible. Trials involving a lot of SA and children we steer clear of. We hope the RA memorizes golden ticket before the trial starts. You can't blame me, Annis, because I don't have a TV. I've never watched. I've never tuned into an episode of whatever that show is. I don't know. I don't watch those shows. Just like that attorney said today, I don't watch those shows. Trial that was terrible that you made us watch was that disgusting coughing courtroom. Oh, that was so bad. I'm sorry. Can someone explain the points and jewels? Points, the app we have that tracks a lot of the interactions with chat. There are a lot of different ways you can interact with the channel. It awards points for just like saying something every day. It's like, hey, you're here again, you got points. You're here first, you get more points. You gave a membership, whatever, you get points for that. And it just tracks points. They're not worth anything. You can't spend them. It's literally pointless, but it's sort of fun. And so those happen in the background. The jewels are something that YouTube just turned on to sort of be a lot like TikTok and I guess Twitch. It's a sort of a visual gift, and it's like a, depending on which one you give, it can be considered like a micro gift because you can gift penny amounts as opposed to other larger amounts that super chats typically were, over 90, 99 cents or up or something like that. And it enables people to give gifts without breaking the bank. I'm very cool with that. So commands have been broken all afternoon. I turned a lot of them off. I can turn them back on since we are in verdict watch. Let me restart it. Katie Bug, thank you very much for gifting the, what is that, a popsicle hand? Marshmallow High. I was close. Marshmallow High. Okay. You'll see someone was first in chat as soon as the commands are back up. 1, 2, 3, 4, 5. They're back up. All right. So the first person to talk after it's back up, which was Carol. You just got some points, Carol, for being first in chat because you said easy. But unfortunately, easy
Have them send someone with more
didn't work.
experience.
All right. Christina, thank you very much for the sun balloon and another Marshmallow High from Late But Present. Thank you. Thank you. Now points are working. See if we can keep an eye on Twitter now, as we may have somebody in the courtroom that might observe something more than we are seeing. Let's see. I don't think we have any court watchers there from our channel, but there might be somebody from the news media that we can find. No updates yet. I don't think we had any court watchers in this trial. Interesting, because this is a courthouse that a lot of people are familiar with, even nationwide, because this is the same courthouse that the Tyler Robinson hearings have been going on in. So we've had national news media present at this courthouse during this case, because Tyler Robinson had a hearing just this last week. But what time is it there? In the East Coast, it's 6:42. It is 4:42 p.m. in Mountain Time in Utah. Tyler Robinson. Yeah, now imagine everyone checking their points and then gambling their points. It went crazy. If they're staying past 4:30, I wonder if they're close. It's a very good possibility. Fan, I have not been to the post office. Cheryl, thank you very much for the party blowers. That deserves the sound effect too, and I can do that. Trigger that one. Thank you. Bobby Jean, here's a flower for you. Thank you, Bobby Jean. Kelly, thank you very much for the laughing disco ball. I'm learning what the names of these are slowly. Did the judge ask them if they wanted to stay or go? I think he just told them they could stay. Ooh, a power potion. We're powering up. And Greener's gifted a mystery gift, which is a cat, apparently. A cat in the box. Or a dog, I'm not sure. Well, it was probably a cat from the tail. Do you get points for chatting? Yes. You do get points for participating, but I don't know exactly if it's per hour or per day or how that works. So... Man, you guys are finding all these crazy. The goat trophy. Holy cow! I rescue dogs. That's awesome. It's literally a goat trophy. Whoever thought of that one? That is amazing. It's my new favorite. I hope it didn't cost you a lot, but that's cool. Oh, the goat is expensive. Northwest. I rescue dogs. Thank you for the goat trophy. I've never seen that one before. And Kelly, one more time. We had a car called Cost a Lot once. What? I was going to tell you a story this morning. Does anyone remember what it was? I was going to tell you a story, and then court started on it. It didn't happen. Thank you, Posty Smith.
Eden the Wise.
Eden the Wise, how are you doing?
Oh, I'm doing okay. I had a little theory that I could be wrong. But do you think Tracey's defense lawyer thinks that she's guilty? And he's kind of being, he has to represent her, but he comes off as if he doesn't believe her, but he has a job to do.
I don't know. I think she wanted to talk to him. And he's like, "Shut up! Don't tell me! Don't tell me! I want to be able to defend you. I want to defend you."
That theory too. Because when you called and you said, I think they had an argument in the back. He kept saying, "I don't want you to testify," and she just insisted on getting up there to tell her story.
You heard that in his closing, but she wanted to testify. He said that was her decision, not his.
Right. So he's like, okay, but now he's convinced. Now it's like I think he alluded to, maybe she did it,
Well, he did
so
sort of.
I don't know.
He did sort of slip up a little bit while he was saying that Kevin shot an unarmed man, and that was his admission. This is what happened. Kevin shot an unarmed man, and now his client says that the knife was there the whole time. And so the lawyer literally
the case too.
feels that it was unarmed. Man,
right?
I'm trying to I'm trying to follow what you're saying, and chat is putting all these crazy animations on the screen: punch monkeys and turtles drinking from water bottles, girl power, and everything.
Right.
Thank you very much for the call. I do think he probably had his doubts about his client for sure.
Right.
Awesome.
Okay.
Thank you so much. Appreciate it. Bye. It is 4:20 on 421. Yesterday was 420. Thank you, Katrina, for the baby monkey. I'm sorry I missed a few of you. Judy, thanks for the clapping seal. Tiffany C., member for 4 months. Late night verdict watch parties with the fam. Love it. Thank you very much. And Bing and Billy, thanks for the sunshine as well. Smiley, longtime subscriber, new chatter. Love it. Thanks. Smiley, thanks for coming out of the lurking shadows. Did he do it on purpose? Well, that would be unethical for him to do that on purpose. But I don't think anything he did would be considered ineffective assistance of counsel. I think he actually tried pretty hard to help his client. So we'll see. Is Tracey in custody? Yes, she is. It would be grounds for disbarment. Yeah, it's serious if he purposefully tried to throw the case. Gilliam May says, it's only 4:17 here, too. I'm on Utah time. Yes, Tracey is in jail. Kelly, thanks for the Sunday. Thank you. Do you think the state proved the case beyond reasonable doubt? I wish I could say 100% of me said yes. Okay, and my problem with this case is some of the most important testimony came from some of the least credible witnesses, right? People that we know lied in other situations. People that we know were, have a lot of reason to say what they said. And that's my only issue with it. I've put some thought into this. I don't think it puts me beyond. I think I can still get to that point where I don't hesitate to act, right? And that's the threshold. Is your level of certainty high enough that you wouldn't hesitate to act on this? And I think I am high enough to do that. But it's really close. I have to admit, it's really close. The thing that gets me over that point is the 8 minutes. The 8 minutes that happened. The fact that she says she couldn't see him in the hallway when, we can stand in the hallway and see where she was sitting. And she says she couldn't see him back the other way, even though he surprised her and was walking down that way. There were some things in the story that just didn't add up. But the 8 minutes were probably what put me over the top. Jennifer Adams, I lurk most days, love this channel. 35 months makes you an OG. Squinty Bubbles, thanks for the 5 months. Who knew that gifted membership counted? Not me. I think I've been here around 3 years. That makes you also an OG. Thank you very much, Squinty Bubbles. How long until YouTube allows custom jewels? I don't know. They're pretty much a follow the money type company, so as soon as they see a profit in it, they will do it. Jennifer Adams gifted 5 memberships. Thank you, Jennifer. Heather from Texas, stay hydrated. I have 4 more bottles of water. I think I've had 3 already today, so we should be good. Exactly. Why wait 8 minutes to call 911? That's what did him in. That's really... Bobby Jane, new here and definitely addicted. Bobby Jane, thank you and welcome. You're one of us now. You can never leave. Thank you for the mystery gift, Ronnie. The cat in the box, love it. Let's see. Either way, she will live a lonely life. What's an OG? Well, it's a term that comes from rap and gang life called original gangster, meaning you're like one of the old school people. You were around in the beginning. We use it for original goat, and we use the term goat with the screaming goat as the greatest of all time. It just means you've been here for 20 months or more is what we sort of draw the line at. Once you're here for 20 months, you're an OG. Playing a new mod game, calling it whack a comment under a floating sticker. Okay, this is the reason that the floating stickers are not loved by all, but it's just a challenge because the mods who are trying to make sure that there's nothing mean in chat and rude to maybe family members of victims and things like that in the chat, which we don't allow. Sometimes these stickers cover what's in chat, and the mods can't do anything about it. My text is green, but my courthouse is blue. Yes. The blue courthouse means you're a new member. That's for the first month. After the first month, it will change to a light green color. Let's see if I can find one to show you. Oh, right here. Let's see.
Remember in the beginning when we started 110 years ago?
I think it goes light blue like this one, like Carolyn's, and then light green like Jody's. And then I think yellow is next. And after yellow, you get to orange. And after orange, you get to pink. And after pink, you get to red. I think that's the order. This is the order it goes. Yes, if you want your own Screaming Goat, they're available on Amazon. That is an affiliate link. If you do click it and make a purchase on Amazon, Amazon will thank me by giving me a couple pennies out of the profit they would have earned from your purchase anyway. It doesn't cost you any more. But as a thank you, they would send that to me. And occasionally it does add up to $. So I am appreciative of all those. Love the floating stickers. Oh my goodness. That goat. This is a goat trophy. This is just massive. Brett, thank you very much for the goat trophy. And the DJ cat. Oh my goodness. Turn it up. Turn it up. Greeners. I have not even looked at any of these. I don't even know what's available out there. Just every single time one pops up, I'm just trying to figure out what it is. Life hack, says Greeners. Post a controversial comment and then a floating sticker to cover it so you can't get banned. Don't challenge the mods. They're good. Greeners, you should know. Cass, thanks for the sunshine. Maybe dinner is something they want to wait for, too. Let's see. Josh says, do you want me to call in and talk about the delivery I just got? I don't know. Hold on that till I know what it is you're talking about. I have no clue. take the bait, Josh. All right. Be very afraid. Joe Sherlock says, "All right, you're stuck with me all the way to the Purple Courthouse." Yeah, that's the next one. Purple's next. Does anyone remember what story I was telling this morning? I told you I was going to tell a story, and then I forgot, like everything. Someone has to go back. I think it was right before court started, like the moment before the judge came in. Weather Watch, welcome. Weather Watch is my podcast partner, a good friend, and also a moderator on the channel.
Remember in the beginning when we started 110 years ago?
I remember. Well, the verdict can arrive now. Yes, you're here. Weather Watch often is lurking as he's working and going in the background. You can meet Weather Watch on Thursdays because we have a podcast called the Not Relevant Podcast, which we do right here on this channel. It's live, just like me, during the day. But we're both live, and we talk about some funny stories and interesting
don't
things.
Put a diplomatic plate on a hoopty.
And occasionally tell some really bad jokes, like dad jokes and things. Not like bad,
Call
naughty.
from Texan.
Texan, how are you doing?
Well, I'm green now.
Congratulations. Welcome. You're one of us who can never leave.
Yep, I was Chip V, then it was Texan, Texas, now it's Texan, Texas 2, because I had to figure out how to get out of the horror of having a branded channel, even though I never do anything with my channel.
I know. What's with that? We've got a couple people that have branded channels and they can't play with any of the fun stuff for some reason.
Yeah, but that's not what I'm calling for. I'm calling because I almost got scammed today.
Oh, no.
And it had to do with jury duty.
Oh, that's the worst
one. They called me, and it sounded legit, but they claimed that I had a bench warrant out for me, and that a couple of sheriff deputies came to the door, and somebody signed off for me, and that I was supposed to be at court, and I didn't show up, and they were going to, I could either. This is like over like an hour and a half or so of time. They so that I could either do this, have them come out and bring me in with handcuffs, or I could do like the civil thing. And
it's
so,
scary.
I definitely want to do civil.
It's scary.
And they were wanting me to put some money down on like a bond or whatever. They had me to write some stuff out, like the court numbers or what, some kind of a thing. They sent some things on that looked like it was legit court papers, but one of them was something about a restraining order that I wasn't supposed to talk about it. And I'm like, okay, this is sounding kind of scammy. And, I said so. And they said, ma'am, this is not a scam, whatever. Anyway, I got in my car and I drove to it was supposed to be the sheriff's department, Jefferson County, Texas Sheriff's Department. Mm-hmm. So I drove to the sheriff's department downtown Beaumont, and I put him on mute, and I started talking to her. She says, "It's a scam."
Yeah. You did the right thing. I'm glad you didn't give them any money. That's what they're after.
Oh, well, I didn't have any money to give. I mean, I can't even get a membership.
That's even easier.
Yeah,
I'm sorry to hear that.
True.
But it's
that's true.
But these
I was more
scammers,
upset that I missed jury duty on a murder trial.
Like, no, let me do the next one, please.
Yeah, and that they said that I couldn't watch Judge Stevens' court on YouTube because I might divulge something. I don't know.
Yeah, I appreciate you calling and sharing that because this is a scam, and unfortunately,
y'all
it's
be
targeted.
careful. Drive to the authorities and check with them. Say take a chance because they're not going to throw you in handcuffs.
Yeah, and they can give you all sorts of fake stuff that sounds real, But as soon as you feel it's bad, hang up. You can always if it's the real police and you call them back at not the number they called you on. You call them back at the number that's listed for the sheriff's office or whatever. Call them back and say, I just had a call from you. If it's the real people, you're like, hey, sorry, bad connection. I'm just calling back. And if there is a bench warrant, which there isn't, okay, 99% of you, probably, hopefully more, there's not
And
a
they
bench
knew
warrant.
the judges' names and everything, and and
They make it
I said,
very
"Look,
real.
I'm at the sheriff's department. I'm just within a few feet from Judge Stevens. Excuse me, I got a frog in my throat. I'm just a few feet from Judge Stevens' courthouse door. I can go in there and talk to him." And anyway, he finally hung up because I was there in front of the.
You are banished from the.
Yep. Sorry. That just
exactly.
Yeah, that is scary. I think there's a special spot in hell reserved for some of these scammers. It's terrible. I like to waste their time when they call me, but the scary part.
Well, let me not waste your time and let you get back there.
No, that's not a waste of time.
Try to find your story.
I appreciate you sharing that because they're going to call somebody else today, and maybe
Yes,
somebody
sir.
in chat hadn't heard of this and said, "Yeah, I heard about you guys yesterday. This is a scam."
Right.
So I appreciate you sharing that very much.
Okay.
All right.
Talk to you later. Bye.
Bye. Yeah. Oh man. I was talking to Ayden on lunch today, Fran, and he actually told me to tell everybody hi. He's doing a whole bunch of stuff. He's busy. He was just walking down to the Walgreens while he gave me a call. And that was it. That's all. He just said, I missed you guys. I've just been busy. So I have a story to tell you. I remember.
Obsessed with Justice.
Hello, Obsessed with Justice. How are you doing?
Good. How are you?
Excellent. What's up?
So I actually have one along the lines of the last caller. I have a really good friend. Her son was arrested, and she received a phone call from the sheriff's office saying, we have your son. We know he's going to see this judge. He's going to see, this person at this time. I had all of his details for his court hearing. And said that he would be going to jail if she didn't pay a $3,000 bond. Yeah. So she paid the $3,000 bond, and it was a scam.
Oh no!
They actually called her back and tried to get another $1,800 in court fees out of her. And she went and talked to one of the bailiffs or whatever at the courthouse, and he said, "Hang up, it's a scam." And she was out $3,000. And she said they knew all the information, all his information, everything. And so she believed it.
That's scary.
And she fell to that scam. So I've been wanting to call.
they use the public records, right? They search online. They see who's been arrested. They see the new people who've been brought into jail from the jail roster. They'll do a quick search and see what the charges are. They can find their home address and number pretty easily. And then they call the family members and exploit them, knowing that this just barely happened, and they probably aren't familiar with the system, and everyone's trying to help out their family member and figure out what's going on, and if I don't do this now, then this will be terrible for them, and they make it a matter of urgency, so you have to respond right now, or else you lose all chance to do this. Once again, special spot in hell.
Her son was going to jail.
Yeah.
Yes. So I was like, I listen to true crime all the time, and I've never heard of something like that. I want to warn my other true crime friends that this is a thing.
Yeah. The next thing, and JR posted this, that's probably going to become big next, is sadly, it's that they can clone your voice. And you might get a call from somebody who speaks to you about something that has nothing related to a crime. Nothing related to anything. It's just some random person that's asking you questions. It might be a survey. It might be, who knows what. It's just getting you to talk. And you talking,
so they can record your voice.
It's training their AI model. And then they use your voice to call somebody you know. And it's in your voice asking them for money. And they trust you because they know you. And it sounds like you. And it's coming from something that says it's your number. It's a terrible scam. And I think technology needs to get ahead of that quickly. Because a lot of people are going to fall for that, and it's terrible.
Absolutely.
Yeah, code words.
Yeah. So I just wanted to warn everybody.
Thank you so much for that. I appreciate the call.
You're welcome.
All right.
Thank
Have a
you.
good one. Yep. Bye-bye.
You too.
Obsessed with justice. Thank you very much for the call. Quick story. I was telling you this morning, we were talking about American Fork Canyon. And American Fork Canyon is the only place I've really been successful in panning for gold, like old timer type of pan for gold. There's a stream up there above Silver Creek Reservoir, I think it's called, up above Tibble Fork, up above Timpanogos Cave, up above the campgrounds and everything. There's a road that goes way up next to the wilderness area up there in the mountains, and that little tiny creek is where I've found gold. And I actually made a device. I made a gold sucker, and this is a large, like a 2-inch PVC pipe with a plunger PVC pipe inside that I made using like bicycle tire circles cut out, and I made this. Think of like a giant syringe that's like 4 feet long, and you can pull the plunger out of the syringe. I have to show you here. It's a 4-foot long syringe, right? And you pull the plunger out of the syringe, and the nozzle where the needle would be is about a 1-inch pipe, and it has a one-way valve at the bottom, so stuff can get sucked up, but it closes the flap and nothing can come out. So you pull the syringe, the plunger all the way out, and then you can dump out what you sucked up. And so I could stick this deep in the water, in like this glacier water. It's so cold. And I could suck up the heavy items off the bottom using just a whole bunch of force with my arm to create that suction. And that's how I found gold. So I went up, I built a better model, drove for an hour and a half to get up there on a motorcycle with this thing strapped to my back, this big long pipe. Went all the way up there, and it's still springtime. Like there's snow banks all over the place, even though it's probably May, maybe early June. There was still snow in this canyon, and you get up there, park my motorcycle, and I start hiking, and I slip, and I fall, and my gold sucker gets out, I let go, I dropped it, and it just goes like a ski down this snowbank, and it just bounces and stays on top, and it just zips, and then it just spears right into this giant rock, and it just exploded. It full on just like pieces went everywhere. I had just built this huge improvement, this design. I was going to make so much money on the gold nuggets I was going to find. I made it like 2 feet, and then it's gone. So I never went back up there. The one big gold nugget I did find up that canyon, I traded for fishing on a private lake and caught 3 of the biggest rainbow trout I've ever caught in my life. And it was worth every gram. It was worth every gram. Anyway, that was the story I was going to tell this morning. So we're still waiting for court to come back. Hope he didn't dismiss them out of the jury room and everyone's gone home for the night. No, Lori, they do lock this court at the end of the night, and the cameraman has to shut off his camera. So if the feed were just to go to like the bars, and by bars, I could show you what it is, but those color bars and then turn off, we'd know that the camera's turned off for the day and everyone's been sent home. It hasn't happened yet. So as long as we have a feed, we know that the court is still open. All right. I don't know who that was. All right. Ace King says, almost started the morning talking about grams, different grams. Let's see. Needs to hurry up, says Josh. I have to go finish making sure my delivery is okay. Josh, what's your delivery? I'm curious now. That's where I made my fortune. There's not enough there not enough gold there in that canyon to get rich from, but you could earn a couple $1,000. Oh, it's worms. You got your worm delivery. That's awesome. There is enough gold up there that you can make some good money, but it only happens once a year, and it's right after spring runoff. Gold washes down from the sides of the mountain, and you can find it in the river. But once it's cleaned out of the river, you have to wait till next year for more gold to wash down. No one's been able to find exactly where it comes from, or else they would mine that. But Josh got some worms. He sent a picture. Okay, let me look. I've got the morels for dinner. Fresh morels. Morel mushrooms are awesome. Whoa, red wrigglers is what I'm seeing there, Josh. Those aren't earthworms. So I get red pen doing a egg yolk and breadcrumb morel mushroom. Josh's bucket of worms, and then red pen frying the mushrooms. That's the order the pictures came in, just so you know. Love those mushrooms. I was telling people about selling the car and people trying to get a good deal. That's just constant. I think I could probably write a book about people who try to get discounts on what I'm selling on Facebook. Hey, little Larry, how are you doing? Did the jury order dinner? We don't know yet, Judy. We know that there have been no questions or verdicts thus far that we have been told about, but the judge might handle some of them from his chambers. Yeah.
Dinner.
Dinner's ready? Can't have dinner. We're on verdict watch. We have to wait. They're staying later. I don't know how late they're going to stay. The mushrooms are so good. Red, I can almost smell them. They look good. How many on the jury? 12, and it has to be unanimous, Bing and Billy. In Utah, it has to be unanimous on this one. I know other states, can be 8, and it works, like Florida. Did little R.A. get tall? Yes, that was my one of my tallest. He's my middle child. Supermom JMH just gifted a husky. Thank you very much. A singing husky, because that's what they do. Hey, are you bringing me dinner? Sorry, he's bringing me dinner.
I almost put the mint salsa on it you didn't like.
Thank you. My wife likes fermented salsa. This is a corn. What is this called?
It's huevos rancheros.
Huevos rancheros.
Laura Fuentes.
Black beans on corn tortilla, fried egg, avocado, and lime. I'm a big fan of the avocado. I'll set this over here. Let it dry out and get cold. Supermom, thank you very much for the sticker. Shelly Small, I'll stay hydrated. Thank you. With wet tortillas? Probably. I should probably check if the tortilla is wet. Judge usually has a deputy check on them. Any word that someone checked in to see if they're alive? No one fighting. Judy, here's what we know. Only one deputy was sworn in. So that one deputy has been working all day long. So he's on overtime right now. And I imagine that they probably don't want to pay him all night long as well. They'll want to rotate him out. And they can't rotate him out without swearing in more deputies, which they could do without us knowing about it. But with only one deputy, I think we might wrap up for the day, probably within a little while. Let's see. Josh just got a delivery of worms today. He's already sold some to his neighbors. Can we get recipes on Verdict Watch? We are slowly, and by we I mean Red Pen, are slowly working on a Verdict Watch recipe book. I don't like the black beans either. Don't tell Mrs. R.A. I'm just not a fan of black beans. Their flavor isn't very good. I'd rather have like baked beans than black beans. Like Heinz 57 baked beans. Katybug, I don't know how they work exactly. I think it is a cost threshold. The more expensive ones show up on screen and the cheaper ones just show up in text. I know the cheaper ones I can't click on to show on the screen. We need another grocery store trip live and a cooking night. Jamie Bobamy, I'm down with that. I need to find a store that doesn't play music in the background, and I think Sam's Club is the one. I don't think they play music. Maybe they do. Maybe they all do, and I just don't hear it. Has been a long day. Well, how about this? When they hit 5 hours, we'll give them just a couple minutes. So they've got 12 minutes more. When they hit 5 hours, we'll plan our day so that we can let everyone get some rest, especially our mods. Thank you very much, mods. You let them get some rest. Then if something happens, we can definitely go live with that. But if it doesn't, then we'll just be rested and ready for tomorrow and be able to come back for the continuation. Because I can go live in just a moment. What about Brandon's email? I haven't emailed him yet. I need to do that really quickly. Basically, a viewer by the name of Brandon shared some really positive news about his life. And successes in his life that came from inspiration from the channel. So that's really cool. I'd love to share that story if Brandon would like, but if not, it's his story, so I don't have the rights to just give that to everybody. But I'm honored that he shared it with me. That's really cool. I'll follow up on that, and if he gives the go ahead, I'll definitely let you know. Otherwise, just know that the one of us is accomplishing great things and just amazing. So, and their name is Brandon. Mrs. R.A., she's got some like molasses cookies out there right now that I have not eaten yet. I was being good and waiting until after dinner, but I need to try those. Remember the rule we have as far as deliberation time, usually an hour per day of trial. And this trial is on day, what? Day 7? It's day 6 right now. I might have missed one. So 5 or 6 hours of deliberation is not bad for a trial that long. Sorry, his cookies are good. Josh, if only you had tried some when you had the chance. I'm just up here north of you, a couple states. Could have swung by. It is, here in North Carolina, it is 7:17. It is 5:17 in Utah. Mimi NC says, for those of you who comment frequently, what are you using, a smartphone or a computer or watching on the... Let's do a poll, Mimi. I can help you out with that. That way it will help. Let's start a poll. Let's see, phone, tablet, TV. What are the other options? Laptop. There we go. We've got a poll going right now, so you can let us know what device you use to watch. I know a lot of you use 2. So if you use 2, please reply with the one you comment on. So if you type and comment, that would help. Results are flooding in, and phone is currently winning. It is putting the poll at the bottom of chat again. You can dismiss the poll if you need it, Red Pen. You can dismiss it on your screen. Has the judge ruled on the Richens motion to postpone the sentencing? I haven't heard, Jamie, if he has. I think it was going to go forward early next month. Even if it is delayed, it might be just a couple days. Speaking of judge's ruling, Josh Mullins, was that his name? Was it Josh? Was the pitchfork rake murder guy? He had a hearing to try to get a new trial, and the judge has taken 13 months to respond. Kathy Russin from Law and Crime. Todd Mullins, thank you, Josh. I just threw your name in there for good measure. Todd Mullins. The judge was supposed to make a ruling, and it's been 13 months and nothing, just like crickets. So maybe this will spur some action there. Commenting on the TV is a little bit difficult because your input is generally your remote control, and it's a little harder to type on that one. Most people don't know how, if it's even capable. Watch on cell and iPad, comments on cell. iPad doesn't let me comment, not sure why. Probably not letting you log in. You might have to check and see if you're logged into YouTube on your iPad. Because you have to be a subscriber to comment. So it might either be logged into a different channel on your iPad that's not a subscriber, or that. You can check that. You think the judge would have a deadline to make a decision? Yeah, he's just rotting in prison while the judge does nothing. I started watching way back when you played the guitar for us and sang a song. I put that song on Suno, I believe. Like my actual song. Yeah, it's not natural how fast kids can type on their cell phones. Something's wrong there. It's like magic. Logged in and subscribed still doesn't allow. Weird. It's impossible to comment from the TV. You can turn chat on, but how many use earbuds? Hopefully none tomorrow morning, Lynn. Mimi and C, thank you very much. Appreciate it. It's good information. I can actually find that out on YouTube. YouTube will tell me a little bit about the demographics on the channel as well. Let me see if I can tell you what they say. Let's see, analytics, audience. Let's see, audience watched by behavior. 45. Let's see, what does this mean? We have 45% of our audience is new members. Casual viewers, 26%, and 28% are regular viewers. Channels our audience watches: Court TV, Law and Crime Trials, Lawyer You Know, Grizzly True Crime, and Emily D. Baker. That's a good crowd to hang out with. Most popular time our viewers are on YouTube is weekdays between 10 a.m. and 5 p.m. There are 20% of subscribers who turned on all notifications for my channel. There are 12.5% who turned on all notifications for your channel and enabled YouTube notifications. You have to do both to get notifications, so only 12.5% of you get that. But the typical is 5 to 20%. That's normal. Watch time from subscribers. This is a fun number. Subscribed members, 80.7% of the viewers are subscribers. So if I were to say, hey guys, let's see if we can get a couple more subscribers, I couldn't really do it because most of you are already subscribed. that is very uncommon to have that high a percentage of subscribers. It's usually about 20% of your viewers are subscribers and the rest don't subscribe. So that's really, really cool, and it's something that we're proud of. Somebody did walk on the screen. We might have some action here at 5:30. Device type, here we go. Watch time in hours in the last 28 days. On a mobile phone, 36%, 36.2. TV, 35.2. Computer, 16.5, and tablet, 11.1. That's all the options. So, age and gender, this probably won't surprise you. Female viewers, 82.1%. Male, 17.8%. And let's see, we have 1% at 13 to 17 years, less than 1% at 18 to 24. That's the demographic we just have not connected with. 25 through 34, we have 5%. 35 through 44, 14.2. 45 through 54, 20%. 55 through 64, 28%. And 65 and over is 31.4%. So that's some good numbers there. The United States makes up 75% of our viewership, followed by Canada, United Kingdom, Australia, and South Africa. I think that's all. And in the last 28 days, we've had 225,000 watch hours, which is all the time everyone watches added up. This is not a place to pick up men. I'm sorry if that's news to some of you and you're disappointed. But we've got a great community here and I love it. Lynn says, how do you know how old people are? Well, YouTube is owned by Google, right? I think they are. Anyway, YouTube is a big company, and when you sign up for something, it learns about you. And sometimes it's from people volunteering information, and sometimes it's from their system learning about who you are. What about geography? I gave the geography 75% in the United States. Males that watch. Josh, Greeners, and Weather Watch. No, we've got more than that. We've got a lot. But we have had an increase of 1,400 subscribers this last month, and thank you all for that. We're getting perilously close to 71,000 subscribers. Wendy, member for 20 months, makes you an OG. Thank you very much. Thank you. That's awesome. Congratulations. We did hit 5 hours. There it is. And some motion in court. Here we go. The camera is jiggling, which means the cameraman is right there. He might either be turning the camera off because we're done, or possibly getting set to pan down to the judge who might be in any moment. The cameraman is definitely fiddling with the camera. I'm hoping it just doesn't go to black. Here we go. Oh. I'm excited. Just pans down a tiny bit. It is 5:30, so this timing seems like a time they would send the jury home. Scotch's mom, member for 17 months, says, how about a verdict? Taps foot, happy to be part of this community. Thank you, Scotch's mom. Barb Russell, member for 15 months. Happy to be a member for 15 months. Mimi, thanks for the idea on the poll. Appreciate that. Let me end the poll officially so you can see the results. Looks like those are similar to the numbers we see on the YouTube side. 54% phone, 20% tablet, 18% computer, and 8% TV. Texas Forever, welcome to the gallery. Thank you very much. Wendy, thank you for your 20 months of support as well. Barb Russell, 15 months. Weather Watch, 38 months. Makes you an OG. Bobby Jean, new here, definitely addicted. Thank you, Bobby Jean. Welcome. You guys, I have to tell you, I am actively looking for a situation where we can use our new equipment. And by new equipment, we're talking about the mobile streaming setup, where we can follow, generally it's going to be a crime that's a little more fresh than what we get in the court system as it's worked its way through the system over the months, the years it takes to get to court and to trial. If there's another manhunt type situation that's local, I want to give it a try. And hopefully it won't interfere with any of the court cases that we're planning to watch. But I'm geared up. I have all my gear packed and ready to go, and I want to try it. Mostly as a test, but also just because I think I've got some ideas for how to cover something like that that's a little different than how everyone else has been covering it in the past. So I'm hopeful. Let's see. Judy says, member for 2 months. I'm an OG wannabe. Thank you, Judy. Appreciate you. Just going to try to look on Twitter and see if anything has been said. Nothing. Judge didn't say how long they could deliberate, didn't set a timeline on the closing arguments. It just sort of goes by the seat of his pants. Who volunteers as tribute for causing a manhunt? You want a list of my equipment? And my insured wants that as well. I'm scared because it might raise my rates, but I can give you that. I can give you a list of what we're using in the mobile kit. Take a big beach trip and stream it. The judge could care less about us. Have a lot of tiny screws, that's for sure. You're right, I can't get this pole to go away. Oh, there. Okay, got it. Okay, this is our way to hide and you go find her. How many buttons now? I have not counted. But I think I added about 20, 30, 40. I think I've added about 50 buttons. I love that hoodie. My son loves his. He wears it all the time. Mary, we've heard it from a couple trials where the judge says you can deliberate as long as you want. It generally turns out that the judge is not the controlling factor there, and the jury isn't either. The bailiffs who secure the courtroom and who lock up the building are the deciding factor, and often they'll be told you have to go home now. What did you do with your taillight from the KR trial? I sent it to Stubby. Yeah, we sold it. We sold it on auction, and there was a very generous donation made, and we mailed it. I mailed it a little late, but it was a super generous donation made to the hospital, and I mailed the light down. We're seeing some people walk around. The camera's moving. Thank you for the flowers, Cass. Appreciate the tulips. Legally Blonde, we are still here. We're hoping for a little action. Lots of people walking around in the courtroom. So we're thinking there might be either a verdict or the end of the day about to be announced. Those are Michigan tulips. What's the story about the taillight from the Karen Reed trial? We followed that trial, and I was curious about various aspects of that case with the taillight, and so I ordered my own taillight from, I think it was eBay we bought it on, but we got an OEM taillight so that I could just see what it was we were talking about and the materials, and so I would show it a lot. I was going to do some tests on it, but there were a lot of other people who did similar tests that were better at testing and documented it than I was, so we ended up just keeping the taillight intact and in full operational condition. And we ended up auctioning it off in one of Ian Runkle's charity auctions that helped the Children's Hospital. Hey, what's that? I think we're good. We're just waiting. There's a lot of motion in court right now. Ooh. Ooh. Hang on. We're getting some word. Hey, Amber, how you doing?
Confirmation.
Got it. All right. All I have left to do right now is to do this. Amber hangs up, and we hit. 5 hours and 10 minutes of deliberation time is all it took for the jury to reach a verdict in the Tracey Grist trial. Tracey Grist, the mother in the family, charged with orchestrating the murder of the son-in-law. We have many players involved in this case, all of them family members connected in a weird web through a long string of husbands, or wasbands as the case may be. 2 family members already in jail for this. The jury deciding if a third person is going to be sitting in jail, in prison, for the murder of Matt. Matthew, the son-in-law, drove up from California to pick up his wife and kids, drove to the mother-in-law's house, entered the front door, and was gunned down, shot 7 times by Kevin Ellis, who was the son of the current defendant, using the gun that belonged to the defendant. And that, the condition of Matt in there in the hallway where he fell, the knife that appeared to be placed in his hands, the timeline of when Tracey called the police, it just didn't add up to police. And from the get-go, they said something is wrong here. Kevin was arrested right away for this, but the other arrests followed soon after. Kate took a plea deal. She has pled guilty to this. She's been sentenced and will be serving a lighter sentence as a result of her help. She testified against her mom in this trial. Kevin refused to testify, pled the fifth, made a brief appearance in court, and then was led away, probably the last time they'll see each other. And just an absolutely wild case. Possibly the craziest part of this was not the story, the crime, the defendants, but the lawyer himself, Mr. Facemeyer, just conducted himself in a manner that was just anything but what you'd expect a defense lawyer to do. He yelled at his client, basically. He told her to shut up, in nicer ways, and accused other people of wanting to kill Matt. It was bizarre. And even his closing statement matched that same energy. So we're going to see if the jury found what he did to resonate with them, or if they're going to instead convict Tracey of the crimes. She's charged with a number of things. The charges are as follows. First, murder. Second, conspiracy to commit murder. Third, obstruction of justice. And if they find her guilty of that, they have to then find that she was either a party to planning or made an untruthful statement to police regarding the knife. in the hand. There are 4 and 5. The 2 charges are commission of violence and domestic violence in the presence of a child. That's because there were 2 children upstairs asleep at the time the shooting happened. And then, of course, there's a special verdict form regarding cohabitation, which we think will be a shut. It'll be a given, basically, because there's a stipulation that says yes, they were cohabitants. So there you go. That is my hasty wrap up of the trial. You've heard the verdict music now. Thank you for all the news. Cohabitation is not a crime, but it does bear on the other charges, 1, 2, 4, and 5. The elements of those charges depend on whether or not there were cohabitation existed at the time. All right, so 5 hours and 10 minutes. For those that had 4 to 6 hours, you were right. You were right. There's the domestic violence enhancement. Thank you for that, Northwest.
I'm not a cat.
I'm going to say they found her guilty of at least the second and third count, hopefully the first count. It's a quick verdict. It's under 6 hours. So that's impressive. We'll start our recorder there. Generally, the judge says that it'll be 15 to 20 minutes or so is what he wants them to be away from the courthouse. So you could come back at a moment's notice. So between now and about 15 minutes from now, we should expect to hear the verdict read in court. There may also be family members that are trying to be there in person. Let's see. Someone said motion in the courtroom. Yep, we have a verdict. We have not read the verdict yet. We do not know. Lady Draconis, welcome. Send our best to Rob for us. Lawyer would have loved this trial. Defense attorney drama. I think he would have. I wish he could explain it to me a little bit, because there may be some strategy that was at play here that I missed, and instead of focusing on the behavior. I'm curious if there's a bigger plan at play Mr. Facemeyer was engaged in. Cameras only ever shown the back of their heads except for the brief time that she testified. Here we go. We're back.
Thank you. Please be seated. Let's go back on the record in the matter of State versus Tracey Marie Grist, case number 2411070. It's my understanding that we do have a verdict. We'll bring out the jury. Ready, please? Ready.
All rise for the jury.
Thank you. Please be seated. Juror number 6, may I assume that you're our foreperson?
Yes.
Do we have a unanimous verdict?
Yes.
Could you hand the verdict to my bailiff, please?
That was a confident response from juror number 6. Judge reviews the form to make sure all the signatures are in the right places. Each juror is supposed to have signed this one, I believe. Should be 5 or 6 pages to this. That was our bailiff.
Thank you. Mr. Facemeyer, if you would your quiet to stand to receive the judgment of the jury, please.
In the 4th District Court, Provo, Utah County, State of Utah. State of Utah Plaintiff versus Tracey Marie Grist, Defendant. Case number 241101170. Judge Roger W. Griffin. As to count 1, we, the jury, impaneled in the above entitled cause, find the defendant as to count 1, murder, as charged in the information, guilty. Jury for a person. As to count 2, we, the jury, impaneled in the above entitled cause, find the defendant as to count 2, conspiracy to commit murder, as charged in the information, guilty. Signed, jury for a person. As to count 3, we, the jury, impaneled in the above entitled cause, find the defendant as to count 3, obstruction of justice, as charged in the information, guilty. Further, having found the defendant guilty, we unanimously find Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand. Tracey Marie Grist made an untruthful statement to 911 or to the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli. Signed, jury foreperson. As to count 4, we, the jury, impaneled in the above entitled cause, find the defendant as to count 4, commission of domestic violence in the presence of a child, as charged in the information, guilty. As to count 5, we, the jury, impaneled in the above entitled cause, find the defendant as to count 5, commission of domestic violence in the presence of a child, as charged in the information, guilty. Signed, jury for a person. As to count 1, 2, 4, or 5, we, the jury, impaneled in the above entitled cause, find that at the time of the offenses of count 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants. Signed, jury foreperson.
Thank you.
It's a clean sweep.
Mr. Facemeyer, do you wish me to poll the jury?
Yes, Judge.
Thank you.
Polling the jury, each juror gets to now say that this
Ladies
is
and gentlemen of the
verdict.
jury, this is a standard practice that we do called polling the jury. It's a little laborious, but what I shall do is I'll just go down the row and ask each of you as to each count if this is indeed your verdict, and then we'll move on to the next person. So it'll take a few minutes, but we'll make sure that the record is clear. And as I mentioned, this is a standard practice. I'll just start with juror number 6, then I'll go to juror 10, and then juror 27, and then we'll go to the back row, and then just hold up your placard so I can see your number, and then we'll go from there. So juror number 6, starting with you, is it indeed your verdict is to count 1 guilty?
Yes.
As to count 2, is it indeed your verdict guilty?
Yes.
As to count 3, is it indeed your verdict guilty?
Yes.
Is it indeed your verdict also that Tracey Marie Grist planted a knife in Matthew Rastelli's hand?
Yes.
Is it also your verdict that she made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Count 4, is it indeed your verdict guilty?
Yes.
Count 5, is it indeed your verdict guilty?
Yes.
Count 6, the special verdict form for cohabitation, is it indeed your verdict that they were cohabitants?
Yes.
All right, thank you.
Do that for all 12 now.
And I was a little neglectful there, so I want to do a couple of things just to make sure we're clear. Count 1 was murder, and that was indeed your verdict for murder?
Yes.
And then for count 2, it was conspiracy to commit murder. That was your verdict
Yes.
as well. And then count 3, it was as to obstruction of justice, it was indeed guilty.
Yes. I do want to say, although you didn't mention it, this count 1, 3, 4, and 5 are all as a party to. Is that correct?
What?
Counts 1, 2, 4, and 5 are
Sorry.
cohabitants.
1, 2.
Counts 1, 2,
1, 2, 4, and 5 are cohabitant.
Yeah.
Counts 1 and 3 are as a party to.
and I'm not sure I understand you there. I'm sorry.
Sorry, can you count 1 was murder?
Yeah,
count
let me
2
read them all to you again.
Okay,
There's no problem at all. I'll go a little slower, okay? So count 1 is for murder. as charged in the
co-conspirator.
information. Was it your verdict guilty for murder?
Yes.
Count 2 was conspiracy to commit murder. Was it your verdict that Ms. Grist was guilty?
Yes.
Count 3 was obstruction of justice. Was that your verdict of guilty?
Yes.
Thank you. Was it also your verdict that Ms. Grist, quote, was a party to planting the knife in Matthew Rastelli's hand?
Yes.
Was it also your verdict that Tracey Marie Grist made an untruthful statement to 9/11 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Thank you. And then count 4 was commission of domestic violence in the presence of a child. Was that your verdict of guilty?
Yes.
Then count 5 was also commission of domestic violence in the presence of a child. Was it indeed your verdict of guilty?
Yes.
Thank you. And then the special verdict form. And that reads as follows. We, the jury impaneled in the above entitled cause, find that at the time of the offenses in counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants. Was that your verdict? Right. Did that clean up your confusion?
Yes, it does.
Your Honor, I believe he means as a party to the offense.
This is the time for polling.
I'm just trying to clarify.
Yeah, let's talk about that after. Let's poll right now. All right. Thank you. Sit tight, and I'm going to go through the rest of the panel. So juror number 10. As to count 1, murder, was it indeed your verdict guilty?
Yes.
As to count 2, conspiracy to commit murder, was it your verdict as guilty?
Yes.
As to count 3, obstruction of justice, was it your verdict of guilty?
Yes.
Did you also find that Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand?
Yes.
Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Thank you. Counts 4 and 5. Count 4, commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
As to count 5, also commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
And then the special verdict form. We, the jury impaneled in the above entitled cause of action, find that at the time of the offenses in counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants. Was that your verdict?
Yes.
Thank you.
This is crazy.
Number 27.
It's super slow
As
and
to count
tedious.
1, murder. Was it your verdict of guilty?
Yes.
Count 2, conspiracy to commit murder. Was it your finding of guilty?
Yes.
Count 3, obstruction of justice. Was it your verdict of guilty?
Yes.
Did you also find that Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand?
Yes.
Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Thank you. Verdict form for counts 4 and 5. Count 4, commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
As to count 5, also commission of domestic violence in the presence of a child. Did you also find guilty?
Yes.
Thank you. Then the special verdict form for cohabitation. Did you find in the above entitled cause that at the time of the offense, any other counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants?
Yes.
Thank you. Juror number 13. As to count 1, murder. Did you indeed find guilty?
Yes.
Thank you. As to count 2, conspiracy to commit murder. Did you indeed find guilty?
Yes.
As to count 3, obstruction of justice. Did you find guilty?
Yes.
Did you also find Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand?
Yes.
Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Verdict form for counts 4 and 5. As to commission of domestic violence in the presence of a child, did you find guilty?
Yes.
As to count 5, also commission of domestic violence in the presence of a child as charged in the information, did you find guilty?
Yes.
As to count 6, the special verdict form, did you find in the above entitled cause of action that at the time of the offenses in counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants?
Yes.
Thank you. Juror number 5. As to count 1, murder.
Yes.
Was your verdict guilty?
Yes.
Thank you. As to count 2, conspiracy to commit murder. Was your verdict guilty?
Yes.
Thank you. As to count 3, obstruction of justice. Was your verdict guilty?
Yes.
As to the Did you also find that Tracey Marie Grist was the party to planting the knife in Matthew Rastelli's head?
Yes.
Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Verdict form for counts 4 and 5 is to count 4, commission of domestic violence in the presence of a child. Did you find guilty?
Yes.
As to count 5, also commission of domestic violence in the presence of a child. Did you also find guilty?
Yes.
Thank you. In the special verdict form, do you also find in the above entitled cause that at the time of the offenses on either counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants?
Yes.
Thank you. Juror number 25. So count 1, murder. Was it your verdict? Did you find it as your verdict guilty?
Yes.
So count 2, conspiracy to commit murder. Did you find guilty?
Yes.
So count 3, obstruction of justice. Was it your verdict of guilty?
Yes.
Did you also find that Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's head?
Yes.
Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Verdict form for counts 4 and 5. Count 4, commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
Count 5, commission of domestic violence in the presence of a child. Did you also find guilty there?
Yes.
And as the special verdict form, did you find in the above entitled cause of action that at the time of the offenses in counts 1, 2, 4, or 5, that Tracey Marie Grist and Matthew Rastelli were cohabitants?
Yes.
Thank you. Juror number 19. As to count 1, murder, was it your verdict of guilty?
Yes.
As to count 2, conspiracy to commit murder, was it your verdict of guilty?
Yes.
As to count 3, obstruction of justice, was it your verdict of guilty?
Yes.
Was it also? Did you also find that Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's hand? Did you also find that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Counts 4 and 5. Count 4, commission of domestic violence in the presence of a child. Did you find guilty to count 4?
Yes.
To count 5, commission of domestic violence in the presence of a child. Was it your verdict of guilty? As the special verdict form, in the above entitled cause of action, did you find at the time of the offenses in counts 1, 2, 4, or 5 that Tracey Marie Grist and Matthew Rastelli were cohabitants? Thank you. And jury number 14. As to count 1, murder, was it your verdict indeed of guilty?
Yes.
As to count 2, conspiracy to commit murder, was it your verdict of guilty?
Yes.
As to count 3, obstruction of justice, was it your verdict of guilty?
Yes.
As to Tracey Marie, was it also your verdict that Tracey Marie Grist was a party to planting the knife in Matthew Rastelli's head?
Yes.
Was it also your verdict that Tracey Marie Grist made an untruthful statement to 911 or the police that Matthew Rastelli had a knife before Kevin Ellis shot Matthew Rastelli?
Yes.
Verdict form for counts 4 and 5. Count 4, commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
Also, in count 5, commission of domestic violence in the presence of a child. Was it your verdict of guilty?
Yes.
In the special verdict form for cohabitation, in the above entitled cause of action, did you find at the time of the offenses in counts 1, 2, 4, or 5 that Tracey Marie Grist and Matthew Rastelli were cohabitants?
Yes.
Thank you. Mr. Faceler.
Nothing further, Your Honor.
Thank you. Anything further from the state, Mr. Watabe?
No, Your Honor.
All right. Ladies and gentlemen of the jury, this concludes your service as a juror almost. I'm going to excuse you back into the jury verdict room for just a couple of minutes, and I'll come in and talk to you for a moment, and then you'll be free to go home. Once they excuse you to go home, the admonition order about talking about the case, using social media, posting about it, letting your friends and family know, that's gone away. That prohibition is gone, and you can do whatever you want or whatever you don't want to do. If you just want to move on with your life, you're able to do that. If you want to post about it, that's your right as well. With that in mind, we'll excuse the jury, and I'll be in just a couple of minutes.
All rise for the jury.
The cohabitation finding is an aggravator, domestic violence aggravator for sentencing. So that's all that's for those 4 charges. There could be a heavier sentence handed down because of the cohabitation.
Thank you. Please be seated. All right, let's get a sentencing date. I'm assuming we'll want a special set again. Is that correct, Mr. Watabe?
Yes, you are.
How much time do you think we'll need?
You could do 2 hours just to be safe, Your Honor.
You concur as well, Mr. Facewear?
2 hours?
Yes.
I mean,
To be safe. I think in the prior ones we did about an hour, wasn't it, approximately?
Yeah, it was about an hour.
But we'll go 2 just to be safe, Mr. Facewear. All right, so I'm out of the country in 6 weeks, so I'm going to have to give you a later date.
Where are you going? And for how long?
so you thinking, are we saying June is what we're saying?
Week.
June.
I'm sorry, Mr. Facewear?
June?
Yes, we'll be in June. I, of course, will make recommendations to the parole board that Ms. Grist receive credit for all time served. About Monday.
Someone's timer just went
How
off.
long is that trial? Let's do it on Friday then. What's the date?
Judge says he's got a 2-week trial. Starts right after the date he's about to announce.
June 19th, it's a Friday at 9 a.m. Does that work for you, Mr. Watabe? Or you're doing that, Mr. Facewear? How about you? Okay, perfect.
Can I ask what the current state law is for June 19th? Is that Juneteenth, what is the holiday for the state now?
Yeah, Monday's the holiday.
We celebrate it on the Monday?
Yeah, this is, I think, the last year that we do that, and then we go back to this, the way the rest of the country celebrates.
Thank you.
There you go. You learned
That's a
something.
good question. That's what we were just talking about. You said that works for you, Mr. Facewear? Thank you. Mr. Watabe?
I'm still checking. Your Honor.
Okay, thank you.
Yes, apparently Utah celebrates June 19th on June 22nd. Until next year, and then we're going to celebrate it on the 19th like everybody else. Pioneer Day is July 24th in Utah. So it's Utah-specific holiday. Who are you texting? Who are you waiting for a response back from?
Almost there, Your Honor. Sorry.
Right, but they're talking June 19th, so you'll be gone. Yeah, they're gone.
Do not read June 19th, Your Honor.
What's the other date? What day is it?
Okay, June 19th is out.
All right, Friday before June 12th, 9 a.m. Does that work? Yeah. Does that work for you as well, Mr. Facewear?
They leave the 12th.
That won't work as well for you, Your Honor. You can do the week after June 19th.
Any day during the weeks besides Friday and
I've got some trials is the problem.
It's only going to take an hour. Just take a break.
It's just a little well past 5.
Yeah, I know.
Not trying to be difficult, but at the same time.
You know, that was the problem is I'm unavailable because I'm not
in the country.
Here.
We could do the week of June 22nd, Your Honor, any day that week.
The week of the 22nd or
It sounds like Diane.
before the 12th.
Or the week of the 8th.
Of what? July? I can't go out that far.
Of June.
June 8th, I'm not available.
Okay, then June 22nd.
That you're in court that day, Judge. We've got a 2-week trial going on June 22nd. They're trying to find a sentencing date.
What do we have in the morning? My what? All right, we'll have to bump the other one. So what day is that again? June 22nd at 1:30 work for you, Mr. Facemeyer?
No, they're not back on the 24th.
I'm sorry, the Rosellis don't get back until the 24th.
Can you change your plans? I can't go out forever.
I can't. It's out of the area.
When do you get back?
We get back the 25th of June.
That was Diane Rostelli.
No, the 12th didn't work.
The mother of the victim.
For somebody. So what day again? What time do the Rostellis leave?
What day?
They leave the 12th.
12th of June, right?
Right.
We get it at
They leave the 12th from California.
10 o'clock. The 11th. The 10th, you mean? Let's do 10th. All right, we'll make my criminal calendar on Wednesday the 10th light, and we'll do it at 10:30.
What day is your criminal calendar?
Wednesdays.
The 10th?
Yeah.
Mr. Facemeyer, you got to make this work.
I'll make it.
Thank you, Mr. Facemeyer. I appreciate that. All right, before I go back and chat with the jury, anything else from the state you need to put on the record?
Would you be willing to ask the jury if they'd be willing to speak with them?
I will. I always do that. I'll talk with them privately first.
All right, thank you, Andy.
Anything from the defense, Mr. Facemeyer, to put on the record?
Just checking the time for...
10:30 on the 10th. We'll do a light calendar that morning to accommodate the sentencing. But there may be a little bleed over, so people have to be a little flexible. Does that still work?
Oh, yeah. I was checking. They asked for the time, just making sure.
All right. And anything you need to put on the record?
No, Your Honor.
All right. Thank you, counsel.
There you go.
We'll be in recess. I'll speak with the jury briefly. If they wish to speak with counsel, I'll let my bailiff know they can bring you up. Thank you.
All rise.
All right. And Tracey is going to be remanded into custody until June 10th at 10:30 when she will be sentenced formally in this case. We'll also have victim impact statement.
I'm in the court, so I'll try to keep it light. Make sure I'll keep my name.
And with that, we're done. Big thanks to Law and Crime, the pool feed provider on this one. Thank you for that. That was amazing. All right, I missed your milestone, Stacey. I apologize. I was locked on court. Let me go back and see what I can find there. Hold, please. Stacey, member for 14 months on the jury. Thank you for staying late. All right, this is my happy place. Thank you. Britt also says, been here since Maya. Happy to be on the jury. Swanee, thanks for standing by to cover the verdict. Thank you very much. Law Watcher, thank you for the coverage. Thank you for being here, Law Watcher. And Legally Blonde, thank you for the overtime and the verdict music. And then before that, Wendy gifted 5 gift memberships. Thank you very much, all of you. That concludes our coverage today of the case. And that means that tomorrow, we're looking for a new trial. We have another case coming up in about a week or so, about a week and a half. So we'll try to find something to fill the time in the meantime before we go up to Ohio for the Caleb Flynn trial. Look, I remembered his name first try. So it's finally sticking in my brain. All right, I'm gonna eat my cold dinner here in just a little bit. Thank you all. All right, tonight when you go home, please hug the people you love, smile at them, and make their day just a little bit better. And please stay safe till we go live again tomorrow morning. We'll probably do a little bit of court hopping, maybe some document reading tomorrow. The wheels are off the buses. They're off the bus. You guys are amazing. Thanks for making this the best place to watch true crime. I'll do what I can on the audio side, but you guys make this community absolutely wonderful. It would not be the same without you here. Thank you once again to my incredible mods for all they do, and it is a lot. Thank you, thank you, thank you. You guys be good to each other. We'll see you in the morning. Have a good one. Bye.
You are banished from the state of Georgia.
What more do you need to see?